Court observe. Court observe.
ಕೇಳ್ತಾ ಇಲ್ರಿ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
Court observe.
ಹೇಳ್ರಿ ದರೆಗೊಂಡು ಸರ್ ಹೇಳ್ರಿ.
Audible ಇದೆ ರೀ?
ಹಾ ರೀ ಸರ್ ಕ್ಲಿಯರ್ ಐತಿ.
ಆಯ್ತು. ಗುಲ್ಬರ್ಗ ಹೋಗಿರಿ ಮೇಡಮ್ ನೀವು?
ಡಿಲೇ ಮೇಲೆ ಎಲ್ಲಿದ್ದಾರೆ? ಸಬ್ಮಿಟ್ ಮಾಡ್ಬಿಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇದೆ ಅಲ್ಲ ಸರ್ ಬಿಡ್ರಿ ಅವ್ರಿಗೆ ಹೇಳಿ. ಕುಲೆಪ್ಪ ಹೇರು ಸರ್ ನಿನ್ನೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರಲ್ರಿ ಆದ್ರೂ
ಪ್ರಿಂಟ್ ತಗೊಂಡ್ಬಂದ ಪ್ರಿಂಟ್ ತಗೊಂಡ್ಬಂದ
Established. Writ appeal fresh. Film hearing.
Put it.
Tomorrow.
Tomorrow. Put it.
Milord, MFA, Milord, fresh matter.
Fresh matter tomorrow. Put it. Put it. Fresh matter.
Not election matter. Today, end of the list.
Hello, what is the urgency?
Saturday is election.
Huh?
Saturday is the
You are
election.
challenging which order?
Challenge the that single judge, Milord.
On what ground? What has happened in the matter?
Writ petition dismissed, Milord.
On what ground? Challenge what? You have challenged what order?
My Milord, representation and the notice is not in accordance with the rule, Milord. There is earlier judgment, Milord, that is not followed, Milord. Contrary to the judgment, Milord, they have moved on the very next day. Assistant Commissioner issued the notice, but is that all these things are made illegally contrary to the earlier judgment of this honorable court. Earlier stay was granted. Immediately when case was disposed of, they moved the application illegally. Same application they have moved, Milord. Some issues they have done, Milord, on that ground, Milord.
What election? Cooperative.
Gram Panchayati election, Milord.
Gram.
Saturday is the election, Milord.
That's good.
Today.
Government, who is the contesting party?
At the first stage itself, it is dismissed, Milord.
At the
First stage itself, it is preliminary dismissed. And I will serve the copy to government. I will comply all the office objections.
government ನೋಡಿ ಅದನ್ನ 230 ಬರುತ್ತೆ.
Yes, I will comply. I give the copy.
Page wise adjournment, page number 7, serial number 21 to 27.
Serial number 27, my lords. Kindly next week, my lords.
Request, inform the other side.
I will inform you.
At request of land council for the appellant, list the matter on date.
24. Page number 8, serial number 28 and 29.
Silver 14, Milord. Silver 14.
1-4.
1-4.
Just wait, just,
So it may be taken
just wait.
230 million.
Just wait.
Page number 10, serial number 30 to 32, page number 11, serial number 33 to 36, page number 12, 37 to 39, 30, 40 to 43, page number 14, 44 to 48, 50,
5, my lord. Serial number 45. In this case, my lord, the two of the my lord sons have been attained majority. I will get instruction, my lord, the infructuous, sir. I will, next week it may be taken, my lord.
Monday?
No.
Tuesday?
Next week, my lord.
When do you want?
Next Friday, my lord.
Thursday, Thursday.
Next.
In the orders list in the orders list on Thursday. Yes,
page number 50, serial number 49 to 51. Orders matter, serial
Serial number 14, my lord, it is connected to, I have moved the matter today 230, my lord.
serial number?
14, my lord. ಅದನ್ನು ಕೂಡ 230 ಗೆ ಕನೆಕ್ಟೆಡ್ ಇದೆ ಮಿ ಲಾರ್ಡ್. ಈಗ ಮೂವ್ ಮಾಡಿದ ಮ್ಯಾಟರ್ ಅದು ಕನೆಕ್ಟ್ ಇದೆ ಮಿ ಲಾರ್ಡ್.
Will pass over.
Serial number 49, my lord.
Ah.
Here, as per the directions of this honorable court, we have to deposit the money before the reference court. I will get the instructions, my lord, from land acquisition officer in 2 weeks' time.
Yes, madam. Ratna Shivayogi Mat.
49,
49.
49. Stay there.
Unmute
Jama
Madi.
ಮಾಡಿದ್ದು.
Unmute Madi.
I'll
Please,
get the,
49, my lord, sir.
They're requesting week after next, they'll make the payment by then.
Please.
My lord, sir,
Ah.
this one
I
submission,
request-
otherly, these matters also covered by judgment of this honorable court. This honorable court has dismissed the appeals filed by the
Petition.
government. No, my lord, sir. Since similar matters were in the similar matters, the government has satisfied the award.
Hmm.
On that ground, this honorable court has disposed the matters earlier, my lord, batch of matters.
If award is satisfied, how does it?
And that was the same notification, same purpose.
my lord, I will go through this judgment.
Find
It
out.
will be taken. If it
Yeah,
is on the point of limitation, my lord, Supreme Court will stay ಆಗಿದೆ. ಮತ್ ಅದ್ರಂಗೆ ಇಲ್ಲಿ ಮಾಡಿ ನಾವು SLP ಹಾಕೋದಕ್ಕಿಂತ
ಇಲ್ಲ,
if it
ಇಲ್ಲ,
is on
may-
similar,
ಅಲ್ಲ, may I make my submission, but the same notification, same village, same purpose.
a dispose
Other,
entry, I will go through and submit.
Other
through,
awards
find
were satisfied, and therefore on this ground only after
out.
hearing, my
Please.
lord, this honorable court dismissed the appeals
Next.
filed by the government.
If you have satisfied
Please, my lord,
and you have not retained liberty, there ends the matter, isn't it?
please, my lord.
Examine it.
Next week ಅಲ್ಲಿ ಒಂದು I will go through that, copy ಕೊಡ್ರಿ.
ಅಲ್ಲ,
compare
ಅಪ್ಲೋಡ್
ಮಾಡಿ.
ಆಗಿದೆ, ಅದು ಅಪ್ಲೋಡ್ ಆಗಿದೆ. ವ್ಯಭಾಸ್ಟ್ ಆಗಿದೆ.
ಇನ್ನೊಂದು ಕೊಟ್ಬಿಡಿ. Relist on. In the orders list on
Monday, my lords.
20,
23rd, ಆಯ್ತು.
which is the earliest date, if it's satisfied, there is.
ಅಲ್ಲ, 20th, 21st ಆದ್ರೆ ಸಾಕು.
21st ಬೇಡ,
ಆಯ್ತು.
ಊರಿಗೆ ಬರ್ತಾರೆ. 23rd ಕಂದ್ರೆ ಅಡ್ಡಿಲ್ಲ. 22nd,
22nd,
please.
Please.
in the orders list.
ಮತ್- ಹೇಳ್ಬಿಡು. ಅಷ್ಟು ಕಾಪಿ ಕೊಟ್ಟು ಕಂಪೇರ್ ಮಾಡ್ತೀನಿ. ಕಂಪೇರ್ ಮಾಡ್ತೀನಿ.
129,
Serial number 1, serial number 29.
48.
One and
Serial number 1, serial number 29 and 48.
129 and
8,
8.
list in the orders list on
48 and 49, yeah. 49,
22nd.
49 also.
ಅದು ಆಯ್ತು 49 ಫಸ್ಟ್ ಗೆ ಆಗಿದೆ.
Please.
ಇದೆಲ್ಲ connected, is it?
ಅಂದ್ರೆ ಆಗಿದೆ, ಎಲ್ಲವೂ ಕವರ್ಡ್ ಬೈ ಆಗಿದೆ ಅಂತಾರೆ. I will go through all these
No,
matters.
are they to be connected?
Yes. In 29, my lords, the earlier disposal file was placed.
ಹೇಳ್ತಿರೋದು.
ಇವು ಎಲ್ಲವೂ connected ಇದಾವೆ.
Connected is-
No, no, my lords.
Sir,
29, one separate, one is separate.
ಇಲ್ಲಿ ಬರ್ಲಿ, we'll have all the three in the orders list
Please,
on
madam,
23rd.
please.
22nd ಅಂತ ಇದೆ.
22nd,
Please.
22nd.
Chief, kindly, serial number 45, I moved a memo.
40?
Learned friend, 45 months. My learned friend took an adjournment. It is the case of the custody of the child. Father was not allowed to meet the child and at the same time allowed in the festivals if the
We had passed some orders, isn't it?
custody it is.
The visitation rights ಏನೋ ಹಿಂದೆ ಕೊಟ್ಟು.
Two sons are, my lord,
They matter.
studying in abroad, my lord. Now they are attained majority.
ಅಲ್ಲ,
One
correct.
is minor, my lord. There
No,
are
he's
three.
saying, ಇವಾಗ they have attained majority.
See, it appears, sir, one daughter attained majority, my lord.
Huh.
And without the consent of the father-in-law, that is the grandfather, shifted to her to Russia.
They are studying. my
Let-
lord.
That is one aspect of
Studying.
matter. Then every festival, when I am approaching my children with a cloths, my lord, they are refusing. And if they send through courier, my lord, they are returning. Literally in this case, my lord, the father is a mute spectator in respect of child is concerned.
The
That's why I am mood
In the
mat-
mediation, my lord,
would a
the
matter,
children
my lord,
also
Lord
came,
should
my lord, they
kindly
don't want
decide
to
the-
go to the along with the.
No, ಹಾಗೆ ಹೆಂಗೆ ಹೇಳಕ್ಕಾಗುತ್ತೆ? ಅವ್ರು ಹೇಳ್ಬೋದು.
Alala, in the mediation, my lord.
You know, it's irrelevant. Children can't say, I don't want the father. Both are required. Both.
Because of the, my
protection
lord,
of-
the ill treatment, my lord, given to the mother of the, my lord, the.
That is a irrelevant ground.
Uh,
He may, the father.
Their
may-
mind, my lord, that
No,
is I
no,
am submitting.
I'm just telling you, father may not like the mother. But that is different from
Sir,
the
already
relationship between
suicide,
the
my lord,
child
he-
and the father.
He died, my lord, he is now no more, mother is no more.
ಗೇಟ್ ಹತ್ರ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ, ಎದುರುಗಡೆ ನಿಂತ್ಕೊಂತಾರೆ, ಅವ್ರು ಒಂದೇ ಮಾತು ಹೇಳೋದು ಮಕ್ಕಳು, ಅಪ್ಪ ನೀನು ಮನೆಗೆ ಬರಬೇಡ. ಇನ್ನೊಂದು 10 ನಿಮಿಷ ಮಾತಾಡಿ ಹಿಂದ್ಲಿಂದ ಅತ್ತೆ ಮಾವ ಅವ್ರ ಮೇಲೆ ಕೂಗಾಡ್ತಾರೆ.
ನೋಡೋಣ. Let us-
My request is to hear this matter.
ಒಬ್ರು minor ಇದ್ದಾರಾ?
ಹೌದು.
One child is minor.
Almost 16 above years.
ಅಲ್ಲಿ
That means,
Italy
my lord, that does not mean that I will not
One is
allow to
again
meet my
majority
children. my
is
lord.
studying in abroad, my lord, the other
On
another.
the next date we'll see, please. ಅದು ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Thursday.
23rd.
Seal number 2. HM Dharigon.
This matter, my lord, I'll place a week's time, my lord.
Prepare for the complainant.
Complained or not, my lord, I'll get the instruction, my lord, not received the instruction, my lord. Also private or not, 27th, my lord, by that time I will,
At request on behalf of the respondent, relist the matter on
next week, your lordship. 23, my lord,
23rd.
please.
Please.
ದಾರಿಗೊಂಡ್ ನೀವು ಧಾರವಾಡಿಂದ ಕಲಬುರಗಿ, ಬೆಂಗಳೂರು, ಗುಡ್ ಗುಡ್. ಗುಡ್. Yes, next.
Number 3. Deepak V. Bharat.
Filing a memo, my lord. I am filing a memo.
Yes.
I am filing a memo, my lord.
Huh.
Since, my lord, in April 2024 itself, the deceased name having 14 sites, my lord, 15 sites in his name, my lord. One of the site, now they have transferred the LRs of their deceased sites, my lord.
Just 1 minute. You
The-
tell us what.
the
If you go
direction
directly
wa-
to the
the-
point, ನಮ್ಗೇನ್
yes.
ಅರ್ಥ ಆಗುತ್ತೆ?
Short accommodation.
No, just 1 minute. I'll accompany. We'll see what it is.
My lord, there was a direction by the learned single judge that, my lord,
Page.
page 18, my lord, 17 will be the relevant portion. 18 will be the relevant portion. Lord, may I? Khatas were in the name of the petitioner's husband, my lord. They were in the name of petitioner's husband. In total, there were 14 sites, my lord. Now, the respondent, TMC has transferred one such plot, my lord, and they have filed a memo on last date of hearing. I had made an application in April 2024 itself by giving details, my lord. Along with this memo, I have produced. My lord, wherein when they have transferred one such khata, my lord, there is no issue with regarding to the other name to be transferred in by the LRs of the khatedar.
No, correct. The subject matter of the writ petition relates to one site or?
No. For entire survey number itself.
Then let us.
Yes.
And now by next date, you get instructions. Their statement is that one site you have done, you have to do it for the others. You find out. Relist the matter on.
Before.
Okay.
Much. Seal number 4. Subhash Mallapur.
Lords, at page number 7 of the impugned order, my lords, the authorities have highlighted some lines, my lord. Is that,
Page.
my lords, page 113.
100 and
113, my lords.
30. 13.
Highlight ಮಾಡಿದ್ದಾರೆ.
113.
113.
ಹಾ.
Highlight ಮಾಡಿದ್ದಾರೆ. That is the offense.
ಆಯ್ತು, ಇದು ರೀಪ್ಲೇಸ್ ಮಾಡಿ. For the time being, we can issue
but-
notice. But ಆಮೇಲೆ ಇದನ್ನ ರೀಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕು.
Yes.
Some people don't like, I may not mind, but some
I
judges
will-
don't like that.
My lords, again they ask for seal, my lords.
Huh?
If the
How
seal,
I can know, this we cannot.
Yes, I will replace. I will replace.
No, you replace it.
Yes.
Week's time granted to replace annexure C with a copy without highlighting.
Five, G,
My lord, it is pertaining to the limitation question, my lord. So many matters are disposed of by this honorable court, my lord, but in SLP number 31094, it is stayed.
That number was
SLP number 31094 of 24, my lord,
310.
94
Ah.
of 24, it is stayed, my lord, insofar as this condonation is concerned. Therefore, I request, yes, my lord. Therefore, this will be taken after 2 weeks, my lord.
I am praying for the curator, kindly permit to stay, my lord. Delay may be kept open and stay may be granted in permit to subject to 50% amount deposit.
No. Now this is the state's appeal,
Yes, my lord.
isn't it?
Yes.
What you're saying, delay may be kept open and
Stay may be granted and 50%, subject to 50%.
stay.
amount.
Why are you asking for stay? Execution ಹಾಕೊಳ್ಳಿ. No, now we first,
Please,
we don't want to pass an order that cannot be implemented. You get instructions and you make a statement. Because so many matters routinely we are passing
yes,
stay.
yes,
But ನಿಮ್ಮ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ ಅಂದ್ರೆ then it's a paper order. I'll have it next week, you get instruction that either we will permit execution or stay, but you have to make arrangement for funds. So, but we don't want to put pressure on you. You ask your client and you get back. I'll have it next week.
instead of next week, week after next.
ಆಯ್ತು.
Right,
Relist on, date good.
please. Madam, 30.
Please. Minister.
You have filed execution, is it?
Yes, ma'am.
You have filed?
Filed.
No done. Yes. You tell your official,
Please, madam.
either in execution, they may take some coercive steps, or we can get a stay subject to the practice of some percentage of
Yes, ma'am.
deposit. And you have to let them get instruction and tell. Yes.
number 6, Basavaraja Kareddy,
Yes.
Lord, a compromise decree as per annexure A was passed at the instance of the compromise between the complainant and second respondent herein. Annexure A is the compromise decree. The complainant herein makes an application to the first respondent PDO to effect khata in his name as per compromise decree. Wide application annexure B, my lord. First respondent sleeps over the matter as such a legal notice came to be issued. Then, my lord, he gives an endorsement, my lord, acting to frustrate the judicial process of the court itself by stating, commenting upon the judgment itself. Then, my lord, I thought let us approach the higher authorities. As such, I approached the Chief Secretary ZP, who in turn gives direction to him as per annexure E, Chief Secretary. Then, my lord, thereafter also taking some excuse, he gives an endorsement stating that accused number 2 has objected and he stated that he will file a review petition, etc., etc.
Yes, what?
May I? Lord, I appear for the respondent number 1, PDO, Panchayat, the then Panchayat Development Officer. Presently, my lord, the accused number 1 is not the Panchayat Development Officer to the post at the Magaon.
No, 192.
You furnish the details, they will take, you furnish, will have him substituted. We'll have him substituted by the person who is now in a position to
That could be, she is now under suspension.
Hmm.
That is the.
suspension on what, some other or this?
Some other, this is not.
Hmm.
And my submission is even otherwise, the Panchayat Development Officer would not be, my lord, party or contempt would not be lying against her. For 3 reasons, my lord, may I take your lordship?
But then you file your affidavit, let us have a look.
Then, my lord, the present PDO will have to be impleted and then.
No, no.
She is under suspension, there are no documents available to her, no.
No, it's by name, isn't it?
Yes, yes, my lord.
So they are saying when she was an officer, what she has done amounts to contempt.
Yeah.
Now,
May I prima facie, my lord, I would take, my lord,
you must file affidavit in
I'll-
contempt.
I will.
So you ask her,
She is not in station after suspension.
I will give you time,
Please.
and by the next date, you put it in writing. Whatever you want to say, we'll decide.
For
In fact-
that reason only they are taking
In
time.
fact,
Even
this-
for accused number 2 also you have appeared.
No. Why, sir?
Huh?
Accused number 2 is not even served, my lord. He is actually. the-
ಅಲ್ಲ ನೀವು ಕೋರ್ಟ್ನಲ್ಲಿ 1 and 2 ಅಂತ ಬಂದದ್ದು.
ಇಲ್ಲ, sir. One ಅಷ್ಟೇ, I cannot appear for accused number 2. How can I appear for him?
Relist the matter on date good, next,
That,
24th.
my lord, 24th, I'm informed yesterday itself. She'll be back. She's in Mumbai to attend her daughter's health issue. My lord, 28th or 30th, my lord.
28th.
In the meanwhile, my lord, the accused number 2, my
Notice.
lord, I was under the impression that he is appearing for both. Now, today, for the first time, he is saying that he is not.
I have not said anything.
ಅಲ್ಲಲ್ಲ
R2 ಯಾರು? R2?
ಕಾಸ್ ಲಿಸ್ಟ್ನಾಗ
Charlie is unserved ಅಂತ ಇದೆ, sir. You have not taken.
ಅನ್ಸರ್ವ್ಡ್ ಅಂದ್ರೆ available warrant may kindly be issued for accused number 2.
Didn't know the notice.
It is not served to him.
Because, my lord, they are hand in glove.
That I deny, my lord.
No, let us see.
Both are compromised. They have compromised, my lord, and they are putting me into trouble, unnecessarily calling upon me to the court.
Some PF issue is there, just check.
For 2, my lord.
Yes.
Please.
They have not taken steps, my lord, and they are blaming me
No,
for.
let us see, let us see.
My lord, formally, in the meanwhile,
In a week's time granted.
Allah, I will give
to
notice.
To make good the process as regards notice to R2, if the same is complied with the notice to be issued to R2 forthwith. Yes.
7, VK Nayak.
Needful has been done.
Counsel for the appellant submits that needful is complete. Office to verify and issue notice forthwith. Yes.
Basavakiran Jia.
Please. Sam for the respondent 1 to 6.
Yes.
Your lordship,
What is the direction?
it's an against
The
interim
direction was
order.
not to
madam.
recruit or make any appointments during the pendency of the writ petition. Interim order was passed by this, the writ petition is still pending before the learned single judge.
Kindly see page 16 minutes, interim order passed in the writ petition. Para 7 is relevant minutes.
Even then, attempts have been made to recruit personnel to 2 institutions belonging to the said society.
Para 7 minutes.
Hmm.
The respondent 3 to 8 are restrained from in any manner appointing any new personnel or taking new loan and selling any of the property of the society till next date of hearing.
Now, so now what is the?
Notes the interim order is passed on 13/7/2023, my lords. Kindly turn to my lords page 17 annexure B. Notes it's a intra-department correspondence, my lords, held on 13/9/2023. Lords, the prior to filing of a writ petition, my lords, the respondents, my lords, all the formalities were completed. It's only a stage where government has to approve it. In that course, my lords, this intra communication is made, my lords. I am told that, my lords, after this communication, nothing has happened. Lords, communication is on 13/9/2023. Complaint is filed after 7 to 8 months, my lords. Now the contempt is filed, my lords. And these officers and these departments were not party to the writ petitions, my lords. At annexure 17, annexure B, it's between the intra-department, my lords. They are not party to the writ petition.
Now the contempt is filed against whom?
Against all respondent 1 to 6, my lords, as well.
Main matter is still pending.
Main
Please,
matter
ma'am,
is
it's
still
still
pending.
pending before the
Main
court.
matter is still pending. As of now, I am told there is no recruitment, no appointment order is issued, my lords. Only that correspondence between the intra-department.
Your Lordship, may kindly see annexure B, my lord. In Ullekha, 4, my lord. As per the reference number 4, my lord, the letter dated 14/7/23. Immediately on the next day from when the interim order was passed, my lord, the correspondence was made by the society, my lord. ಅಧ್ಯಕ್ಷರು ಕಾರ್ಯದರ್ಶಿಗಳು ವೀರಶೈವ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘ ತಾಳಿಕೊಟ್ಟಿರವರ ಪತ್ರ ದಿನಾಂಕ 14/7/2023.
They were the respondents
In the writ petition, my lord.
Ondina, we don't know if it was communicated or not.
They were a party, my lord, to the writ
The
petition.
party,
There will be a party.
They were present, they were represented, my lord.
In law, they are deemed to know. But in fact, whether it was communicated, we don't know.
It was communicated.
Letter is dated 14/7.
Please, my lord.
14/7.
Could have been dictated maybe 2 days earlier. Typist would have drafted it. Signature maybe have been made on 14/7. Anyhow, you file in writing whatever your stand.
Please. Open.
Just examine the order passed in CCC 1237 of 23. We'll have it next week. Examine, you also examine.
Please, my lord.
Please.
1237 of 2023. Relist next week. It appears that there is some doubt regarding scope of contempt proceedings against interim order.
Interim, please.
Examine it,
Please.
yes.
Number 9, Ravi B. Patil.
This matter, my lord. To comply the order of the Lawrence single judge.
Order is complied.
Learned counsel for the petitioner,
Memo.
complainant submits that the direction of the single judge
Please.
Single.
has been complied with.
By passing the conversion order.
Deemed conversion,
Yes.
Conversion order is passed.
has been complied with. Memo filed by government advocate along with order of conversion. In light of the same, proceedings are dropped.
I'll take notice for R2 also, my lord. Sir.
GA accepts notice for respondent number 2 as well.
Please.
I know deficit and the.
To the superintendent of police, who in turn deputed the officials.
Fresh ಹೋಗ್ಬೇಕಾ?
Pardon?
Has it?
That report is there. Your phone, they have intimated number 2. Who said that I am in Mysore? The notice and number is intimated. That's the report. Because there, it is flagged, my lord. Report is flagged, I say. Police report, ಅದು flag ಆಗಿದೆ. First flagger. Yes.
You bring your friend, you bring your friend.
Our only R1
No, correct. You bring him in his presence.
Please.
First.
Till number 10, Nitish Padilla.
Yes.
Your Lordship, there has been specific direction issued by the learned single judge for taking me under the government, covering me under the government aid, my lord. Your Lordship may kindly
What is the direction?
the respondent number 2 is directed to consider the letters of respondent number 2 dated 6/12/6/2020 Annexure C and pass appropriate orders in accordance with law so and so. The gist of the case is that, my lord, I was appointed in the year 1993. And entire institution has been covered under the government grant. My specific request was to cover me under the government grant. They did not. I approached this honorable court. This honorable court directed me to approach Education Act under 131.
The respondent 2 and 3 were directed to consider in light of the orders passed by the principal secretary. So what is the order passed by the principal secretary?
Covering me.
Page?
Other very likely.
You have a copy of it?
Huh. Now, I am trying to pursue your lordship is that.
No, we just want to have a look at the direction passed by the principal secretary.
One niche.
Now, what is the endorsement issued now?
My lord.
Now, what they say is, my lord, I was appointed under the non-government aid. So there cannot be covering me under the government aid.
No, correct. So let us have a look at the principal secretary's direction. Now, the consideration must be in accordance with the direction of the principal secretary education, isn't it? You produce it, we'll have it.
Aye. Please.
Relist the matter on 28th.
Please.
Number 11, Nitish Padilla.
Your lordship.
Same or different?
Different.
Different. We pass the order, my lord. That is.
Indirect. Your lordship, for the difference of the arrears of my salary, there was I approached this honorable court and by order there has been specific direction.
Now, what is on what ground they've rejected?
Your lordship may kindly. This is the state of affairs, my lord, 61, page number 61. The joint director addresses me a letter.
Annexure F.
F, my lord. Your lordship may kindly peruse
the statement of objections which was filed before the
Single.
learned single judge, it has been copied from para number 1 to 35. 1 to 35. Same, my lord. 1 to 35. And at the end, my lord, he says it at 68, ink page 68. ಈ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠದ ರನ್ವಯ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿದ್ದು ಅರ್ಜಿದಾರ ದೇವಣಿ ಕಾರ್ತಿಕ್ ಶರಣಯ್ಯ ಇವರಿಗೆ 300 ದಿನಗಳ ರಜೆ ಅರ್ಪಿಸಿ ಸಂದಾಯಕ ಅನುಮೋದನೆ ನಂತರ ಅದರಲ್ಲಿ ಅಸಂಗತತೆ ಕಂಡು ಬಂದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಿಂಪಡೆದು ತಿದ್ದುಪಡಿ ಆದೇಶ ನೀಡಿದ್ದು ಸರಿಯಾಗಿದೆ. ಅದಕ್ಕೆ ಸಂಬಂಧ My lord, he is playing with the majesty of this honorable court.
Oh.
He is a class 1 officer, he is a government servant.
Just hold on. Now, once the objection was filed before the single judge, you may come to the same conclusion. That's a different matter, but you can't do it mechanically.
Kindly see, my lord,
No.
page number 15, my lord.
Page?
Page number 15 of the content petition. What is the
1-5.
order passed by the learned single judge?
1-5.
Please, para number 3.
No, correct. What we have.
But just what I will highlight that one also. my lord.
No, what we have in mind, suppose an order is passed. Before you give that endorsement, at least you should have given an
No,
opportunity.
that is
of
not the correct, my lord. Kindly see, annexure C, my lord, he given the reply to the so-called notice.
Annexure.
Annexure C, my lord.
This is prior to filing of the writ.
Yes, but kindly see, this is the, my lord, dated 19/9/2024, my lord. This is the reply. There is a direction by the learned single judge.
Page.
No, page number 30. This is the, my lord, reply given to the joint director, defending himself, quoting, my lord, 25, my lord, points in that one. We consider this, my lord, reply, we reply to this, my lord, question raised by him in the, my lord, order. That is the para number 1 to 24. In kindly, my lord, page number 33, my lord.
This reply under now of
This
19.
is his, we given the finding to his reply.
At
That is page, para number 124,
at
page number 33.
point 1 to 25.
Yes, my lord. 24, my lord. 25 is the, my lord, he requested joint ಪುಟಗಳು ಸಮಜಾಸಿ ಉತ್ತರ ಸಲ್ಲಿಸಿದ್ದು ನನಗೆ ಸಿಗಬೇಕಾದ ಅಂತ, that is the request. Page number 31. But we given the finding to that one in page number 33. How, my lord, we highlight, given the reply to that,
This para number refers to 19,924 points.
yes, my lord.
The
Yes,
para
that,
number.
yes, my, that one, he given the reply, my lord, that is referred, my lord, and given the finding in the order.
So
We
this
pass the order.
para 1 to 24
Yes,
at page 33 refers to annexure C.
yes, absolutely correct.
Para number.
Please. Then we pass the order. And now, my lord, along with, my lord, in my memo, my lord, I produced the detailed endorsement, my lord. Even, my lord, answering to the, that is, my lord, memo dated 8/1/2025.
8-1.
2025.
Where is that?
Along with memo, I produced. In that, my lord, endorsement dated 4/10/2024 is produced. We answer to the, my lord, all the,
Annexure F is dated.
not annexure F, annexure F, my lord.
Annexure F
F, not annexure F, my lord,
is dated
dated, my lord, 5/10/2024.
510,
Please, ma'am.
isn't it?
Yes, ma'am.
Now this is subsequent.
Yes, ma'am. Subsequently. Though, my lord, it is signed on, my lord, 5/10, my lord, endorsement, detailed endorsement is issued. This is, my lord, ಅರ್ಜಿಯಲ್ಲಿರುವ ಅಂಶಗಳು. But whatever he stated in the application or reply, that was to the, my lord, given the uttara. In all 1 to 24 para, that is referred in the, my lord, whatever my lord friend client is, my lord, referred in the reply, that 1 to 24, That is also replied in the endorsement. Concluding last my lord, ಪ್ರಸ್ತುತ ಸದರಿಯ ನಿವೃತ್ತ ನಂತರದ 300 ದಿನಗಳ ರಜೆ ಗಳಿಕೆ ರಜೆ ನವೀಕರಣ ಮಾತ್ರ ಸೋ ಅನುದಾನ ಬಿಡುಗಡೆ ಮಾಡಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲ ಎಂದು ಇಂಬರ ನೀಡಲಾಗಿದೆ.
Yes.
My lord, my humble submission. The letter which is Annexure C is addressed to Joint Director
Yes.
by the principal, that is me. It is I who has written letter to Joint Director. Joint Director, my lord, he writes letter. That is 5/10/24, which is at Annexure F. And my lord, in the statement, objections affidavit filed before this honorable court, same Joint Director, my lord.
No, please, I didn't get your point. Now the this annexure C is a reply given by you to the Joint Director, isn't it?
One.
Annexure C. Annexure C is a reply by you to the Joint Director.
Yes.
Now the Joint Director has considered your reply at Annexure F. At Annexure F. Dated 5/10. And in support of that, there is an endorsement dated.
1 ನಿಮಿಷ. As per the order of the Honorable Court, learned single judge, I write a letter for its implementation.
Yes.
I need not write. There is a direction to him. He is a government servant. And my lord, he cannot take an excuse that it was just a reply, it is for that reason Annexure F is there. No. He is a class 1 officer, responsible officer.
No, now he has considered your reply.
No, my lord, my humble submission, when there is specific direction, your lordship may kindly, illi, bartha sir, illi nodi.
The order of the single judge says that the order dated 14/5/2016 will be considered as a show cause.
Yes, yes.
To that show cause, you have made your reply in terms
Yes, my
of the
lord.
order.
Yes, my lord.
He has considered it and passed an order.
No, my lord, that runs contrary to the statement of objections that has been filed, runs contrary to this.
No, that may be so. That you take it up, you challenge it.
Allah, sir.
Contempt, how we can do.
Allah, sir, my humble submission, in the contempt proceedings, the defense which they are entitled to take before the writ court, and they are entitled to prefer the writ appeal, they are entitled to contend before the appellate court. They cannot take such a defense before the contempt court.
So it was only treated as a show cause notice.
My lord, my humble submission is,
Order
my humble, your lordship.
Copy of the order at Annexure Q.
Adilla, sir.
You
I shall file.
Produce it.
Please. My humble submission, my lord, your lordship is absolutely correct, my lord, in directing me that we cannot look into the merit of the case. In the same fashion, my lord, my humble submission, respectful submission is that the government is also not supposed to take a different contention or
Let us see.
plead or defend. They cannot undo the order passed by learned single judge. It is not an appellate authority. This is dealing with the contempt proceedings. Instead of answering, sir, my humble
Let us
submission.
see.
In all the cases, the government will be coming and saying that we have complied.
Let us, the petitioner to produce the petition papers. Relist on. Yes, next.
Number 12, DG Chagashetti.
In this matter, my lord. Praise, my lord, 2 weeks time, my lord. For this reason, my lord, we return letter to the, my lord, government. Or
Let's see, this case, you also kindly see. Page
we
number
return
9.
letter to the government, my lord, for
Internal,
for further direction, my lord, whether it is should be approval or, my lord, to take further action, my lord, that is returned letter to the government, my lord, on
What,
20.
what was the direction?
let's say, page number 18 words, para 9, para 9 words. In my view, in the light of the documents of the stand taken by the government, that school was closed between 1/12/1990.
No, now they've deemed it that it was,
I meant,
it was working between 1/12/98 to 11/1/2008.
yes, yes.
He is seeking for benefit of the,
Correct.
this period, my lord. As per our, my lord, contention, he is not entitled because that close itself, that school itself is closed.
No, that contention is rejected at.
Rejected.
Yes.
That's why, my lord, we requested the government to proceed with the further or, my lord, to challenge the order of the logistical judge. That is the
But
request
till
made, my
today,
lord, on
lords, they are-
20th/11/2024.
I'll have it next week, whatever stand you want to take, you take.
2 weeks, my lord.
No, no, sir, because not, order is passed.
This is the date, could be 10 days, one date.
Please.
30th.
Please.
Number 30, P. Nitesh Kumar.
I appear for the complainant.
Yes.
There is a direction to
Lord, this is similar to my lord, yesterday's matter, my lord. Wherein, my lord, I sought for, my lord, short accommodation. And my lords were pleased to, my lord, adjourn to 23/1, my lord. And in between, my lord, this, my lord, SLP filed before the Honorable Supreme Court also, my lord, we received an order, please.
Against which order?
My lord, against the, my lord, writ appeal orders,
Writ appeal orders.
please. Seeking regularization and, my lord, confirmation by this Honorable Court is, my lord, now.
Order of 25th June you have challenged.
Yes, ma'am, please.
Huh?
Please,
Against this very same writ appeal.
very same writ.
Section C.
Yes,
You have filed SL.
we filed SL, please.
So what happened?
My lord, yesterday, my lord, it has been ordered, my lord, saying this item number 3, kindly come to my lord, page number 2. Lord, 1, 2, 3. In the meanwhile, High Court shall not proceed with
Yes, sir.
contempt petition, so and so, my lord, up to,
Right off.
please.
Yes.
my lord, that is not that case number, that is a
241. 241. Contempt. Last, my lord, and 24440 and CCC 241.
147.
Today's matter is 241. Please.
Either line.
Yes, please.
Huh? SLP has been filed. Specially petition civil diary number 47686 of 2024 has been filed against the order in WA 200147 of 2022. The Honorable Apex Court has directed as follows by order passed on 15/1/2025. In the meanwhile, High Court shall not proceed with the contempt petition. That is CCC so and so and CCC so and so. In light of the same, list this matter after disposal of SLP.
Published much, please.
Yes,
14 Pastor, till number 50. Viranagowda Malipati.
I moved an application for recalling order, non-filing of second set motion. We already filed second set motion. Only recalling it.
In both the cases,
yeah,
In they are connected, they are filing today.
serial number 50, MFA 200854
Huh.
and 870 in both cases, sir. I'm filing second set.
counsel for the insurer appellant in 15.1 and 15.2
Yes, sir.
has filed the second set of appeal memos.
In 15 ಅಲ್ಲಿ recall ಆಗಬೇಕು ಸ್ವಾಮಿ, for not filing it for dismiss for non-prosecution, we already filed second set.
Now you have filed.
Filed.
Now main matter you are ready.
No,
What is the main matter?
I have not asked. On date may fix.
My lord, main matter is MFA number 200870.
No, correct. Enhancement and liability or
Liability.
what?
Liability, my lord.
Liability.
Liability.
On what ground?
My lord, only one point is involved in this case, that the charge sheet has been filed against both the vehicles. The lorry and Travera Jeep. And as far as the lorry is concerned, Travera is insured with the appellant, Travera vehicle. And another vehicle, lorry, the police have filed a charge sheet against the lorry, not only against the driver that he does not have any DL, owner is also prosecuted that he has been entrusted the vehicle to a person who does not have a DL, as far as the lorry is concerned. As far as the Travera is concerned, it has been admitted in the cross-examination that owner of the Travera vehicle given the vehicle to a student to drive who does not have any DL, my lord. Now that vehicle is insured with the appellant United India. Now, while deciding the matter, the honorable tribunal has not apportioned the liability. Entire liability has been, apportionment is more important, my lord, in this case. There is no apportionment
Apportionment between
between the lorry and the Travera Jeep. Accident is between the Travera Jeep and the lorry. Travera Jeep is insured with the United India appellant.
it was being driven by a minor.
Not minor, he's a student, my lord, who does not have any DL. We have also led an evidence on that point. That a Travera Jeep which has been driven, he does not have any DL. Otherly pay and recover. In that case, it will be pay and recover, my lord. Pay and recover. And tribunal, my lord, while passing the award, a liability has been imposed against 1, 2, 3, my lord. There was no apportionment. So therefore, apportionment is because
You can claim from any one of the vehicle.
Yes, my lord.
As per Kine judgment, cross feeser.
No.
Not we, sir.
No. As per the Kine judgment, I concede, my lord, that claimants can recover from any one of the trot fees. But here, all the persons are the party to the proceedings. They are recovering the amount from me, United India. Apportionment of the liability, that apportionment was not done.
No, but whether there was a plea, whether there was an issue,
Yes, that issue,
contributory negligence.
yes, ma'am. As per the,
Kindly pass on, we'll argue the. Can't pass
as
on.
per the judgment,
Okay, then
may
get.
I
to
read the issue, my lord?
Pass over,
Obli.
pass over.
Obli.
Yes.
Second set ಕೊಟ್ಟಿಲ್ಲ. ಬಾಕಿ ಏನೇನ್ ಕಂಪ್ಲೈಂಟ್ಸ್ ಇದೆ ನೋಡಿ.
Everything is-
Recall ಆಗ್ಬೇಕಷ್ಟೇ, recall ಆಗ್ಬೇಕು. Recall ಕಂಪ್ಲೈ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಗಿಲ್ಲಕ್ಕೆ
ಕರೆಕ್ಟ್, ಬೇರೆ ಕಂಪ್ಲೈ ಆದ್ರೆ ನಾವು ರೀಕಾಲ್ ಮಾಡ್ತೀವಿ, ಬೇರೆ ಇದೆ ಅಂತ.
ಏನಿಲ್ಲ ಸರ್, ಸೆಕೆಂಡ್ ಸೆಟ್ ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
First man.
ಪಾಸ್ ಓವರ್ ಚೆಕ್ ಮಾಡಿ. ಎಸ್, ಬೇರೆ ಏನಿದೆಯೋ ಸಣ್ಣ ಪುಟ್ಟ. ಎಸ್,
Till number 60, Kadlur, Narayan.
Yesterday evening, respondent counsel had called me
Yes.
Respondent counsel had called me yesterday and he has given details of their proposal. Their proposal is mainly the share as given by the trial court. They are restricting that. And in addition to that, for the diverse settlement, they are insisting for 50 lakhs college fees of the daughter. And what they said, 50 tola gold that according to her, this was taken by this husband and it is sold. They want that either the gold 50 tola gold or its value. And another thing is that she is admitting for giving up her share in the sold property by receiving 8 lakhs from each of the purchaser. Now this very disproportionate suggestion given by her. Anyway, but now our party has come. My party has come. Now he is ready to give up the entire complex. Measuring 40 hall is a complex comprising of 40 by 80 hall and 14 shops. So more than 4 crores. If it is acceptable, we will give that entire complex itself and she has to leave the share as it is. In addition to that, if there is further renegotiations required, once again, if the matter is to be referred to the mediation, that would serve the purpose, my lord.
Let him come.
Ravi
We'll pass.
Ravi Patil is.
Let him come. We'll pass.
Yes, my lord.
You bring him.
Yes, ma'am.
You bring him. The report of the police appears to indicate that telephonic communication has been made to R2.
I am not.
No, I'm saying. So then we will take further steps.
I have nothing to do with R2.
Sometimes R1 will whisper in your ear, no? So we are just thinking.
Oh, no. There is an objection. Objection.
Let us, insofar as notice issued to R2.
But on, if I'm not, as a just amicus, my lord, communication, even a telephonic communication, would it suffice to be a,
Yes.
that not, I just.
For us sufficient.
Not, may I also submit, my lord, if the appellant, the complainant could, my lord, make the present PDO as a party.
That we'll see later.
Please.
That is when compliance is required. Now they're only on contempt.
Yes.
They're only on contempt. They produce the report of the sub-inspector of police. It is peruse the communication of the sub-inspector of police to the Assistant Registrar General, Kalaburagi, High Court of Karnataka, Kalaburagi bench. It's mentioned that notice to R2. R2 neither.
How
That is the Jagadevi Rathod.
No.
sorry,
That is the
R1.
R1. Jagdevi Rathod is R1, my lord.
Notice to R2 has been communicated by HC 373 telephonically. And R2 is stated to have informed that she was not in the village. Full stop. We would deem such intimation telephonically made by a police official to be sufficient for R2 to have put in appearance in contempt proceedings. Accordingly, issue available warrant for a sum of rupees 25,000. Returnable to be executed to the jurisdictional police SHO. Returnable by call the matter on. Adidli, update idli. Call the matter on for idu. order. Yes.
Serial number 70.
The application, my lord, for. There is a money decree in my favor, my lord, the respondent. This honorable court was pleased to grant, my lord, an interim order subject to deposit of 40%. Is now deposited. Sought for withdrawal of that, my lord, subject to result of the.
So let us see that anyhow interest will run on that. Kept in an FD.
Yes, madam.
Huh?
Order to be kept in.
Kept in FD. So we'll hear the main matter.
Yes.
What is the,
To file objection, I have filed an application seeking production of additional documents. They have not filed objections.
you file
Actually-
your objections to that, we'll see the main matter.
Bless. Those, my lord, documents are pertaining to a transaction between him and, my lord, another firm. My lord, he alleges that, my lord, that firm belongs, my lord,
Let us see.
I'll file.
Now you file your objection.
Yes.
If you make out a case, we may say not required. Let us see.
Yes.
Objections.
It's
to-
a decree
be
based
filed.
on, my lord, check.
So IA2 of 2023. Now you file it. We'll
I'll do that.
relist date code.
First week,
Recovery on basis of check.
yes.
So you're saying there's no
Check,
difference.
yes, my lord, the check is, my lord, they admit that it belongs
18
to, my
lakhs
lord,
is
her
check.
husband. It belongs to, my lord, her husband, my lord, is not disputed, the debtor, my lord. And, my lord, she also, my lord, doesn't dispute, my lord, the signature. She says it appears to be her husband's signature. Check is issued, my lord, based on that, my lord, the money, my lord, suit is decreed.
Then you come
Now-
ready on the main files synopsis, let us consider.
Bless.
What is said
I'll
is
file
on
it.
15/4/21,
Huh.
he stated to have given a check and he died on 28/4. After the death, knowing the death, they are very close friends. Knowing the death of the said person, thereafter they filed this for encashment. Two checks were given. There was a business transaction.
You're correct, but then in how, unless you prove, how we can take note of any other case? Check is there, presumption is there.
I'll just prove the circumstances, sir.
Let us get ready
From
for
the evidence itself.
synopsis.
Bless.
Just on date. What's the RFA for admission on 30th?
Admitted, right? That's
Huh? It's admitted.
It's admitted.
Let it come from, my lord, the same stage. Lord,
This
it can be,
on. So
an understanding that it will be heard.
Yes, get ready with the main.
Bless.
Paper book or a TCR is there?
TCR, my lord, I
CR
think
ಬಂದಿದೆ.
TCR could be called for, my lord. That would
TCR,
be
TCR to be summoned through telephonic communication.
great.
Previous metric.
Serial number 60, Kadluri Satyanarayana. Ravi Patti.
They have made a counter of for settlement. I have informed to council. If they are agreeable, my lord,
No, they have made one.
Today, my party
They're
has
making
come.
one more offer.
They are, he is ready to give entire complex worth more than 4 crores. For the further negotiation, the meeting may be arranged for them.
I'll get, my lord, the instructions from my client. If they are,
You have some sitting.
That would be better.
That would, my lord, come.
Personal sitting would be more.
So you go arrange for a meeting.
Please, someday, my learned friend would
If
suggest.
ಮಾತಾಡ್ಕೊಂಡು, you do it.
Please.
No mediator is required. Both of you are mature enough to sort it out.
Because there are some.
Required. If required, we'll have a, you
Please.
first sit together and see.
Yes.
There's some loan transaction on that complex and all. We need to also get some details from them.
Yeah, I will get
We'll,
all the details.
also, my lord, secure, my lord.
Yes, we'll get
Look
all
at
the
it.
details.
Please.
Yes. Relisted on. Next week. 24th,
23rd, my request.
23rd. You find, you see what are the common points,
Please.
what are the areas of dispute.
Yes.
And then we'll see what is to be done.
Please.
Serial number 80, ವಿಜಯ ಮಲ್ಲಿಕಾರ್ಜುನಪ್ಪ. Eighty.
Your Lordship, continuation of delay of 166 days, Your Lordship.
Yes, who is the respondent? Is he working somewhere?
He's working as a driver, Your Lordship.
Driver?
Yes,
Where?
in Kalaburagi only, Your Lordship.
Some, he's working with some entity or private?
No, private.
No, but what to do now? He's served. He's not represented. What is the order of the trial court?
So, divorce of judicial separation, Your Lordship. Divorce of judicial separation was ordered, Your Lordship. For a period of 3 years.
Once more, we'll see. Matrimonial matrimony ex parte, sometimes with a paper decree, we don't know. Let us see. Now, after 3 years, there's a different remedy. Now, you are challenging the very order of judicial separation.
Yes.
You want
Because
to,
both are not ready to live together, Your Lordship.
not ready.
Not ready. So,
So you're saying it should have dissolved.
yes, Your Lordship.
That's your stand.
Yes.
Let us see, let notice go once again. We'll see what is to be done. Now, suppose he comes and he says, there ends the matter.
Condone the delay, Your Lordship. I'll talk in the trial court, Your Lordship. He's EP is there, Your Lordship. He's coming there.
EP is there.
Yes.
I will permit you to serve on him on the council in the EP.
Oh, yes.
Delay condonment. IA, one of 24 is allowed, taking note that the respondent is served and no objections are filed. Full stop. Cause shown explaining delay is accepted. Accordingly, IA 1 of 24 is allowed. Delay in filing the appeal is condoned. Full stop. Taking note that the present dispute is a matrimonial dispute, it would be appropriate to issue notice once again to the respondent to court. The appellant is permitted to serve counsel for the respondent who appears in the execution proceedings stated to be pending between the parties. The presiding officer in the execution proceedings to facilitate service of hand summons to the respondent herein or his counsel on the next date of hearing. Office to issue hand summons forthwith.
Yes.
List week after next 2 vara ಆದ್ಮೇಲೆ date. Yes. TCR to be summoned forthwith. Yes, next.
Till number 19.
19 I am for appealant, my lord. This is 5 petition, my lord. There is 241 days delay.
Notice is not issued.
Notice,
Notice is not ordered, but there is 241 days delay, lords.
issue notice on IA as well as main to the respondent.
Rajesh Doddaman.
Appearing on behalf of Rajesh Todmani, my lords, appeal by accused, he has been convicted for section 302, 376, 201 and 354. My lord. There is a delay of 51 days. Further, he has filed for suspension of sentence.
Take the reason assigned in the IA, assigned in the affidavit, memorandum of facts.
Memo of fact, affidavit filed by the wife of accused.
Affidavit, accompanied to IA 2 of 2015. So also considering the aspect that the appellate is in is in custody from the date of the judgment passed by the trial court, the delay of 51 days in filing this appeal is hereby condoned. Accordingly, IA 2 of 25 is allowed. This renotify this appeal after 2 weeks on date. 31st. In the meantime, learned SPP is permitted to file objection if any to IA 1 of 25. Office is directed to secure the TCR.
Preliminary hearing matter, till number 21, Subhash Malapur.
No, liberty is given to you. Why? Liberty is given to you. Huh? Liberty is given to you. If it's within limitation, you initiate. So how are you agreed by this order?
Technically, I don't have locus standi to challenge the 14.
That's a different matter on merits. Only question is whether he has retired.
Yeah, he is retired.
Then liberty is given to you if it's within limitation. So what's wrong with that order? KCS sir. KCS. CC and KCS sir.
Provisions of my lords, 214, 2B2, my lords, it was. Our cases, my lords, that the complaint was filed within the period of 4 years, my lords.
214?
Lokaयुctam. 214, 2B2, man.
Which is that which says after he's retired, you cannot initiate. 6.
Yes.
I beg you. Retire ಆದ್ಮೇಲೆ ಅಂತ ಯಾವ್ದು ಅದು proceeding?
Retired, my lords.
6 ಯಾವ್ದು?
Sorry. ಇಲ್ಲ, book ಇಲ್ಲ. ನಾನು ಬಲ್ಲದು. And pass over, my lords, 230.
Just find out, that's all. You just point out which provision after retirement you cannot. Then they've given you liberty. So that liberty, if it's within 3 years, then you can. Otherwise, that you take a decision.
It is within 3 years, my lord. One employee retired on May 15 and another on August 16. The complaint is the articles of charge 6/4/17. Within 3 years. Retired on 30th to 5/15. First applicant before KT and second applicant on 31/8/16.
Second applicant on,
31/8/16.
so both had retired as on that day.
Yes, after, so on superannuation, they have retired and the articles of charges dated 6/4/17.
Here, my lords, the inquiry was entrusted under provisions of 214(1)B, my lord. May I read? The recovery of pecuniary losses from the pension. The government reserves to themselves the right of ordering recovery from a pension, the whole or part of any pecuniary loss caused to the government or to a foreign employer under whom the government servant has been worked on deputation or otherwise, along with interest. If any departmental inquiry or judicial
Subsection 2. B, departmental inquiry, B, departmental proceedings.
departmental proceedings, if not instituted while the government servant is in service, whether before his retirement or during his re-employment, shall not be instituted to save the sanction of the government. If shall not be in respect of any event which took place more than 4 years. My lords, here, from the date of complaint, if it is counted, it is within 4 years.
Not date of complaint. The charge. The incident. Now that,
More than
that liberty is given to you.
institution. Yes, ma'am.
Liberty is given to you at page 50, last sentence.
Yes, ma'am. Yes, ma'am.
Then how are you aggrieved? Huh? No, you must withdraw it. We will not dismiss it. Otherwise, I'll impose 1 lakh costs on the Lokayuta. It's impermissible to abuse the process of the court like that. I'm going to impose 1 lakh costs payable by the law officer who approved the draft. You can't file such frivolous matters and clog the court board.
Next week.
Relist in the orders list. Absolutely no ground to file a matter. You have given liberty there. Yes. You get instructions and close it. Relist the matter in the orders list on 21st.
Number 20. Mahadev S. Patil.
It is appearing.
My lord, I appear for the appellant in this case.
Yes.
Appear for the appellant in this matter, my lord.
Yes.
No, disqualification of the 10th respondent, he was a petitioner. He was a president of 4 cooperative societies when the election was declared for the 9th respondent bank. Even that itself is a disqualification, in fact, under the act. And subsequently, he resigned from 2. Even one resignation, my lord, which was accepted by the learned single judge, notwithstanding that 15 days was not elapsed before it was accepted by the board of management of one of the societies. Learned single judge, no, it is a deemed provision, therefore that will not disqualify. Even then also under section 29C2 of the Cooperative Societies Act, if a person cannot hold more than 2 offices, now if he is elected in fact, it is nothing but a third one. It is again a disqualification. There are several infirmities, my lord. The learned single judge says that, no, you have a government advocate when made submission under section 17, says that there was no pleading to that effect. Not necessary. It is a legal proposition.
Take
Now,
out
pardon?
take out,
Please,
take
my
out,
lord. Please, my lord. No, let there be interim order throughout, from
No, no,
20th,
but,
23rd 10/2023.
no, without hearing, we cannot now.
No,
Now-
what my submission to your lordship is,
No, correct. We'll fix a date. You serve the counsel who appeared
No.
in the writ proceedings.
I'm sorry, my lord. What happened was, even the interim order sought by him was rejected. That was not under challenge before this honorable court, though he has filed, did not press for it. And he is not in the office from October 2023 till date.
No,
Now,
let us see.
by virtue of these orders,
No,
now
I'll have it next week. You serve the counsel who appeared in the writ proceedings. We'll consider in their presence. We'll
Please.
consider.
Please.
Emergent notice. AG accepts.
1 to
notice
4.
for respondents 1 to 4. Please. Emergent notice to 5, 6, 7. 5 to 10. The appellants are permitted to serve counsel who appeared for respondents 5 to 10 in the writ proceedings. Consideration of interim prayers kept open. List on. 10 days notice. 27.
please, not 5 to 8, they were served, they did not appear before the court. It was held sufficient.
No, and adu last sentence peda. Emergent notice, let us see, you want to take out
please.
hand
Please.
summons? You want to
Please.
take out hand summons?
We'll take out the hands.
The appellants are at liberty to take out notice by way of hand summons to respondents 5 to
5 to 8 also.
5 to 8. Relist on 27.
Please, please.
Yes.
But 23, Siddharam Basavaraj Wadi.
Petitioner. Earlier working as
No. You are promoted to which post?
hostel warden.
Promoted to
Promoted to hostel, from hostel superintendent to hostel warden.
hostel superintendent,
Hostel warden as per annexure A2, my lords, ink page 25.
hostel warden.
Warden. As per annexure A2, ink page 25, my
No,
lord.
now.
Thereof-
Annexure?
Annexure A2, ink page 25. And after promotion,
So after promotion,
he continued in the same place.
Nilaya Palakar,
Ilaya Palak. That means warden,
hostel warden.
warden.
सब कंपेयर करके अगर कवर पर रहे तो yes,
Now, who has been posted?
The fourth respondent has been posted to my place as per annexure A4, serial number 17, ink page 29, my lords. Serial number 14 and social 18. In both the serial number, the name of the fourth respondent has been shown, and serial number 18, the fourth respondent has been posted to the place of the applicant, that petitioner.
Serial number?
Serial number 18, ink page 30, annexure A4, my lord.
18.
18, Shivlila,
That is the fourth respondent.
fourth respondent. Her name also shown at serial number 14 also, in the same order. Shivlila,
Nilaya male vicharakar.
Nilaya male Bechar, a hostel superintendent.
Now, this place is where you are working.
Working, I am hostel warden. It is upgraded.
No,
And insofar as
Nilaya male vicharakaru is the
Is
same
the
as hostel
hostel
warden.
superintendent,
Superintendent.
superintendent,
So she is posted as hostel superintendent.
superintendent. But that post has been upgraded from superintendent to hostel warden. For that reason, I have been given promotion from superintendent to hostel warden, and I have continued in the same place, earlier working place. And my application has been, I have challenged, this order has been challenged before the tribunal. And the honorable tribunal was pleased to dispose of the,
Just one.
please.
Now, in terms of annexure A4, in terms of annexure A4,
Yes,
Rupa Sagar,
yes.
serial number,
Serial number 18. Shivlila.
no, Shivlila is posted as.
Posted to
hostel.
ನಿಲಯ ಮೇಲ್ವಿಚಾರಕ ಮೆಟ್ರಿಕ್ ನಂತರ ಬಾಲಕಿಯರ ಇಂಜಿನಿಯರ್ ಮತ್ತು ಮೆಡಿಕಲ್ ವಿದ್ಯಾರ್ಥಿ
Where
ನಿಲಯ.
is your posting now?
That is my post. I have been not shown any post.
Hello, where is that? You are working as
I am working as in the same place, annexure A2, my lords.
annexure A2.
A2, in page 25. ಶ್ರೀಮತಿ ರೂಪಾ ಸಗರ್ ನಿಲಯ ಪಾಲಕರು ಮಹಿಳೆ ಮೆಟ್ರಿಕ್ ನಂತರ that is BCW 2105.
ನಿಲಯ ಪಾಲಕರು.
ಪಾಲಕರು.
And ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು is different.
Superintendent. That is superintendent.
Correct.
It is upgraded post, ನಿಲಯ ಪಾಲಕರು, warden.
Is it not a different post?
Yes, it is different post.
Ah.
The post of hostel superintendent has been upgraded as a hostel warden.
There is no post of hostel superintendent in that hostel.
Superintendent is there. But this fourth respondent is ineligible to hold that hostel superintendent. She has to be hostel warden to hold that post.
So that's a different matter.
Yes.
Now,
And as per annex, the impugned order of transfer is concerned, I have been disturbed prematurely, that without posting.
where is your order of transfer?
Transfer. This fourth respondent has been posted to my place.
Yes.
In that post, I have not been shown any place. And on the other hand, I have been asked to report to first respondent for my posting as per annexure. A5, my lords. Next, A5 typed copy is there. The petitioner has been asked to report for her posting at to the first respondent. I may be permitted. In page 33, typed copy, annexure A5. ಶ್ರೀಮತಿ ಶಿವಲೀಲಾ, that is fourth respondent, ನಿಲ ಮೇಲ್ವಿಚಾರಕರು ಮೆಟ್ರಿಕ್ ಪೂರ್ವ ಬಾಲಕಿಯರ ವಸತಿ ನಿಲಯ ಚಿತ್ತಾಪುರ ಕಲಬುರಗಿಯವರನ್ನು ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟ so and so BCW 2105.
10/24, you were directed to be relieved.
I have been relieved. I have been directed to report at the first respondent for my posting.
Correct. Now you were posted as hostel warden.
Hostel warden.
When were you posted?
As per annexure A2. Annexure A2 is my promotion order, and I have been taken charge as per annexure A3, my lords. In page 27, serial number 3. On 19/1/2024. As
19/1/24.
2024.
What is the tenure?
4 years. I belongs to Group C.
Group C.
Group C, 4 years.
4 years. Yes, government.
My lord, if lordship looks at annexure A1.
Just one minute. Government. Now it's premature. It's premature.
Premature agala. My instructions, my lord, there is no such post.
No.
No post is there.
No, just 1 minute.
Please.
Now, on 18/1/24, Roop Sagar, petitioner was posted as hostel warden, metric, post-metric women hostel, isn't it? Now, that is after on promotion. Now, if on 18/1/24, she was posted to that place, till 4 years, she has security of tenure, isn't it? Now, how have you displaced her within that 4 years? If you have displaced her, you have to get Chief Minister's permission, etc. That you have to show. That's all. If it is not there, there it goes. Will not enter into other issue. Their only ground is it's premature. Will not enter into upgrade, etc.
So,
or the qualification of the respondent. That is a different matter. They are saying that you can't displace me within that security of tenure. If you have displaced, you must have followed the procedure. So you verify and let us.
I take notice and the first time. 2015 is from 2015 she is working there. Charge
Is there a post of hostel warden?
No, my lord, that is not there. That is the rule says there is no post. And it has already been held in men's case, it has already. But there are no post of hostel warden and women's it is still pending, my lord.
As per rules, there is no any post. That is the reason given by the,
The rule doesn't have that.
no, my lord. From 2015, she is working there on the very same place. Annexure A1, if lordship looks at annexure A1, from 2015, she is working in the very same place. And by 14, and even cost has been imposed on the government, and who is responsible for issuing such orders, action has to be taken.
Their contention
Yes.
is that the post of hostel superintendent has, I mean, that's their.
Yes, that has been
has been-
promoted to hostel warden.
As hostel warden.
There is no
Is
such
it
post.
so?
That's what the tribunal has. Tribunal has directed the government to take action on the person who has given such orders. At para 13, last two pages, my lord. The rules doesn't provide for hostel warden.
Or upgradation.
Yes, my lord. That's why action, there is a direction to take action, my lord, against the concerned officer.
Void it.
Yes, even in women also same. There is,
Can't recruit to hostel warden.
yes, my lord. That's why action, the specific lordship can see, direction is given to take action against the person who has passed such orders. And from 2015, she is working there. And even she didn't relieve us, my lord, then the commissioner, after,
That's the leave, the two tables, 2 chairs. We will not get into that. All of you are in the
from
same
2015, from 10 years.
sympathy to both of you. Both of you are fighting for the same chair.
I have taken charge, my lord, order of,
So that we leave.
please.
But you get instruction.
Government has to seek instruction
No,
regarding.
there's no mistake in him. He's entitled for promotion, promoted. You must give him some posting. And
That there is a direction, my lord,
Please,
to
my lord.
appear before the concerned officer and take the charge, my lord. Annexure A5.
With permission, I may be.
put it.
I have produced the documents, that government proceedings on the, and that order submitted by the other side, it is of the men. And that order has been challenged by the government before this honorable court, and same is stayed. Stayed. And insofar as I have produced the document, in document number 1, there was a government proceedings. My lords, kindly peruse, I have produced salary slip in page 5, additional document. My designation is shown as warden and government proceedings. I may be permitted to read.
The government, you get,
Proceed.
Please, my lord, I will take.
there are 2 things. Suppose you have upgraded the post of hostel superintendent
To
to warden.
please.
That is your decision. If it is so, and then you have posted the petitioner, then it's a different matter. But whether there was some upgradation, whether there was post, that you verify and tell.
Please.
We'll have it on, when do you want? Short dates, transfer matters.
Taken on 28th or 29th.
What?
By that time, I will get the paper.
I have submitted the documents, the proceedings. Kindly peruse, my lords. First document, Sarkarada Nadavali, and that last line. ಹಿಂದಿನ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ನು ಬಾಕಿ ಉಳಿದಿರೋ ಫಸ್ಟ್ ಪೇಜ್ ಫಸ್ಟ್ additional document.
Page 1.
Page 1, third paragraph.
ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಮೆಟ್ರಿಕ್ ನಂತರ.
ನಿಲಯ ಮೇಲೆ ಮಹಿಳಾ ಹುದ್ದೆ ಅರ್ಹ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರ ಮಹಿಳೆ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡುವ ಬಗ್ಗೆ. ಅಂಡ್ ಲಾಸ್ಟ್ ಲೈನ್, ಕೋರಿ ಮಾನ್ಯ ಆಡಳಿತ ನ್ಯಾಯಮಂಡಳಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಅರ್ಜಿ ಸೋಣಿಸುವ ಸಂಬಂಧ ನ್ಯಾಯಮಂಡಳಿಯು ದಿನಾಂಕ 18/2/21 ಈ ಕೆಳಗಂಟೆ ತೀರ್ಪು ನೀಡಿರುತ್ತದೆ. Thereafter, last there was also from seeking opinion from the law department, and law department has given opinion that earlier when C&Rs change ಮಾಡಬೇಕು, promotion ಕೊಡಬೇಕು from hostel warden to hostel superintendent to hostel warden. For that there was an order.
So what is the operative order?
Operative ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ in page 3, internal page 3.
Yes, read.
ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಮೆಟ್ರಿಕ್ ನಂತರದ ಬಾಲಕರ ವಿದ್ಯಾರ್ಥಿ ನಿಲಯಗಳಿಗೆ ವೇತನ ಸೋಣಿಸುವ ಮಂಜೂರಾಗಿರುವ 200 ನಿಲಯ ಪಾಲಕರ ಹುದ್ದೆಗಳ ಪೈಕಿ 169 total there was 246 sanctioned posts. 169 were vacant.
Nilaya Palakaru means hostel warden.
ವಾರ್ಡನ್ ಇದ್ದ 169 ನಿಲಯ ಪಾಲಕರ ಹುದ್ದೆಗಳಿಗೆ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಆಡಳಿತಾತ್ಮಕ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶ ಹಾಗೂ ಕಾನೂನು ಇಲಾಖೆ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದ ನಡುವೆ ಅರ್ಹ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಮಹಿಳಾ ವೃಂದದ ನೌಕರಿಗೆ ಒಂದು ಬಾರಿ ಪರಿಗಣಿಸಿ ಈ ಕೆಳಗಂಡಿನ ನಿಬಂಧನೆಗಳಿಗೆ ಒಳಪಟ್ಟು ಪ್ರಮೋಷನ್ ಕೊಟ್ಟು. On this order, I have been promoted.
Now read that operative portion.
Yes, madam. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತ ಮೆಟ್ರಿಕ್ ನಂತರ ಬಾಲಕಿಯರ ವಿದ್ಯಾರ್ಥಿ ನಿಲಯಗಳ ವೇತನ ಶ್ರೇಣಿ ರಲ್ಲಿ ಮಂಜೂರಾಗಿರುವ 200 ನಿಲಯ ಪಾಲಕರ ಹುದ್ದೆಗಳು ಪೈಕಿ ದಿನಾಂಕ 29/9/2019 ಅಂತ್ಯಕ್ಕೆ ಖಾಲಿ ಇದ್ದ 169 ಮಹಿಳಾ ನಿಲಯ ಪಾಲಕರು ವಾರ್ಡನ್ ಹುದ್ದೆಗಳಿಗೆ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಆಡಳಿತಾತ್ಮಕ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶ ಹಾಗೂ ಕಾನೂನು ಇಲಾಖೆ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದನ್ವಯ ಅರ್ಹ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಮಹಿಳಾ ವೃಂದದ ನೌಕರಿಗೆ ಒಂದು ಬಾರಿ ಮಾತ್ರ ಪರಿಗಣಿಸಿ ಈ ಕೆಳಗಂಡ ನಿಬಂಧನೆಗಳಿಗೆ ಒಳಪಟ್ಟು ಮುಂಬಡ್ತಿ ನೀಡಲು ಆದೇಶಿಸಿದೆ.
So permission is granted to effect promotion as a one-time measure.
One time
From hostel superintendent to hostel warden.
hostel warden.
Hmm.
And I have been promoted. My salary slip is there.
No, what is the, ಓದಿ ಅದು full, no?
ಮುಂಬಡ್ತಿ ಹೊಂದಲು ಅರ್ಹರಿರುವ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಮಹಿಳೆ ವೃಂದದ ನೌಕರರು ನಿಲಯ ಪಾಲಕರ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ಹೊಂದಲು ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ವಯ 29/9/2019 5 ವರ್ಷಗಳ ಸೇವೆಯನ್ನು ಪೂರೈಸಿರ್ತಕ್ಕದ್ದು. I have been completed since I have been appointed in the year 2015. ಮುಂಬಡ್ತಿ ಹೊಂದಲು ಅರ್ಹರಿರುವ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ವೃಂದದ ನೌಕರರು ನಿಲಯ ಪಾಲಕ ಹುದ್ದೆಗೆ ಯಾವುದೇ ಪೂರ್ವಾನ್ವಯ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಲು ಕೋರಿ ಮನವಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಕತ್ತರು. There was departmental proceedings. In departmental proceedings, I have been promoted, and in the counseling, I have chosen current place of work. ಮುಂಬಡ್ತಿ ಹೊಂದಲು ಅರ್ಹರಿರುವ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಮಹಿಳೆ ವೃಂದದ ನೌಕರರು ನಿಲಯ ಪಾಲಕ ಹುದ್ದೆಗೆ ಯಾವುದೇ ಪೂರ್ವಾನ್ವಯ ನಿಗದಿಪಡಿಸಲು ಕೋರಿ ಮುಂದೆ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಾವೇ ಹೂಡತಕ್ಕದಲ್ಲ.
ಅದು ಕರೆಕ್ಟ್ ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಹಂಗೆ ಬರ್ತದೆ ಕೋರ್ಟಿಗೆ ಬರ್ಲೇಬಾರ್ದು ಟ್ರಾನ್ಸ್ಫರ್.
I am my
ನೆಕ್ಸ್ಟ್
ಮೇಲಿನ ನಿಬಂಧನೆಗಳು ಒಪ್ಪಿರುವ ಬಗ್ಗೆ ಮುಂಬಡ್ತಿ ಹೊಂದುವ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಮಹಿಳಾ ವೃಂದದ ನೌಕರ ಮುಚ್ಚಳಿಕೆ ಪ್ರಮಾಣ ಪತ್ರ ಆಯುಕ್ತರು ಹಿಂದುಳಿದ ವರ್ಗ ಕಲ್ಯಾಣ ಇಲಾಖೆಗೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು.
So in terms of the proceedings of 12/1/24, DPC was conducted.
DPC was conducted.
And then you were promoted and given a hostel warden.
Hostel warden.
You have the DPC.
No, it is reflected in the same order. Annexure A2. Annexure A2. Annexure A2 in page 25. Ullekha 1. I mean,
This is after this government order.
Yes, my lord.
ಉಲ್ಲೇಖ 1
ಉಲ್ಲೇಖ 1 ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖ 2 ಪ್ರಕಾರ ದಿನಾಂಕ 17/1/24 ನಡೆದ ಇಲಾಖಾ ಮುಂಬಡ್ತಿ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿದಂತೆ ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶದಲ್ಲಿ ವಿಧಿಸಿರುವ ಷರತ್ತುಗಳನ್ನು ಒಪ್ಪಿ ಉಲ್ಲೇಖಿತ 3 ಸಲ್ಲಿಸಿರುವ ಮುಚ್ಚಳಿಕೆ ಪ್ರಮಾಣ ಪತ್ರದಂತೆ ಹಿಂದುಳಿದ ವರ್ಗ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತೆ ಈ ಕೆಳಕಂಡ ನಿಲಯ ಮೇಲ್ವಿಚಾರಕರು ಮಹಿಳಾ ವೃಂದದ ನೌಕರಿಗೆ ಕೆಳಕಂಡ ಷರತ್ತುಗಳು ಪಟ್ಟು ₹16 ವೇತನ ಶ್ರೇಣಿಯ ನಿಲಯ ಪಾಲಕರ ವೃಂದಕ್ಕೆ ತಕ್ಷಣದಿಂದ ಅನ್ವಯಿಸುವಂತೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಿ ಆದೇಶಿಸಿದೆ.
Now there in that hostel there is a post.
No. Yes, it is upgraded. I have also produced that document, my lord. And my salary slip, it is reflecting as warden.
No, that upgradation just show us.
Yes, ink page 7, my lord. The
page 7.
Ink page 7
of that memo.
Additional document. District level organization chart it is.
Yes.
Jilladhikari, CEO. So Nilaya Palakaru, metric ನಂತರ ವಿದ್ಯಾರ್ಥಿ ನಿಲಯ. It is Nilaya Palakaru. It is hostel warden. Thereafter Nilaya ಮೇಲ್ವಿಚಾರಕರು. It is hostel superintendent. Metvir Purva. Slight different is there, my lords. It is metric ನಂತರ. It is Metvir Purva.
ಇವಾಗ ನಿಮ್ದಿರೋದು
ನಿಲಯ ಪಾಲಕರು. It is post metric.
Metric ನಂತರದ ವಿದ್ಯಾರ್ಥಿ ನಿಲಯ. This is the organization chart.
Yes, organization chart. Nilaya Palakaru means hostel warden should be at post metric. Nilaya ಮೇಲ್ವಿಚಾರ hostel superintendent pre-metric. ಅಲ್ಲಿ ಇರ್ಬೇಕು ಅಷ್ಟೇ.
Oh, that is
yes,
pre-metric.
Pre-metric.
So
I am working at post metric. See, the fourth respondent is ineligible to hold that post. It is post metric hostel, not pre-metric hostel.
Now what has happened now? Now what has happened?
By virtue of interim order of the Honorable Tribunal, I have been continued, and after the disposal, I have not handed over the charge, but the fourth respondent assumed this charge. As on today, she is, but I have not handed over the charge.
Whatever it is. Now you tell us correctly, if in that hostel There is a
That post is available or not. Please, madam.
Now, in terms of the proceedings and annexure A2, if you are promoted and posted, then there must be some upgradation in terms of the organization charter. You find out what the procedure
madam.
is. But all said and done, once you promote a person, it's not fair to put that person to this litigation. Suppose you promote, ಅವೆಲ್ಲ ಬಂದು ಹಾರ ಹಾಕಿ ಮನೇಲಿ ಹೇಳಿ ನಾನು ಪ್ರಮೋಟ್
ಆದ್ರೆ
ಆಗಿದ್ದೀನಿ ಅಂತೆಲ್ಲ
169
ಅಲ್ಲಿ ಒಂದು ಟೇಬಲ್ ಇಲ್ಲ ಅಂದ್ರೆ
169 post ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆ ಖಾಲಿ ಅದ್ರಲ್ಲಿಕ್ಕಿಂತ
you
ಜಾಸ್ತಿ.
find out.
Yes, that is what I'll take.
I'll have it on
It
Monday.
is also I have produced with
Monday
additional document.
ಬರ್ಲಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ. Monday ಬೇಡ.
ಅಲ್ಲ,
ಅವ್ರು
next.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಟೈಮ್ ಕೇಳೋದು.
23rd.
ಆಯ್ತು.
List on 23rd in the order stage.
Please.
ಇವಾಗ ಅವ್ರ ಪ್ರಮೋಷನ್ ಗೆ ಸ್ವಲ್ಪ ಖುಷಿ
ಹೌದು.
ಪಡೋದು ಬೇಡ.
ಅಲ್ಲ, ಆ ಪೋಸ್ಟ್ ಇಲ್ಲ ಅಲ್ಲಿ.
Set up. Post ಇದೆ ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಈ page ಏನು?
If transfer, let's say better. ಅದು ಎಸ್ ಮಾತಾರ ಏನೋ ಒಂದು ಸ್ಟ್ರಿಕ್ಟ್ ಆಗಿರೋ ಕಾಯ್ದೆ ಹಾಕ್ಬೇಕು. ಅಲ್ಲಿಗೆ you must get one undertaking. We will not challenge the transfer. I will first report any grievance. I'll make to the grievance redressal authority. I will exhaust all the administrative options. ಅಂತ ಇಲ್ಲಿ 24 ಗಂಟೆ ಇಲ್ಲಿ ಬಂದು ಇಲ್ಲಿಂದ right up to the Supreme Court curative petition. Transfer, why are they spending time here?
But Supreme Court latest judgment says, my lord, first they have to take charge and then challenge.
Correct.
That is latest judgment of the Honorable Apex
That
Court.
is the
First they have to take charge. Without taking charge, they can't challenge the order, man.
Because you are on this side, you are saying.
No, even.
ಏನಿಲ್ಲ.
Please, ma'am.
Let us, please.
Number 24, Maruti S.
Appear for the petitioner, my lords.
This is a similar matter
Yes.
yesterday.
Yesterday matter, my lords. Same matter, yesterday matter, my lords.
41 officers.
ಹಾ, ಕೊಡಿ.
Yes, my lords. And my lords, and the same issue also decided in one case, my lords, in the Honorable High Court Dharwad bench, my lords. My colleague is, my lords, there, submit the copy, my lords.
ಕೊಡಿ. ಓಪನ್ ಮಾಡ್ಕೊಡಿ ಇದು. The
ಇದಲ್ಲ ಧಾರವಾಡ ಬೆಂಗಳೂರು ಹೊರಗಡೆ ಮತ್ತು ಮೇಡಮ್
now here they have adopted sealed cover, ಏನದು? No,
ಇಲ್ಲ,
they've reverted. They've
ಹೌದು, reverted, ಸ್ವಾಮಿ, reverted.
The present petition has been filed by the applicant before the tribunal, challenging the order passed in application number 20980 of 2022, whereby application filed before the tribunal challenging the order at annexure A6.
Please.
A6 page.
A6 page 78, my lords. Dated 6/9/2022, my lords.
A6 dated 6/9/2022, whereby the order of promotion of the petitioner dated 30th August 2022
Please, my lords.
was revoked.
Reverted.
Was order of promotion was revoked and petitioner was reverted to the
Please.
earlier post and stuff. The brief facts made out in the full stuff. The parties are referred to by the rank before the tribunal for the purpose of convenience. Next, it is the case of the petitioner that he was appointed as a warder.
Warder.
Warder Warden, warder,
Warder, my lords, warder.
warder. In the year 2012 and was eligible for promotion, and accordingly the second respondent, Director General of Police, is stated to have called for necessary records to consider the case of promotion. It is further submitted that pursuant to proceedings in the Departmental Promotion Committee, the petitioner was promoted as per order dated 30th August 2022
22, my lords.
at annexure
At annexure A4, my lords.
A5.
Yes, ma'am. A5, my lords. Sorry, my lords.
At annexure A5. Full stop. The further case of the petitioner is that by order dated 6/9/2022, the petitioner's order of promotion was revoked and petitioner was reverted to his earlier posting pre-promotion. Full stop. Petitioner had filed application before the tribunal and challenged the order at annexure
A6.
Full stop. Next, it is to be noticed that the order at annexure A6, while reverting the petitioner and setting aside his order of promotion, has noticed that insofar as the petitioner had committed lapse in performance of his duty, disciplinary proceedings were contemplated to be initiated, and such proceedings were sought to be initiated in relation to the illegal use of mobile phone by under trial number 13167 Yusuf Bacha Khan. Before the tribunal, both sides had addressed detailed arguments, and the tribunal, taking note that proceedings for initiation of a disciplinary inquiry was sought to be initiated, took note of the DPC, but observed that due to lapse on part of the concerned officials, this aspect of contemplated disciplinary proceedings was not brought to the notice of the Departmental Promotion Committee, has upheld the order at annexure A6 and dismissed the application. The tribunal took note of contemplated disciplinary proceedings as a sufficient ground to uphold order at annexure A6. Tribunal also took note of the sensitive post of the petitioner. It was further submitted that though order of promotion was effected, the applicant had not taken charge.
Please, my lords.
Had not taken charge, and within such time it was permissible to pass order at annexure A6. That order has been challenged before the tribunal. It is the case of the applicant that in terms of Rule 2146, subclause 6 of KCSR, it's the date of framing of charge, which is the date to be taken note of as initiation of a departmental proceeding. Full stop. It is submitted that the charges were framed on
Annexure R4, my lords, dated, let's, dated 24/11/2022, my lords.
on 24/11/2022, while the order of promotion itself was on 30th August 2022.
Please, my lords.
And the DPC proceedings were at an earlier point of time. And accordingly, as no charges were issued as on the date of the DPC proceedings, petitioner could not have been subjected to reversion by order at annexure A6 by reliance on articles of charges issued after his order of promotion. Full stop. Reliance is also placed on the orders of the coordinate bench in WP 105960 of 2024, disposed of on 7th November 2024, as also order passed in WP 19407 of 2023, disposed of on 11th July 2024, relating to employees who were subject matter of proposed disciplinary proceedings relating to the identical nature of allegation of employees permitting impermissible use of mobile phone by the under trial. Next, heard both sides. The only question that falls for consideration is whether the tribunal has erred in upholding order at annexure A6, which was contrary to at annexure A6. Next, it must be noticed that the facts are not in dispute. The DPC proceedings were before 30th August 2022. The petitioner was promoted as per order at annexure A4 dated 30th
A4,
August, 30th August 2022. No doubt there were certain proceedings relating to lapse in performance of duty by the applicant along with other employees numbering 41. Full stop. However, the show cause notice itself came to be issued on 24/11/22.
Yes, my lords.
Subsequent to the order of promotion. Full stop. Clearly, it is not in dispute that as on the date of the DPC, no articles of charges have been framed. Full stop. If full stop. In terms of Rule 2146 of the KCSR, the date to be taken for initiation of inquiry proceedings is the date of issuance of articles of charge. As on the date of the DPC, since no articles of charges have been issued, it could not be stated that there was any embargo on considering the case of the petitioner applicant. Full stop. Next. No doubt in the event in the proceedings initiated pursuant to show cause notice dated 24/11/2022, the applicant were to suffer an adverse order, punishment is always open to be imposed. But that by itself would not be a ground to revert the petitioner as regards order passed at annexure A4. We'll stop. Next. The coordinate bench of this court as regards similarly situated employees facing identical allegation has considered their case and passed order upholding has passed an order holding that the resorting to seal cover procedure as regards such of the employees was impermissible as there were no proceedings pending as on the date of the DPC and order of promotion. Peruse the order passed in WP 19407 of 2023. Observations made at para 8 onwards are of relevance and extracted below. Full stop. The coordinate bench has clearly noticed the case of KV Janki Raman's case and upheld the contention as raised by the applicant herein and recorded a finding that as on the date of convening of the departmental promotion committee and as on the date of promotion, there were no proceedings pending as against the employee. Full stop. The same stand has been taken by the coordinate bench in the case of Rajesh K. WP 105960 of 2024. Accordingly, even on the ground of parity, we find that there is no reason to meet out the applicant with a different outcome. The fact that the petitioner stands on parity with the petitioner in WP 105960 of 24 and WP 19407 of 2023 is not in dispute. Accordingly, the order of the tribunal is set aside and the application is allowed. Order at annexure A6 is set aside.
Much obliged. And my lords, direct the my lords to provide the post, my lords.
Respondents to take necessary steps to give effect to order at annexure A4 and provide posting.
Much obliged.
Yes.
Question number 25, Harshvardhan R. Malipatti.
The appellant.
Yes.
It's an appeal by the claimant for enhancement. Not
Why
deceased,
since 2018 is pending?
But the issue is regarding, my lord, the salary, my lord, which is taken. Court has considered, my lord, 3,19,112 as the gross salary. Will Lordship kindly come to, my lord, internal page 12 of the judgment.
PCR again. PCR not required. Required or not required?
But no, my lord, because, my lord, the salary is extracted. The issue is, my lord, what should be the deduction towards, my lord, income tax? The accident is of the year August 2016. So, my lord, the financial year will be 15-16 and, my lord, the assessment year will be, my lord, 16-17. The basic exemption was, my lord, 2,50,000. Court has considered, my lord, 1,50,000 and for the remaining part, my lord, it has taxed, my lord.
You have the details.
My lord, I could get an extract from the.
First, you show us now there
Yes.
how the tribunal.
Yes, page, internal page, judgment page number 12, my lord. The third paragraph, my lord, the month, I'll read from, my lord, the second paragraph, exhibit P, internal page 12 of the judgment. I'm referring to, my lord, judgment page number 12. Exhibit P9 salary set, paragraph 2, exhibit P9 salary certificate of the deceased goes to show that he was drawing gross salary of 26,624. Salary certificate for so and so is produced before the court. Monthly is so and so. Annual salary comes to 3,19,112. Out of which, my lord, professional tax of 2,400 rupees per month, rupees 200 is deducted. My lord, this is proper. Then the amount comes to 3,17,112. In this 3,17,112, income tax is to be deducted. Rupees 1,50,000 standard deduction is to be deducted. Then 3,17,000 minus
17,000 odd minus 1,50,000 comes to 1,67,000. For this 1,67,112, 10% income tax is to be deducted. It will come to so and so. So, my lord, 16,000 is deducted. As per my calculation, my lord, it will be, my lord, instead of 1.5 lakhs, 2.5 lakhs has to be deducted. 2,50,000 was the basic exemption for that, my lord, period. If that is done, my lord, about 67,000 and odd will be the, my lord, income which will be taxable. 67,112 will be the income, my lord, income amenable for tax. My lord. If 10% is taken, my lord, it will be 6,711. Instead of 16,000, my lord, it will be 6,711, which will have to be deducted.
So you give it in writing.
Yes, I'll produce that.
67,112 minus.
This 6,711, my lord, that has to be deducted in 3,17,000. 317,112 minus.
On 67,112, 10%.
Minus 10%.
Yes, yes.
67,112, 10%.
10%. It will be, my lord, 6,711. My lord, if that is deducted, my lord, the net income, my lord, will be, my lord, 3,10,401 for per annum.
3,10,401.
Lord, there will be an additional increase of, my lord, 10,000 per annum. Court has considered 3,401. Lordships will get in last second paragraph on the same page. My lord.
So you give your rework and
Yes,
give it.
yes, yes.
That is the ground.
Yes.
Huh?
Yes, my lord. That is one ground, my lord.
Huh.
Second ground is, my lord, the multiplier, he was aged 40 years.
40 years.
Yes.
What is the multiplier?
Multiplier applicable is, my lord, 15. The court has considered, my lord, 14. Lordships will get his age on, my lord, first paragraph of judgment, page number 12. Court says that, my lord, he has completed 40 years. He is running 41 years. So, my lord, it goes to, my lord, a lesser multiplier. It's the completed age which has to be considered. Page 12, my lord, first paragraph is the age.
You're saying it's the completed age.
Yes, completed age.
41 is running.
That is
He has completed, my lord, 40 years.
No, correct. So where do you get this completed age?
My lord, on the first paragraph of, this thing, my lord. My lord, the criteria for multiplier is, my lord,
In Sarla Varma, do they say?
Yes, my lord. Sarla Varma, my lord, paragraph number 21. Lord, 15 multiplier is applicable for an age group of 35 to 40. 14 multiplier, my lord, is applicable for age group of 41 to 45.
Age multiplier of?
14 multiplier of 14 is applicable to age group of 41 to, my lord, 45. For, my lord, age group of 35 to 40, my lord, it's 15. So, my lord, if it is 40, my lord, it has to be 15. If it is 41, my lord, age always, my lord, will be, my lord, the completed age, my lord. Running age cannot be taken. He was, my lord, 2 days, my lord, or, my lord.
Sarla Varma
Paragraph 15, my lord, I'll supply that, my lord. I'm sorry. On the earlier occasion, I think it was.
Idea? Noti file.
Paragraph 15, paragraph 21, my lord, I will.
Age shown in the PM.
Sorry, my lord.
Age shown in the PM.
No, my lord. They have considered, my lord, his birth age because he was salaried person.
Exhibit P, R5.
They have considered R5, his service, my lord, record,
Service.
which shows, my lord, his age was, his date of birth is so and so, and they have calculated, my lord. It's about 40 years and, my lord, about 21 days.
Yes.
That was the second ground. The last one was, my lord, I contended that, my lord, the future prospect should be, my lord, 50%. My lord, since his age is 40. My lord, but the wordings, my lord, therein are, my lord, if he's less than 40, my lord, it's 50%. And, my lord, 30% for, my lord, 40 to 50.
So it will be 30%.
My lord, I may fail on that account, my lord, it will be 30%. Multiplier, it's, my lord, worded as, my lord, 35 to 40 and 41 to 40. Whereas, my lord, when it comes to, my lord, future prospects, if
So
he's
40.
less than 40,
40.
my lord, that's the wordings, my lord. So
Be
will
30.
be, my lord.
30.
Yes, my lord.
40.
That's all.
Yes.
So now you give that one
My lord.
page note.
Yes.
On the multiplier.
Yes.
And this income tax.
I'll give the chart, my lord, the calculation. I'll do it right now, my lord. I had done it, my lord, with 50%, but 50%, my lord, I
Make it
just checked.
30%.
I'll make it 30 and, my lord.
Yes. No. Make one detailed one so that it becomes easy for dictation. This
Will be
need
an
not have waited 5 years.
Yes, my lord, I was, my lord, contesting that future prospects of, my lord, 50%. That's why, my lord, it got adjourned, my lord, several times, my lord. Then I made my research and, my lord, now I'm convinced that, my lord, 30% is the one.
Less than 40.
Why that judgment relied from Bhagat judgment?
Somvati.
Somvati, my lord, the other issue was regarding, my lord, the consortium, my lord, because at that time, my lord, there was a confusion whether, my lord, that consortium can be given to, my lord, all the persons. Pranay Sethi said, my lord, 40,000 is the consortium. My lord, that was interpreted to mean, my lord, per head, my lord, 40,000.
For all the.
Yes, my lord, for all the claimants, my lord, 1,20,000. My lord, now that is settled for every person. My lord, that was another issue for which it was. There will be an escalation about, my lord, enhancement of 4,45,000. I'll give the, my lord, chart. Great. Great.
Allowed in part.
Yes.
26. Harshvardhan or Malipatti?
This is, my lord, appeal by the claimant. Claim petition is dismissed, my lord.
Claim petition is dismissed.
Yes, my lord. It's a case of death, my lord. The court, my lord, dismisses it on account of, my lord, on the count that, my lord, one medical record, my lord, paragraph 12, my lord, internal page 6 of the judgment. The accident is said to have taken place, my lord, on 26/11/2014 at, my lord, 7:15 p.m. That is the case of the claimant. The court assumes, my lord, one medical record. It is, my lord, the court interprets that medical record as, my lord, the deceased having been admitted at, my lord, 5 o'clock on the same day. So court says when you are admitted in the hospital at 5 o'clock, there cannot be an accident at 7 o'clock, 7 p.m. That's the, my lord, whole analogy for, my lord, the dismissal. My lord, firstly, my lord, it has read the document, my lord, erroneously. Because the document time of admission is, my lord, for 7,
Exhibit R3.
yes. The time of admission, my lord, is 7:42 PM. But in the body, my lord, he says that the person who came with that person, the injured, my lord, who was unconscious at that time, he said that, my lord, an accident has occurred at 5 o'clock at this place. That's recorded in the body of that, my lord, medical.
Take us to that exhibit. Then. Let us see.
Yes. Exhibit P3, my lord, your lordship is holding, my lord, the medical record register of, my lord, General Hospital.
Admission record R3.
In the bottom, my lord, the Dr. Sharad K. Date is, my lord, 26/11/2014. Time is, my lord, 7:42.
26/11.
Lord, your lordship is holding this document. Please.
Admission record.
It's titled as, my lord, register Basveshwar Teaching and General Hospital. Yes, my lord, accident register. Yes, my lord. Right hand side bottom.
Admission.
My lord, I think, my lord, it's a long, lengthy page. Your lordship may kindly turn to the next page. Your lordship is holding, my lord, the first Murugappa anta baride. The first page, my lord, mentions the name of the second page, my lord. It's a single extract, my lord, lengthy register, my lord, produced as. Yes, my lord, that. The first page and this is, my lord, the second half of the same page.
26/11.
26/11/2014 is the accident. Admission time, my lord, is, my lord, 7:42. In the body, my lord, there, my lord, it is mentioned as, my lord,
At about 5 PM.
at about 5 PM. That's the, my lord, the statement of the person, attender who came along with them, saying that, my lord, accident has occurred at 5 PM.
So you're saying, so the admission of the patient was at 7:40.
7:42. My lord, my case is accident occurred at, my lord, 7:15. He was admitted, my lord, after that. That is 7:42. Here it is, the only statement is, my lord, the attender, my lord, said that the accident has happened at so and so today at about 5 PM. This, the court presumes that, my lord, he was admitted at 5 PM.
There is no specific mentioning of admission date. Admission.
9:30.
Yes, my lord. It is not, there is no specific mention, but this was something which was recorded at, my lord, 7:42. He records that, my lord, this is very, my lord, written in this thing, my lord, I was able to say, my lord, petitioner attendance gives alleged history, H-bar-O is, my lord, history of RTA, that is road traffic accident, near Magaon on so and so at about 5 PM. So patient attender, what is recorded at top is, my lord, the say of the attender that accident has occurred at so and so on so and so date at so and so time. Now, my lord, if your lordship sees, my lord, the judgment. The court assumes this.
Considered at 9:36 p.m.
Yes, my lord. In fact, the other records also show that, my lord, it was, my lord, 9:36 p.m. Otherly 7:40. But any event, my lord, it's a post, my lord, 7 o'clock. He was never admitted, my lord, there. This 5 p.m., my lord, comes only, my lord, with reference to this document, which says, my lord, the patient attender report.
There's one more document.
Yes.
You go to the history, admission record. Admission record.
Yes.
In the next page, handwritten history. It says 6:30.
Actually, what is the 9:36 p.m. 26/11 in exhibit R3? R3?
R3, my lord.
26/11/2014. Discharge on 30/11/2014. What is it? 9:36 p.m.
He died on 30th.
Died at expired on the 2/15.
Yes.
9:36 p.m. died, expired.
No, my lord. He expired.
Just see R3. R3.
But he expired, my lord, on 30th. He expired subsequently. Date of exam 30th 11. My lord.
Date of admission.
Date of admission
9:36.
9:36. My lord.
Date of discharge 30/11/2014, 2:50.
Yes, my lord.
So what is that? How come this 26/11/2014, 9:36 p.m.?
My lord, what will happen is, my lord, he is produced to the casualty unit. There he is, my lord, examined. That's, my lord, 7:36. He takes admission, my lord. That admission process, my lord, the paperwork, my lord. There, the, my lord, admission, my lord, will be, my lord, the paperwork and the entries, my lord. That could be, my lord, the variations.
So injured reached the hospital at 7.
Yes, my lord. 7 after, my lord, 7:30 only. The only record regarding that 5 p.m. that was, my lord, as per my claim, prior to, my lord, the accident. That is, my lord, a statement given by, my lord, the attender saying that on this time it has happened. It's an approximate time, my lord. That cannot be, my lord, used as, my lord. He has come, my lord, after everything else, my lord. The complaint was registered within 24 hours. The charge sheet is filed. Court assumes, my lord, this 5 p.m. as the date of, my lord, he being, my lord, that. What I believe is, my lord,
So after 5 p.m. when he admitted.
Yes. There is no question of, after 7 only he's admitted. My lord. The first records, my lord, speaks of, my lord, 7, after 7:30 only. He was never admitted, my lord, at 5. And he was brought unconscious.
Whether the accident is in question?
No, my lord, the charge sheet is filed. Charge sheet is filed. The complaint was within, my lord, 24 hours. My lord, police investigation was made, charge sheet was filed. Everything, my lord, is okay. Court presumes he was admitted, my lord, at 5 p.m. and, my lord, says that this record doesn't tally.
Whether you place the FIR and this one, charge sheet?
Yes.
Document?
Yes.
Huh?
Yes, they're part of the record.
Accident in question is not disputed.
No.
Coverage of police.
FIR
also not
P1 coverage is also not in dispute. P1 is, my lord, FIR
Criminal
P3.
dismissal only based on this one, na?
Yes, yes. Your lordship may kindly see, my lord, internal page 6 of the judgment, para
Case
12.
of the rider itself is that they started traveling at 7 o'clock. So question of, they started traveling at 7 o'clock.
ಯಾರು ಹೇಳ್ತಾರೆ?
Or Baga, who is the rider of the motorcycle? The deceased was a pillion rider.
Where it is
They,
stated? Where it is
they
stated?
should have been examined.
Where it is stated? The complaint.
The complaint is.
ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್ ಒಮ್ಮೆ ಓದಿ ಅದನ್ನು.
615 is what is stated.
ನಿನ್ನೆ ದಿನಾಂಕ 26/11/2014 ಬಬಲಾದ್ ಗ್ರಾಮಕ್ಕೆ ಬಬಲಾದ್ ಮುತ್ತೆ ಅವರ ಪುಣ್ಯ ತಿಥಿ ದರ್ಶನ ಮಾಡಿಕೊಂಡು ಬರಲು ನಮ್ಮ ಹೊಂಡಾ ಆಕ್ಟಿವಾ ಸೋ ನಂಬರ್ ಸಾಯಂಕಾಲ 6:05 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ಮತ್ತು ನಮ್ಮ ತಂದೆಯವರು
ಸಾಯಂಕಾಲ 6:15 ಗಂಟೆ ಸುಮಾರಿಗೆ
ದಿಂದ ಹುಮ್ನಾಬಾದ್ ರೋಡ್ ಮುಖಾಂತರ ಬಬಲಾದ್ ಗ್ರಾಮಕ್ಕೆ ಹೊರಟೆವು. ಸಾಯಂಕಾಲ 7 ಗಂಟೆಗೆ ಸಿರ್ಗಾಪುರ್ ಕ್ರಾಸ್ ಹತ್ರ ನಮ್ಮ ಹೊಂಡಾ ಆಕ್ಟಿವಾ ನಿಲ್ಲಿಸಿ ಅಂಬಾಭವಾನಿ ದೇವಿ ದರ್ಶನ ನಾವಿಬ್ಬರು ನಡೆದುಕೊಂಡು ದರ್ಶನ ಮಾಡಿ ನಮ್ಮ ಗಾಡಿ ಹತ್ತಿರ ಬರುವಾಗ
it's not after 7. It says, my lord, 6:15 we started. Accident occurred at, my lord, about 7.
ಮುಂಜಾನೆ ಹೋಗ್ಯಾರ. ಏನು ಟೈಮ್
ಇಲ್ಲ PM.
7:30 ಆದ್ಮೇಲೆ ಯಾಕಿನ ಮೊದಲಂತ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿಲ್ಲ. ಇದಕ್ಕೆ ಹೆಂಗ್ ಹೋಯ್ತಪ್ಪ 7ಕ್ಕೆ ಹೋಗಿ ಸ್ಪಾಟ್ ಮೇಲೆ 7ಕ್ಕೆ ಇದಕ್ಕೆ ಹೆಂಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ? 145.
What is the, in your statement of objection before the tribunal, what have you taken?
I don't have records.
Huh?
Don't have records. And they have not. RW1 has been examined. RW1, the doctor has been examined. His evidence.
Have you questioned the charge sheet?
No.
No.
Then?
No, we are not disputing the charge sheet, Manoj. We are not disputing. We are accepting the charge sheet. The charge sheet said the accident took place at 7:30. And my lords, the MSc report that has been produced is at 5 o'clock. We have examined the doctor. It was RW1. Evidence of RW1.
Time of accident ಅಷ್ಟೇ ಅಲ್ವಾ? Admission and time of accident. Even admitting. Even admitting for the sake of argument.
What the RW1 has deposed, I would.
ಏನಂತ ಡಿಪೋಸ್ ಮಾಡಿದ್ರು?
Ample file. Record.
What it says is, my lord, at about 5 PM, accident has occurred. My lord, I say it's 7, about 5 PM.
The son being the my lord's
time
is the sole witness. He is the son, my lord. They would have examined.
ಆಗಿದೆ ಹೌದಾ? ಒಪ್ಪಿಕೊಳ್ತೀರಾ?
Accident
Accident ಒಪ್ಪಿಕೊಂಡಿದ್ದೀರಲ್ವಾ?
It is not disputed.
Dispute
Only the
ಇರೋದು
timing.
Dispute ಇರೋದು timing ಅಲ್ಲಿ. At the time of admission to the hospital. That's all. Then how does it matter?
My lords, here what has happened, my lords? The son himself is the rider of the motorcycle. He says that the accident took place at 7. But he has been admitted to the hospital at 5 PM prior to the accident.
No. He is admitted at 7:45, 7:42 or at 9:36. Both are after 7
Alla,
o'clock.
Judges, my lords, here, the question is, my lords, whether, why didn't they examine the eyewitness, my lords, who was taking his own father, my lords? That adverse inference has been drawn by the tribunal.
It's not a criminal case.
And we have examined the RW1. Now, if I go through once, I will go through evidence of RW1.
W1, what does he say?
ಒಳ್ಳೆದಾಯ್ತು.
ಐವಿಟ್ನೆಸ್ ನಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಸಿ
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. Eyewitness ಅಲ್ಲಿ his family member, not as a eyewitness.
PW1.
RW1.
ಅಲ್ಲ RW1 is ನಿಮ್ಮೂರು.
ಹಿಸ್ಟ್ರಿ ಆಫ್ ಇಂಜುರಿ ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಕ್ಲಾರಿಟಿ ಸ್ಟೇಟೆಡ್ R1 ಅಲ್ಲ?
ಇವರು R1 ಅಂತಾರೆ ಸುಮ್ಮನೆ. R1 ಅಲ್ಲಿ ಆತರ ಏನಿಲ್ಲ.
ಕ್ಲಾರಿಟಿ ಸ್ಟೇಟೆಡ್ ಬೈ ಸ್ಕಿಡ್ ಅಂತ ಸ್ಕಿಡ್ ಆದಂತ
It didn't fell. When he was 5 p.m.
5 p.m.
He was traveling on. He was traveling.
About 5 p.m. His
Fell down on
he was traveling
yes.
on a bike so and fell down. Fell down.
Fell down anta ide summa. Fell down can be read, my lord. Fell down.
FIR registered next day, na?
Sorry. Patient is semi-confined.
Complaint ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ number?
Sorry.
Vehicle number.
Yes, yes.
Complaint it is stated.
Howದು. It is stated. It was seized, my lord, and charge sheet is filed against the same vehicle. Complaint is, my lord, within.
Lodged it?
Lord, within 24 hours, my lord. About 3 o'clock next.
3 a.m.
Next day.
3 a.m. on 27/11.
Immediately then.
I have not disputed.
Mention the name of the offending vehicle.
Yes.
Number of offending vehicle.
The vehicle, he dropped the vehicle and ran away, according to him. The vehicle was there itself.
That is not at all dispute.
No.
Only the timing. ಇನ್ನೇನಿದೆ?
If I go through RW1, my lord.
RW1 ಸೇಮ್ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. ಸ್ಕಿಡ್ ಆದದ್ದಂತ ಹೇಳಿದ್ದಾರೆ. That's all. He placed the
ಇದು ಏನಾಗುತ್ತಂದ್ರೆ person, my lord, an attender who comes along with him, my lord. My lord, the situation is that he has come, my lord, unconscious or, my lord, barely conscious, my lord. And some attender gives, my lord, some information at the time.
He is not some attender. He is the rider of the motorcycle and son of the injured, my lord. How
Alla,
can
son of the injured has given this ಅಂತ ಬರೋದಿಲ್ಲ. He says patient attender.
Random person ಹೇಳಿದ್ರು ಮಾತ್ರ.
ಆಯ್ತು ನೋಡಿ ಮೆಮೊ ಕೊಡಿ. ನೋಡಿ ಮೆಮೊ ಕೊಡಿ ಎಷ್ಟಾಗುತ್ತೆ ಮೆಮೊ. ಅವ್ರು ಬೇಕಾದ್ರೆ ನೋಡ್ಲಿ.
ಆಯ್ತು.
ನೋಡ್ತೀರಿ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ?
I will only go through evidence of harm.
ಮಾಡ್ಲಾ ಅಲ್ಲ ಯಾವಾಗ? ನಾಳೆನಾ?
Heard
Tomorrow.
ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ, ಎರಡು paragraph ಇದೆ.
ಆಯ್ತು ಹರ್ಷ, ನಾಳೆಗೆ ಇರಿ.
ಆಯ್ತು.
Let him go through.
My
But what,
presence may be.
regarding income, how do you say?
Yes, madam.
Notional income,
Yes,
huh?
for income, my lord,
Notional income.
7,500.
They give you a calculation.
I'll give the chart.
Release tomorrow.
Lord, my presence, my lord, morning.
You just
My
give that
colleague
chart.
will be there.
Give the chart. Give one memo,
Yes,
mention the calculation, and briefly you just one page you write, so it help us to dictate. Yes,
Number 20. Hema L. Kulkarni.
yes.
The order of the learned single judge is agreed here. Order of the learned single judge, my lord, the termination of the petitioner from services who was working since 2011, my lords.
No, correct.
Last occasion, my lordship has expressed that if there are availability of 2 posts and because of the absence of the other side, my lords, he was not
correct,
keeping. them.
but
Please,
now, before the single judge, the termination was challenged by you. You have challenged.
yes. Earlier to that, there was a writ of mandamus by the contesting respondent, my lord, to consider his representation. He had given a representation because he has left the job in 2009 and
Who?
he had the contesting respondent number 6 minutes.
5.
He had, in the earlier round of litigation, he had filed a mandamus to consider representation. Based on that, my lord, I have been terminated, saying that now that there is an order.
Just, who is this Rajkumar? He was the original employee.
Oh, my lord's original employee, there is no sanction post, there is no permanent
Okay,
employee.
who was first working? Rajkumar.
Rajkumar. He says that he was
The services were terminated.
not terminated, my lords. He left the job in 2009. He makes representation only in the late 2000, only after my appointment, saying that I was not terminated. He is not terminated properly. Therefore, the appointment of the petition itself is illegal per se. With that notice, my lords, but that was not the contention before the writ petition before in the earlier round of litigation. He had said, I have been moving a representation.
No, correct. In the writ proceedings, you filed the writ, isn't it? What was the relief sought for by
Yes.
you?
The annexures. So I'll take that.
Annexure D.
Please.
You challenged Annexure D. Page
38 and 39.
What is this Annexure D?
Annexure D is, my lords, that is in persons of the order passed in writ petition number 207584 of 2015, my lords. May I take my lordship notice to that order, my lords? 207584, page number 40 to 42, Annexure E.
That was filed by the respondent.
By the
number
respondent
4,
5 Rajkumar.
5. What happened in that? Writ?
His contention that representation by Annexure H, it was submitted by him on 30th April 2014. Same was not replied. Therefore, my lord, he had approached this honorable court and this court has directed the respondent but 2, my lords, that is
So
CEO
what
to
is the
consider.
representation at Annexure H?
That is not forthcoming.
This is the tragedy of issuance of mandamus.
Yes.
Huh?
And keeping that, my lord, they
Tragedy or a comedy?
the disadvantage that is.
ಏನ್ representation ಅಂತ ಆದ್ರೂ
ಅಷ್ಟೇ ಇದೆ, ಅದನ್ನ ಎನ್ಕ್ವೈರಿನೇ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ ಅವರು. They had replied it, that would have been enough. But based on that, they conduct inquiry and say that termination itself is illegal. Therefore, the appointment itself is illegal and therefore they terminate me. This is the only thing.
No, correct. So what he said, he wanted reinstatement.
Annexure H is.
Rajkumar.
Yes.
Annexure H page. We don't have that copy.
That annexure
No, this
H
one.
is not there.
Page 44 is yours.
My representation, that is.
So what it, okay, so after this annexure E, what happened? After
Annexure
annexure
E.
E,
After this annexure E, that is annexure D, my lords. D happened.
annexure,
D. At page 38.
read that,
38.
read
She-
that order.
Please. Shri Rajkumar, that is impugned herein before the learned single judge. ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುತ್ತಿಗೆಯವರನ್ನು ನಾಗ್ನೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಪುನರ್ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಮೇಲಿನ ವಿಷಯದನ್ವಯ ಉಲ್ಲೇಖ 1 ಮೂಲಕ ಕಲಬುರಗಿ ತಾಲೂಕಿನ ನಾಗೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುತ್ತಿಗೆಯವರನ್ನು ವಿನಾಕಾರಣ ಕರ್ತವ್ಯ ತೆಗೆದು ಹಾಕಿದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಒದಗಿಸದೆ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರು ಅಧಿಕಾರ ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ನಿಯಮ ಬಾಹಿರವಾಗಿ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದೇವರನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಈ ರೀತಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರ ಮೇಲೆ ಕ್ರಮ ಕೈಗೊಂಡು ಸದರಿಯವರನ್ನು ಪುನಃ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಂಪ್ಯೂಟರ್ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರೆಸಲು ಆದೇಶ ಮಾಡಲು ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ದಿಯವರು ಕೋರಿಕೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧ ದಿನಾಂಕ 30/8/2014 ಹಾಗೂ 12/7/2015 ಸಂಬಂಧಿಸಿದ ಅಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಅಲ್ಲದೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ತಾಲೂಕಾ ಪಂಚಾಯತ್ ಕಾರ್ಯಾಲಯಗಳಿಗೆ ಅಲೆದಾಡಿ ನೋವನ್ನು ಅನುಭವಿಸಿದ್ದೇನೆ ಎಂದು ದೂರುದಾರರು ತಮ್ಮ ಮನವಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಕುರಿತು ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿಯಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಸೋ ಹಾಕಿದ ನಂತರ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯವು ಸದರಿ ಮನವಿದಾರರ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸೂಚಿಸುತ್ತಾರೆ. ಈ ಕುರಿತು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಯೋಜನಾ ನಿರ್ದೇಶಕರು DRDA ಕೊಠಡಿಯಲ್ಲಿ ದಿನಾಂಕ 20/11/2017 ಹಾಗೂ 8/3/18 ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಹಾಗೂ ದೂರುದಾರರ ಸಮ್ಮುಖದಲ್ಲಿ ವಿಚಾರಣೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆ ಸಮಯದಲ್ಲಿ ಸದರಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅನ್ನು ತೆಗೆದುಹಾಕಿದ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಒದಗಿಸುವಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 2ರ ಈ ಕಾರ್ಯಾಲಯ ಪತ್ರದ ಮೂಲಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರಿಂದ ಅಭಿಪ್ರಾಯ ವರದಿ ಕೇಳಲಾಗಿತ್ತು. ಸದರಿಯವರು ಈ ಕೆಳಗಿನಂತೆ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ವಿಷಯದಲ್ಲಿ ಸಂಬಂಧಿಸಿದಂತೆ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ಗಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಇವರ ಕುರಿತು ಕಚೇರಿ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ನೇಮಕಾತಿ ರದ್ದುಪಡಿಸಿರುವ ಕುರಿತು ಯಾವುದೇ ನೋಟಿಸ್ ಮುಟ್ಟಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ವರದಿಯನ್ನು ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಹಾಗೂ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಮಾಡಿದ ವಿಚಾರಣೆ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ತಾಲೂಕ್ ಪಂಚಾಯತಿ ಕಲಬುರಗಿಯವರ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ಗಿಯವರನ್ನು ನಿಯಮ ಬಾಹಿರವಾಗಿ ತೆಗೆದುಹಾಕಿ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದಾರ್ ಇವರನ್ನು ನೇಮಕ ಮಾಡಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಹಾಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದಾರವರನ್ನು ತೆಗೆದುಹಾಕಿ ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ಗಿಯವರನ್ನು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ನೇಮಕ ಮಾಡಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಕೊಳ್ಳಲು ಆದೇಶ ಮಾಡಲಾಗಿದೆ. This is
Who
So the
appears for the panchayat?
My lord, I appear for the.
So what is the position now?
My lord, position as on today,
No, not as on today.
please.
Now, this Rajkumar was working or no?
He was working, my lord, but he himself had left the job, my lord.
Huh.
And based on that, a resolution was passed by the panchayat, my lord, at page number annexure, my lord, page
annexure A,
16.
page 28.
Page
16,
16.
sorry, my lord, annexure A,
28 minutes,
30
page number 28, annexure A.
33 is the typed copy.
33.
3,
This is the resolution. of the
resolution, my lord.
By
ಈ
virtue
ಗ್ರಾಮ
of-
ಪಂಚಾಯತಿಯಲ್ಲಿ
Page number 33.
ಟೈಪ್ ಕಾಪಿ.
ಹ್ಮ್.
ಈ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀ ರಾಜಶೇಖರ್ ತಂದೆ ಬಸವರಾಜ್ ಕೆಲಸ ಬಿಟ್ಟಿರುವುದರಿಂದ ನಮ್ಮ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಎಲ್ಲಾ ಯೋಜನೆಯ ಗಣಕೃತಿ ಕೆಲಸಗಳನ್ನು ಕುಂಠಿತಗೊಂಡಿರುವುದರಿಂದ ಸರ್ಕಾರದ ಕೆಲಸವು ಕುಂಠಿತಗೊಂಡಿರುವುದರಿಂದ PDO ರವರು ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಲಾಯಿತು. ಶ್ರೀ ರಾಜಶೇಖರ್ ತಂದೆ ಬಸವರಾಜ್ ಅವರು ಕೆಲಸ ಬಿಟ್ಟು ನಂತರ ಶ್ರೀ ಶರಣಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದರ್ 5/5/2011 ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. ಅದರಿಂದ ಇವರು ನಾಗೂರ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಗಣಕಯಂತ್ರ ನಿರ್ವಾಹಕರೆಂದು ಸೇವೆ
ನೇಮಿಸಲಾಯಿತು.
As per the resolution, my lord.
13/11/2013.
Yes,
Yes.
ma'am. Yes, ma'am.
And there was a no
Both
publication.
are contractual employees only.
So 13/11/2013.
Yes, ma'am.
Now he made representation in which year?
Lord, in the year
19.
After 6 years.
2014, my lord.
Huh?
2014, as per page 41.
Huh.
The prayer column, the petition is filed under Article 236 of Constitution of India, praying to issue a writ of mandamus or any other order in the like nature, directing the second respondent to consider the application given by petitioner on.
2017.
ಇಲ್ಲ, ಇದರ
9/10/2017.
38/2014.
30th August
38/2014, as per annexure H, and permit the petitioner to continue to work as a computer operator as he was working earlier and
And
received
that writ was filed
in the year 2015, my lord.
2015. and disposed of in November 2016.
Please.
Yes, ma'am.
And this Chief Executive Officer
Just
Jilla
passed the order
Panchayat,
on,
19.
2019.
8/7/2019.
Now, before the Chief Executive Officer, you didn't defend properly.
My lord.
Before the Chief Executive Officer,
My lord,
Jilla Panchayat, in the proceedings at Annexure D, you didn't place this record of him having abandoned. Isn't it?
it is not there. my
Or
lord.
the resolution of
Yeah.
the Panchayat was not placed.
Not placed, ma'am.
Huh?
Not placed.
Huh.
The CEO had sought information from the executive officer, my lord. Based upon that order, CEO has passed an order.
Correct.
Yes.
This resolution was not brought to his notice.
Not,
Huh?
Because I was
the
not
order
the
it is
party.
not brought to the.
Before the termination, I should also have been made participate in the proceedings. If a notice should have been given to me, because as I was already working there, I could have produced the resolution.
Hmm. Okay, so now is there one more place you take him? There ends the matter.
My lord,
Huh.
what is,
If
we
there
have
are two
to,
posts, you take both of them.
there is only one post, my lord.
Hmm.
Whatever is there, we have to issue through paper publication, and then only, even in respect of appointment of,
Publication to
appointment
paper
of petitioner,
Hmm.
we had issued paper
Paper
publication.
publication was issued.
Paper publication is issued, and based upon that, he has been appointed. my lord.
Correct.
Now also, if any appointments have to be done, it has to be done only through, by way of paper publication based upon caste, etc. and all. my
No,
lord.
no. Now, we are not directing appointment.
Please,
He's already working,
yes,
isn't it?
yes.
Now, by virtue of Annexure D, the fourth respondent in the writ proceedings, fifth respondent, was directed to be reinstated.
Yes. Fifth respondent is not working from the year 2010, my lord, up to 2025, from 2010. 10. Based as he had left the job himself, a resolution was passed to appoint a new one by by issuing a paper publication. my lord.
This Annexure D, you also should have challenged.
My lord, Annexure D, I am the part of Jilla Panchayat, PDO. He can't, he's a part of, his hierarchy wise is the PDO, upon PDO, executive officer above CEO.
Okay, now how do you solve this problem? No?
I'll just verify, my lord, what's the,
Huh?
because both are contractual employees, they can be removed at any time. There is no, it is not a permanent post, my lord. It is not a permanent post.
So then now you decide what is to be done.
I'll take instructions, my lord.
Now you appear,
For fifth respondent,
Respond.
fifth respondent, madam.
Rajkumar or
Raj-
Rajshekhar?
Please, madam.
Huh?
Rajkumar.
Rajkumar.
Not Rajshekhar.
Rajkumar, Raj.
Huh? No, no. The resolution says Rajshekhar. That's why I'm confused.
It's Rajkumar, my lord.
Huh?
It's Rajkumar actually.
Rajkumar.
It is, I think it is typographical mistake, my lord.
ಅಲ್ಲ, ಎರಡ್ ಮೂರ್ ಕಡೆ ರಾಜಶೇಖರ್ ಅಂತ. That's why I just checked.
No, it is, as per, it is Rajkumar in the type copy, there is a mistake. They have made. Type copy, they have made a mistake.
No, correct. So how do you solve it?
I'll just sit with the CEO once.
Case, according to you, if only one person can work.
Please.
Now, without us adjudicating, because it's badly conducted litigation.
Yes.
Annexure D is your fault.
Yes.
You have not appeared to have briefed. So you take a decision who you want,
Please.
depending on who has worked. You are aware of it.
Please.
And then you choose one of them and take appropriate decision who you have to leave
Leave and who have to.
in a proper manner.
Please, my
Let
lord.
that not be against stigma.
No, that's right. We will issue notice to both of them, seek instruction,
Inquiry.
take the assistance of PDO and the members.
Since
And
it's
then we'll pass.
contractual,
Yes,
you take a decision
Please,
in
madam.
accordance with law
please,
and you report.
please.
Mine is temporary, not contractual. His was contractual.
I was appointed, my lord.
Huh?
I was appointed, my lord, through conducting examination and due process of both, my lord.
No, but they're saying you went to Kumbh Mela
Really? Because of
by,
that, with
by walk.
Yes.
You came back by then. You appointed
Mahakumbh came.
somebody else. Relist on. week after next, you try to solve it.
Please, my lord.
It doesn't require adjudication by us.
Please.
Now who's working?
Now,
Myself, the appellant here is
appellant is working.
Admitted.
Appellant is only working
working.
from
You
2000
take a decision. Huh?
2011,
Correct. So you take a decision.
from 2013, appellant itself is, appellant himself is working.
Grateful.
It may be taken up on 28th or 29th, my lord.
Yes. 29.
Please.
Grateful.
Yes.
30. Vikram Basavaraj body.
Divorce decree by the husband, respondent husband. As on the date filing of the
Expertise.
expertise, the respondent husband furnished the false address before the family court. And on the count that the petitioner, who is respondent before the family court, she refused the notice. I have produced the additional documents, my lords. And as on the date of pending of the
mediation,
mediation, it is failed.
So now the address shown in the plaint, take us to the plaint.
As on date of filing of MC, pending of MC, the the appellant was not residing at her native place. Both the husband and wife belongs to same village. And due to pandemic COVID, she has shifted to Bhalki, where she has filed the, initiated the domestic violence proceedings before the JMFC Bhalki. I have produced the document, additional document. And it is well within the knowledge of the respondent.
No, but before that, just notice was issued to which address?
That native place, Kamlapur.
Take us to the cause title of the cause title. Page 33 is the cause title, family court, isn't it?
Yes. Input judgment is at Annexer.
So it's shown as
Ashok Nagar Block 2 near
Kalaburagi.
Kamlapur Taluka District, Kalaburagi.
Isn't it?
Yes.
Page 33, Kamlapura.
Yes.
It's shown as Kamlapur.
Kamlapur.
This is the address shown.
Shown by the respondent husband.
Yes. Now it was not served.
It was it was refused. The endorsement before the
family
court. It is.
But you are saying that you are not residing.
I have produced the additional document. I have initiated the domestic violence proceedings before the JMFC at Bhalki. The respondent husband tendered his appearance, contested the case.
No, just 1 minute. Now this family court proceeding was initiated on 23/1/2020.
Yes. Yes.
So 23/1/2020, you are already staying at Bhalki.
No. Thereafter, in the month of March, there was pandemic COVID. I have shifted my residence from Kamlapur to Bhalki.
Notice was issued on which date as per the order sheet?
First notice was, I have produced the entire order sheet. Additional document, ink page 34. Additional document.
Yes.
Ink page 34.
Yes.
There was pandemic, there was no proceedings. Ink page 35, 36, 37, there was no 37. On 18/11/2020, advocate petitioner present, issue notice to respondent through RPA.
Notice is issued on?
First time issued on 18/11/2020 itself.
Page?
Page 37.
37.
Yes.
18/11/2020. Correct.
It was not served. On next date, steps for finally. and kindly peruse the relevant page, my lords, 42, ink page 42, additional doc, 42, 12/4/2022. Advocate petitioner present and submit that respondent has left the house. Therefore, some times are required for find out the address of the respondent, trace time for steps.
So that is
Admittedly, it is
admitted.
within knowledge of the respondent herein, who is petitioner, that the respondent wife has left her native place. Thereafter, once again, the counsel for the petitioner submit to issue notice by RPD to respondent, and he will furnish correct address, RPD and PF in the office.
So only point is this.
Yes.
TCR has bandidya. TCR. We'll get the TCR and close it. If in the process will be shown to which notice went first time,
Please,
they would have given process.
remand matter. My prayer is to remand the matter. There may be an opportunity to the petitioner to contest the case before the. Admittedly, if it is within the knowledge of the respondent that the petitioner is not residing at her native place. And thereafter, my lords, once again, on 28/9/2022, ink page 43.
No, do one thing. We may not ask for TCR. Can you get that certified copy of that RPAD furnished on 28/9/22?
Please.
That will be to the same address if it shows. That would be sufficient.
Please. Even in the absence of my lords, I have initiated the domestic violence proceedings before the Bhalki, where the respondent appear, and there was an interim order.
Without going to that, on 22/11/22, RPAD refused it.
Refusal.
Isn't it? If the address shown is the same in the cost title, that is sufficient for us to say
Please.
that in light of his statement that she has left the house, it could not have been issued to the same address.
Same.
You get certified copies.
To that effect, the advocate for petitioner there, at least he must have submit, I have furnished the correct address, issued RPD.
No, so just get certified copy of
Please,
that
please,
process fee paid by him, etc.
please.
Where is this court? Which court?
Family court Gulbarga, family court Kalaburagi,
Family court?
family court Kalaburagi,
Then we'll get it.
please.
TCR to be summoned through telephonic communication. List the matter on Wednesday,
Please, oblige.
22nd. That's all. We'll see those two and we'll.
Oblige.
Now, he is married or remarried?
When she went to lodge a complaint, then only she came to know that he is going to marry. On that day only, I came to know that there was passing of divorce, ex parte divorce. Otherwise, I have not having
No,
knowledge.
married or not yet?
He is married. Right
Children?
now, no, she is not married.
No, he.
He married. He
Children,
married. On the count of
children.
no children.
Okay, let us see. Stay there, right?
Still,
Stay there. What is she?
I heard the rumors that he is going to get another marriage. Then only I went to police station to lodge a complaint, where he produced that copy of the divorce. Then only the wife came to know that there was passing of. I for condonation delay, it is allowed.
I stay.
Still, he is already married. For that reason, I have not.
Hello, Maklagbardu.
Will.
You should file.
Please.
So he's married even before the.
No, after passing of divorce, he got married.
Before the appeal.
Madam?
Before you file the appeal, he's married.
Yes, before filing.
May I make one? May I make one submit? Serial number 51. I entered my lord appearance recently. I have also instructions to file my lord order 41 rule 27 application. Additional evidence. I request my lord, 2 weeks accommodation. 51.
Fresh matter, is it?
No, not, yes, fresh. Lordship,
Relist on date.
2 weeks. 51. Final hearing.
List, date code.
Please, great.
Share ಬಗ್ಗೆ ಅಂತ ಹೇಳಿ. ಆಯ್ತು. Astormet 40, Shivashankar Manu. Till number 50,
This writ petition is not, the 14 writ petition is not maintainable, my lord. The president Gram Panchayat filed the writ petition, filed the writ appeal.
ಇನ್ನೊಂದು ಏನೋ ಫೈಲ್ ಮಾಡಿದಾರಂತ.
ಅವ್ರು ಮತ್ತೊಂದು ಹಾಕಿದಾರೆ, ಅದು ಬಂದಿದೆ. ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Again, the liberty was reserved by the learned single judge to move the, once again, my lord, for no confidence motion. Accordingly, they might have moved the, and this notice was issued fixing the date for no confidence motion. ಇದು ಇಲ್ಲಿ ಬರಲ್ಲ, ಅದು ರಿಟ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ. Issuing of the notice direct before the division bench.
ಬರ್ಲಿ.
Please.
number 50.
15 Mala.
Nagauda.
I am appearing for appellant. There is a delay of 1600 days in recalling Mala. Matter as dismissed for default regarding non-compliance of office objection.
ಇವಾಗ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, ಪರ್ಮಿಷನ್ ಕೊಟ್ಟು ರೀಕಾಲ್ ಆಗುತ್ತೆ. ಸಣ್ಣ ಸ್ಮಾಲ್ ಕರೆಕ್ಷನ್. ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಪೀಲ್ ಮಾಡಿ.
Once for all dispose ಮಾಡ್ಬೋದು ಅಲ್ವಾ?
I am ready, my lord.
ಎಲ್ಲಿದ್ದಾರೆ ಅಸ್ಪಲ್ಲಿ?
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
ಏನು ಸಿರಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಒಂದು,
pending disposal of IA 1 of 21. The appellant is permitted to comply with the office objections. Relist on date could next week could. Oh, 22nd.
22nd.
Please.
22nd ಮುಗಿಸ್ಬಿಡೋಣ.
Please.
Number 39. Santosh Kumar Pirada.
SPP.
Astor matrix. Number 40.
I'm sorry, my lord, just now ಹೀಗೆ ಕೊಟ್ಟರು ಪೇಪರ್ ನೋಡಿದೆ, ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಏನಿದೆ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ 230.
This is, my lord, this made is out, madam. 14.
14.
It will be taken along with, today I have moved the matter.
ಬಂದಿದೆ.
ಬಂದಿದೆ, sir.
ಹೌದು, ಬಂದಿದೆ.
Yes, that may be taken first.
ಕೊಡಿ.
ಅದ್ರದ್ದು connected ಇದೆ, my lord. ಇದರಲ್ಲಿ only earlier judgment na challenge.
What have you challenged?
I have challenged the annexure F, my lord.
Annexure?
Annexure F, my lord. Page number 61, my lord.
Eighteen one is the date fixed.
18, yes, my lord.
Now, this you challenge before the single judge.
Please, my lord.
This notice you challenge
Yes,
before
my
the
lord.
single.
This notice is pursuant to the annexure E, my lord. Annexure E is the representation made by the members, my lord.
On what ground you challenge before the single judge?
My first point is, my lord,
So what is the order of
both
the
these, please.
Let us have a look at the order of the single judge.
Yes, my lord. My lord, yesterday it was dismissed, my lord.
Ah.
The court did not consider the point, my lord.
Hello, where is the order? Order is not there.
Illa, not released, my lord.
We'll have it tomorrow.
Directly.
We'll have it
dismissed.
tomorrow, let us see. We'll have it tomorrow, let us see. We'll have it tomorrow, government, you'd get instruction.
My lord, here, my lord, I submit, my lord, within 5 minutes.
Tomorrow, my lord.
Earlier, my lord, the serial number 14 writ appeal.
14 and dismissed
ಇಲ್ಲ
together.
ನಾ
will be
ಹೇಳ್ತೀನಿ
taken.
ಒಂದ್ ನಿಮಿಷ ತಡ್ರಿ ಹೇಳ್ತೀನಿ ಏನಾಗಲ್ಲ ಏನ್ ಇರೋದನ್ನೇ ಹೇಳ್ತೀನಿ
ಅಲ್ಲ, ನಮ್ ಕೇಸ್ ನಾವು ಫಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು. sir,
ಇರ್ಲಿ
please.
ಪರವಾಗಿಲ್ಲ ಹೇಳ್ತೀನಿ
ಇಲ್ಲ, dispute
serial
ಮಾಡ್-
my lord writ appeal this writ appeal is filed challenging some portion of the operative portion of the single judge order, that is number 4 and number 5, wherein the liberty
This
was
is not-
reserved.
ಅಲ್ಲ,
ಒಂದ್
wait,
ನಿಮಿಷ
sir,
ತಡ್ರಿ.
serial number 14.
One
ತಡೀರಿ,
minute,
ಯಾವಾಗಾದ್ರೂ ಹೇಳಿದೆ
ಅಲ್ಲಿ
I thought my colleague submitting with regard to serial number 14.
Yes,
Not this case.
that is important. That is important.
ನೋಡೋಣ.
Serial number 14 ಅಲ್ಲಿ operative portion of the learned single judge order, wherein that operative portion, para number 4 and 5, the liberty was reserved for, wherein that writ petition was, my lord, dismissed, and liberty was reserved to move, because technically that earlier application by the Gram Panchayat members for no confidence motion was signed by the PDO. PDO has no business. Therefore, that was quashed, my lord, and liberty was reserved. After reserving the liberty, one more representation was submitted, and on that basis, this input notification, if yesterday and dismissed agide, that notice was issued, and that writ petition is dismissed. This writ appeal is filed. Very simple, my lord. Here the president, the petitioner is the president. The president cannot file the, my lord, writ petition challenge the no confidence motion. The president, ಅವ್ರ ವಿರುದ್ಧನೇ no confidence ಇರುತ್ತೆ. There is a judgment, division bench judgment.
Now, on what grounds the single judge
Sir,
dismissed?
my lord, in this case, Kevet also filed, my lord, yesterday. I served the copy. My learned colleague Ganesh Kalaburagi appeared for the respondent number 7. He may permit to take notice for the respondent number 7. I served the copy of this petition, writ appeal, my lord. And it may be taken tomorrow at first instant, my lord, ready to argue the matter.
Your lordships, the contention which were raised by them before the learned single judge, your lordships, was with regard to the presence of 2 members at the time of submitting the no confidence motion, as required under Rule 3, your lordships. It is covered by judgment, your lordships, wherein if AC proceeds with the no confidence motion representation and notice is issued to the members, it is deemed that, your lordships, the necessary compliance mentioned under Rule 3 has been complied. It is their contention, your lordships.
That they were not.
2 members were not there at the time of submitting no confidence motion.
We'll have it tomorrow. let us-
Yes, yes.
Please.
Meanwhile, you get whatever telephonically, you find out what instructions
Please.
from the
They
concern.
may call for the report. my lord.
I request my colleague, my lord, Basrede, due to my personal inconvenience, ನಾಳೆ ಅವ್ರಿಗೆ ಹೇಳಿರ್ತೀನಿ.
ಆಯ್ತು. Now you appear for, you accept notice for? In serial
ಗ್ರಾಮ
number,
ಪಂಚಾಯತ್ members.
in serial number? 2000012.
Respond number 7, your lordships.
2000012.
Here, your lordships, case number has not been mentioned.
Sevanti versus state.
Yes, both are same, your lordships. The serial number 14.
Both same,
Cost title is same.
parties are all same.
Hello, now ಇವಾಗ 2000012 ಅಲ್ಲಿ you will accept notice for?
Respond number 7, your lordships.
ಹೆಸರು ಹೇಳ್ರಲ್ಲ.
Ashok. Ashok, son of Shivappa.
Only for that person?
Yes, yes.
Learned counsel so and so accepts notice for respondent number 7, AGA accepts notice for respondents 1, 2, 3.
Please.
He list tomorrow.
My lord,
Meanwhile, you can serve on the,
7 appears. Ashok appear idu.
meanwhile, you can serve on who appeared in the writ proceedings, you can
I
serve.
served already. It may be taken on record. me. Copy also served. my lord.
Now in this one, 2000011,
ಅದರಲ್ಲಿ ಇಲ್ಲ, my lord, ಯಾರು ಇಲ್ಲ. ಅದು directly filed. No
AGA
limited
accepts
scope is there. my lord.
notice
I
for
solve it.
respondents 1, 2, 3.
Yes.
Same. So and so undertakes to appear for R7.
Please.
That
Relist,
copy may be served your lordship.
ಅದು
relist
ಕೊಡ್ತೀನಿ
tomorrow.
ಅದನ್ನ. ಈಗ ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಮಿಲೋಡ್ ಪ್ರೆಸೆಂಟ್ ಅದನ್ನು ಕೊಡ್ತೀನಿ ಹೀಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ ನೋಡಿ. It may be taken, my lord, it may be recorded as served me
Both may be taken up together, your lordship, tomorrow.
tomorrow, together.
Seal number WP 2000112 of 2025 to be called along with seal number 14.
Please.
Yes.
Number 39.
Yes.
In all the prosecution of examined PW 1 to PW 14 in support of the case, and exhibits have been marked exhibit P1 to exhibit P45 mellows and MOs 1 to MOs 20. And also in exhibited documents marked for the defense are exhibit D1 to exhibit D16 mellows. Mellows, the PW1 Tamanna, who is a son of the both deceased. The complainant is a hearsay witness. Then also while arguing other side, my lords have opened that he's a res gestia witness. And PW2 Dhundaya, he is a puncher to inquest, spot, seizure of motorcycle, Mahindra Jeep, and bloodstained mud without bloodstained mud. And PW3 Ramappa, puncher to the deceased cloth mellers, seizure of cloths of deceased, that is MO 13456 that belongs to Basappa. MO 789 belongs to Rangava. And PW4 Srishail Kanbur, he is a puncher to seizure of cruiser vehicle bearing number K28 and 1758, that is exhibit P13 melons. And motorcycle, lead ball, stick, iron rod, that is exhibit P15. And conspiracy place where the all accused have made a conspiracy for making this particular crime melons. And PW5 Narayan, who is a eyewitness to the incident, and he happens to be the distant relative of the deceased as well as PW1 and also accused, because accused and deceased happens to be the relatives. And PW6 Kalmesh, the important witness, Millers, he is an injured eyewitness and he fully supported the case of the prosecution. Of course, Millers, PW41 to PW14, all have supported the case of the prosecution. But mainly this witness evidence is main evidentiary value for this particular case. And PW7 Mallesi, he is a younger brother of the deceased Basappa. And he is also hearsay witness and he has supported the case of the prosecution. And PW8 Rangan Gowda, he speaks about, he is a villager, my lords, that Gunadal village, he speaks about the compromise which has been made in the police station on 8/8/2013, wherein the deceased Basappa went to the Bableshwar police station for lodging the complaint against the accused for life threat purpose, what they have given a life threat. To that effect, my lords, police and these all persons, including this PW8 and other inmates of the villages, have compromised, and the matter has been pacified there itself, and not to quarrel with each other. And PW9, Dr. Shankarling Galgali, who was a medical officer at Galgali, and who treated the PW6, Kalmesh Mills. And after X-ray report, he has given the wound certificate to that. And PW10, Dr. Ramesh Patil, who has conducted postmortem report, postmortem examination, and has given the cause of death certificate. And PW11, Vishnu, who took a photo, is a head constable also. And PW12 is important. He is an investigating agency officer. PW13, Subhash, he is a assistant engineer who prepared the sketch. And PW14, Ramesh Chayagod, PSI, who registered the case, and also he arrested all the accused. Accused number 1 to 5 and produced before the PW12. Admittedly, my lords, the
Listed accused on 16-1, na?
17-1.
17-1.
Yes.
Yes.
17-1, 2014. My lords, as the other side has argued in detailedly, my lords have directed me to come to the
Yes,
points.
yes.
That's all. My lords, the death is a homicidal, that's admitted. And second one, motive has been proved, my lords. And as per the witness of the PW6 and
Disputed the homicidal death also. According to them, it's an accidental.
no, my lords, that is there, my lords. But that is there. But as per the PW6 and 5 and 6, doctor's opinion, doctor who has given his opinion in exhibit P22, cause of death, that I'll come to that point, my lords. And motive is a land dispute, my lords. The other side have argued that accused number 1, 2, 3 or 4 and 5, they are not at all the litigants in the petition. My lord, the Hanumant Kumatgi is the father of accused number 1, 2, 3, who married second wife. Due to wedlock of Hanumant Kumatgi and the accused number 1, 2, 3's mother, the 4 sons have been born. So to that effect, my lord, since 1997, there was a dispute pertaining to 9 acres of land, which was given by the deceased Rangava's mother. So after death of the Rangava's mother, it's Nagava, this person, the second wife, is the mother of all the accused, the accused number 1, 2, 3. They started quarreling. To that effect, there was a quarrel between them. But the accused number 1, 2, 3, of course, they are not before the court in civil court or in RSA court, but Hanumant Kumatgi is the litigant. He filed a suit against them.
Their father.
Yes, my lords. Hanumant Kumatgi, who died in 2007. Of course, the matter has been summed up in 2006. 2007, he died. So the motive on the looking to the facts and circumstances and the papers which have been produced along with charge sheet, that clearly shows that, my lords, there is a motive pertains to land. Other side has argued that, my lords, the matter has been summed up in 2006, but now 2014, would it be possible to occur? So what is the explanation about 8/8/2013, wherein the deceased Basappa and Rangava went to the police station for lodging the complaint due to their life threat by the accused number 1, 2, 3. Even after the judgment of the Honorable High Court in RSA number so and so.
Whether this complaint is marked?
No, Xerox copy that has been given. That has not been marked. But that has come in
Before 3 months, before 4 months.
before 4 months.
4 months.
4 months. Yes, definitely. 8/8/2014, my lords, incident 7-1.
Yes.
The 4. And even Iowa has adduced in his evidence. And also PW7 has adduced, PW8 has adduced. That was a Xerox copy of complaint. That's what it couldn't be marked. Then, and thereafter, my lords, the homicidal death and motive and act done as the witness of PW5 and 6 that has been shown. These 3 points are important to attract section 300. Those all have fulfilled. Coming to the PW1, evidence, my lords.
Is the hearsay may not be.
He has said, my lords, what other side have argued that, my lords? There was a outpost station is there in Galgali. And while going to the hospital, what was prevented him for lodging the complaint at Bableshwar or else in Vijaypur? My lords, his parents have died. And that injured, Kalmesh was injured severely. He was taken to the hospital. What is the delay? 4 hours delay, 5 hours delay is a delay, my lords. Incident is said to have occurred at about 4 to 4:30 p.m. Complaint has been lodged at 10:30. On the same day itself. If the complaint has been lodged in next day or very next day, the thing would have been different. It is a prepared and this thing. That is there. What their argument, I'm giving the answer, that's all.
Yes, yes.
And also, the PW5, which is a so-called eyewitness to the incident, what they have argued that even he didn't try to give a complaint or else he didn't try to give advantage to the PW6, he would have called somebody else. Already in his evidence, he has adduced that he did not have mobile on that particular day. There was only one tractor driver. A cabin, the factory salvagi cabin lari barutte hogutte sir. Yaru involve aglike our number illa, avanu cite madila witness andre. Nobody would like to involve in the crime smellers, even for evidence as a witness also. But that doesn't mean that the investigating agency did not try to get him. Our number enitu, even the taking the tractor driver's mobile, the PW6 has called to PW1. And even he has told the number in by heart. And also he specifically stated that my lord's identification of the A1 to A5. He has seen all the accused in Satagundi village in functions in several times.
When PW5 is present there in the spot.
Yes, my lord.
And what prevented him to either to lodge a complaint or at least to inform PW1?
Yes.
When PW6 is injured boy,
yes,
was lying there.
Yes.
Then why PW6 has to call PW1?
Yes. PW5 happens to be the close relative of the both, accused as well as deceased. If he involved, due to his life threat, if he involved that the accused could have assaulted for thinking that he stood some 150, 200 meters away from where the incident is said to have occurred. But if he tried to complain in this thing, my lords, they may finish him. That is one of the reasons, my lords. Because of that, ಅವ್ರದವರೇ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ PW6 ಮಾಡಿಸಿರ್ಬೋದು sir. That is there. Nobody in village, my lords, nobody wants to involve in terms of what I have submitted. Because of this reason, my lords. Even then, my lords, after the incident, when PW6 was taken by one Sri Shaila and PW1 and PW7 to the hospital by that time, PW5 went to his house, but he did not disclose it. That point also other side raised. This shows that, my lords, he did not want to involve in this crime because he happens to be the close relative of deceased as well accused. This might be one of the reasons. And in PW6, the categorical emails he adduced in his evidence. A 8 years old boy cannot say the allegations and assault in which accused is having in which weapon and all those things. 8 years boy is a very important, my lords. He's
Tell us
studying,
one thing,
my
now
lords.
PW, why at least PW 6-5 could have informed this aspect to PW 1 after the incident,
He went
before
to his,
lodging complaint.
he went to his village, my lords. Even
How you can? He is a close relative.
close relative as well deceased and accused, I'm submitting, my lords.
Hmm,
Because he did not want to involve in that particular incident all.
hmm.
Even he did not disclose to his wife and his family members also pertaining to this incident. This shows the innocence of that particular witness, my lords.
Hmm.
Otherwise, you would have gone and lodged the complaint. The outpost is very near to that, in the evidence it has come, rather. This is the thing, my lords. And PW 7, of course,
Appearing in the scene of occurrence on that day, he suddenly appears and thereafter disappears till next day.
that is the main hurdle in villages, my lords. They do not want to involve in any crime, others' crime, in fact. ಇನ್ನು ಮತ್ತೆಲ್ಲಿ ನನ್ನ ಮ್ಯಾಗ ಬಂದ್ಬಿತ್ತಪ್ಪ ಇವ್ರು ಇವರಿಗೆ ಹೊಡೆದು ಹೋಗಿದ್ದಾರೆ ಮತ್ತೆ ನನಗೆ ಹೊಡೆದ್ರಂದ್ರೆ ಹೆಂಗ? These are all fear. This is due to fear, my lord. Their life threat. And my fair submission would be, the puja has not been arrayed as a charge sheet witness, or neither she has not been arrayed a charge sheet witness nor expert. That is, of course, one thing is the fatal to the investigation. That is even then, my lords, even then, PW 6 evidence and PW 5 evidence can't be discussed, along with PW 7. And
what do you say?
my lords,
It is their assertion that PW 6 is tutored. How could you have identified all these people? That's their argument.
yes. Shall I come to his evidence? In page number, my lords, 221. From 2, no, it's 214 to 223 minutes, page number. The 12th line. ನನಗೆ ಕರೆಯಲು ವಿಜಯಪುರದ ಸರ್ಕಾರಿ ದವಾಖಾನೆಗೆ ಪೊಲೀಸರು ಎಷ್ಟು ಗಂಟೆಗೆ ಬಂದಿದ್ದರು ಎಂದರೆ ನನಗೆ ಇಲ್ಲ. ಇಂದಿನಿಂದ 3 ವರ್ಷಗಳಿಂದ ಆರೋಪಿಗಳು ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಬರುವಾಗ ನೋಡಿದ್ದೇನೆ. ಆದರೆ ಅವು ಎಂಥ ಕಾರ್ಯಕ್ರಮ ಎಂದು ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಸತುಗೊಂಡಿಯಲ್ಲಿ ಇದ್ದ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಆರೋಪಿಗಳನ್ನು ನೋಡಿದ್ದೇನೆ. ಆರೋಪಿತರಿಗೆ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನೋಡಿದ್ದೇನೆ ಎಂದು ಹೇಳುವಂತೆ ನನಗೆ ಕಲಿಸಿಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ನಿಜವಲ್ಲ. Absolutely he denied. Of course, suggestion has been made by the defense, but it has been denied by us. Sir. And even they, in the cross-examination, they wanted to change the vehicle, my lords, the same 223 page number. That after that, my lords, ನಿಜವಲ್ಲ ಮುದ್ದೆಮಾಲು 10 ಮುಂದುಗಡೆ ಜಖಂ ಆಗಿಲ್ಲ ಎಂದರೆ ಮುದ್ದೆಮಾಲು 19 ಎಡಬದಿಯ ಬಂಪರ್ ಬೆಂಡ್ ಆಗಿದೆ ಎಂದರೆ ಈಗ ಬೆಂಡ್ ಆಗಿದೆ. MO19 is a Jeep Mahindra where after the incident it was driven by accused number 2 and stood over there. That is there, my lords. And the my lords have
Yes.
my lords.
How many injuries he has sustained? This PW6 boy?
Boy sustained 3 injuries, it seems. Exhibit P20, my lords.
Page just
The 6 injuries, 6
injuries.
6 injuries.
Page 98.
Page 98.
98, huh?
Yes, laceration over right side of forehead, laceration over forehead, swelling over right side of forehead, laceration over right little toe and fourth toe. Laceration over right side of nose, laceration over root of nose. Of course, they are all simple in nature. And on the and even my lords, this Kalmesh on page number 98 itself, a history of this injury is road traffic accident. Of course, it's a true fact. There is no line that accidental death. And thereafter they have assault. That is different to the deceased, not this particular boy. He sustained injuries on the accident itself. And PW7, even his hearsay, he has categorically stated before the trial court, and trial court has.
See, in a case based on evidence of the direct eyewitness,
Sir.
you will not play much vital role, even otherwise. Even otherwise. It's a subtle law. So, as far as the motive is concerned, if the evidence of PW 5 and 6 is what to believe, then motive may not play vital role. So now you have to show the evidence of PW6 is believable in nature.
Definitely.
PW6.
Yes. He hasn't given a single admission in the cross-examination. If you go through entire cross-examination, some discrepancies there, my lords, I do agree. But in 90% of in his cross-examination, defense has not elicited anything to help them.
He was 8 years boy at that time.
Boy, yes.
So
Now at the time of giving evidence, he was 11, my lords.
After 3 years,
yes, ma'am.
He remembered everything and he deposed such a manner.
My lords, the brutal murder have occurred before in his eyes. Nobody can forget such a things, my lords. That to his lovely grandfather and grandmother, wherein he was studying in their house itself after taking his birth, as he has stated in his evidence. And he was studying in 2nd standard at Vivekananda School at Gunada. then they both are like a parents. Of course, his birth has been given somebody else, his own mother and father, but he born and brought up with the deceased, both deceased. That's why, my lords, this has to be taken into consideration. A brutal murder of 2 lives.
Pooja is elder to this boy.
Yes. Pooja is elder, 13 years old at the time, my lords.
At that time.
She is a deceased son's daughter.
Of course, she was there very much
Yes.
present.
My fair submission, I have submitted before.
And moreover, she has not sustained any injuries.
The small injury, she had not been taken to the hospital. She was taken, but that has not come in any certificate or else in the cross-examination of the defense. That is there.
What is the reason not examining
That
of
I
Pooja or
Fail to understand, my lord. Pooja and the person Srishal.
Srishal?
Yes, he was also along with the PW 1 and 7.
Witness to the incident, that Srishal.
I know.
Otherwise, he who shifted the injured,
Yes.
this boy,
Yes.
so he must be there in the spot or?
No. Thereafter, he came over there. Along with PW 7, he came over.
So Srishal accompanied PW 5, alva?
No.
Srishal,
Srishal accompanied PW 7, my lord.
that boy.
Yes. Accompanied PW 6. PW 6 ಆಯ್ತು ಸರ್ ಅಲ್ಲಿ ಸ್ಪಾಟಿಗೆ ಬಂದಾಗ he came to the spot along with PW 7.
6 ಅನ್ನು ತಾಸ್ಪತ್ರೆಗೆ ಕರ್ಕೊಂಡು ಹೋದ್ ಯಾರು?
Srishal, PW 1 and PW 7.
Not cited in charge sheet.
So Srishal must be there in the spot, alva?
Yes.
Or else he must be an eyewitness.
Yes. Not eyewitness.
He is
Must
not.
be an eyewitness, or at least he must be in the spot.
Yes. That is there.
Otherwise, how he will accompany this
Definitely. These
boy?
are 2 lacunas to the investigation. I fairly admit, my lords. One is Pooja has not been as in charge sheet witness, nor she has examined. And secondly, Srishal. Another Srishal is there. He is the pancha to the.
Now, who shifted the dead body at least from the place?
My lords, as per the PW 1, the evidence in page number 177. In first para. ನಿಶಾನೆ P1 ಫಿರ್ಯಾದಿ ಕೊಟ್ಟ ನಂತರ ರಾತ್ರಿ ಸುಮಾರು 11 ಗಂಟೆ ವೇಳೆಗೆ ನಾನು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಹೋದೆನು. ರಾತ್ರಿ ಪೂರ್ತಿ ನಾನು ಘಟನಾ ಸ್ಥಳದ ಮೇಲೆ ಇದ್ದೆನು. ನಾನು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಈ ರೀತಿಯಾದ ಪೊಲೀಸರು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದರು. ಆ ವೇಳೆಗೆ ಕಲ್ಮೇಶ್ ವಿಜಯಪುರದಲ್ಲಿ ಇದ್ದ ನಾರಾಯಣಪ್ಪ ಫಕೀರಪ್ಪಗಳು ನಮ್ಮ ಸಂಬಂಧಿಕರು ಅಲ್ಲ. ನಾನು ರಾತ್ರಿ ನಾರಾಯಣಪ್ಪ ಫಕೀರಪ್ಪಗಳು ಕರ್ನಾಟಕ ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದಿದ್ರು ಹೇಗೋ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. Police have come, it means, my lords, police have shifted the deceased body, but there is no accurate who has shifted.
Dead bodies must be there in the spot.
Yes.
It wasn't on the spot only.
Yes. He was
Somebody
the
has to watch
police visited the spot on the same day. Both others had argued that no police visited next day, but Panchanama has been conducted next day. That is there. But as per the PW 1, police have visited on the same day at 11 o'clock. Soon after the registration of this particular
That
case.
must be deposed by any of the police officer. Where is the evidence to that effect by your IO
That is,
or the police officers?
no, sir.
See, after registering an FIR,
Yes.
that is at 10:30.
Yes.
See, before that itself, double murder, this one caused in a road, that one in highway road.
Yes.
Then definitely the police would have informed by somebody.
Yes, definitely. Definitely.
So immediately they have to rush to the spot, or
Rush.
at least after lodging a complaint. That is 10:30.
Yes.
So till morning, nobody was there in the spot. Nobody went to the spot.
But that is there, but PW 1, no, IO has not reduced in his evidence. But as far as PW 1 is concerned, they have visited the spot at 11.
This is a serious lacuna on the part of investigation officer. Even after lodging a complaint.
They'd have gone over there and visited, rest to the spot, definitely. It's a double murder. It's not a silly thing. It's a double murder. And so I'd like to come the PW10 doctor who has conducted the post-mortem. Page number 256 and second parameters in last sixth line. It is true that at the time conducting PM examination of dead bodies of deceased Basappa and Rangava, I was not serving in Government District Hospital, Vijaypur. Witness volunteers that at the time of said postmortem examinations, he was serving in Al Amin Medical College, but District Government Hospital, Vijaypura was attached to the Al Amin Medical College to conduct autopsy. What other side has argued that, my lord, the dead body should have been transferred to the government hospital, but that is there. The attached to the Al Amin Medical College, that is one aspect. And in next page, my lords, in 257, that is in second para. Again at 3:35 PM called the PW10 call in this. The comminuted fracture injuries may cause in road traffic accident, but depressed fractures not possible in road traffic accident, but depressed fractures not possible in road traffic accident. These depressed fractures have been caused to the disease. Yes. If I had come in contact with hard portion of moving vehicle, there is no possibility of causing depressed fracture injury on it. Specifically, he has taken. What the PW6 has stated that PW5 cut hold the legs of the deceased Basappa and PW2 draw the vehicle on his head. But that verbatim that corroborates the doctor evidence. Specifically, yes. That is there, my lord, that is false. The suggestion he did.
Even no scientific examination of that that wheel, the tire of that vehicle, Jeep.
Nothing is there. All the vehicles stood in front of the police station till today.
Okay.
They have not been released. They have no documents and are not. Nobody has come forward to release those documents.
As on today, still the vehicles are with the police.
Upon sound legal advice. Upon legal advice.
Anyhow, it's not stands in the name of accused.
Yes. All these circumstances and the material put forth before your lordship, I, with folded hands, pray the lordship, the appeal may be dismissed.
Thing to say?
First thing, in reply, my lordship, yesterday, I had forgotten to bring home point out that there was no any special reason for the accused number 4 to think of taking of the life of the deceased. In respect of that,
Which one?
regarding accused number 4's involvement, accused number 4 never had any intention of taking away the life of these accused, and he had no any grievance as against deceased and his family. Regarding that, there is a PW1 in his cross-examination has admitted
A1, 2, 3 are the children. A4 is the distant relative.
distant relative. And A5 is not concerned to.
What about A5?
A5 is not concerned to the family.
It's not a relative.
I already brought to the notice of this honorable court regarding the cross-examination of PW1 as read out. And there is absolutely nothing that he has admitted that he had no, A4 had no any dispute with regard to giving or taking of the land and property to their family in the cross-examination. And one more thing, PW1 has admitted the distance between Harmageri and Gundal. It is 80 kilometers, whereas Gundal and Galgali is again 8 kilometers. Gundal and Kangalgutti is 8 kilometers. Kembagi is 20 kilometers. PW5, residents of PW5 and 7. So these things, they are to be taken into consideration. PW7 in the cross-examination, page number 240 and 241, has also admitted that the accused number 4 had no any conflict with any members of the family relating to the property.
See, that is the point we express.
Yes.
Motive loses its importance.
Yes, correct. Yes, correct. It's only my submission is we are in appeal. We are in appeal. That the trial court has, on analysis, had come to some conclusion. That way, what the trial court has held after there is no analysis of evidence as it is. The chief examination portion has been discussed. And only one sentence in respect of each of the witnesses, that there is nothing has been elicited in the cross-examination. Cross-examination portion has not at all been considered at all in respect of any of the witnesses. Therefore, it is now the lordship having the powers under section 286.
Evidence means chief
Yes.
cross.
Yes.
Cross and
Entire evidence, that should be. For why it should not be considered and how it has to be rejected. That has to be said, something has to be said. Only one sentence in respect of each one of the witnesses that has been highlighted by the trial court. In its wisdom, what we can say. That's therefore, I'm required to rebut that, place it on record that it's not correct. The PW8, Ryan Goda, who has come before the court to say regarding the earlier complaint. And he has also admitted in the cross-examination that this accused number 4 had nothing to do with the incident or any enmity he had with the family. If the evidence of PW6 is to be believed. Now, regarding exhibit PW6 evidence, now learned SPP now submitted that in the cross-examination, he has stated that just 3 years prior to this incident, this day, there was a function in their village, and he had an occasion to see. Now, the date of incident is 7/14, and this PW6 is examined in 2017. 3 years prior to this day, he says. 3 years prior to this day, it is to be accepted. That is after the incident. One thing. If this, even accepting for it in that aspect, there was an occasion. If that is so, then lodging of the complaint 4 months prior to, as per Xerox copy, that is also falsifies.
3 years prior to deposing.
Yes, 3 years prior to evidence. That 3 years prior to the incident ಆದ್ಮೇಲೆ ಬರ್ತದೆ.
That strictly.
Strictly,
It is not a mathematics.
Mathematics, probability. No, we have to see the probability. When you say concretely there has been enmity so hard.
That's what Supreme Court repeatedly said. It is not testing the memory power of the witness.
No, but my lord, with great respect, I am submitting. when it comes to the evidence of a child witness, this has to be looked into, because Lordship would see in the beginning of the deposition of recording of evidence of his child witness. So what is required is generally the questions are posed. If the child witness answers those questions rationally, then whether he's fit or not, that will be decided, and then recording has to take place. That is what is then held. Now, Lordship could see this is not so. Simply one sentence is added. Some questions were asked. He has answered correctly. What were those questions? What answers were given? That is not there. So now that is also one of the consideration. Now he has as if in a very systematic way, he has been made to memorize things and he has deposed. That which cannot be accepted.
A special child with the this memory
Lordship,
power.
why I am submitting that. In the very next sentence, when he was asked what was that function, he says, I do not remember that function. He says, I saw them in the function. But when he was asked what was that function, he says, I do not remember that function. This is the position of this boy after 3 years of the incident, who is 11 years old. Can we expect what he had seen, all those things with the specification? It would have been different. I saw these people, some 5 people came and assaulted my grandparents and went away. That would have been different. He names individually. That is not possible. When it regarding PW5's position, as the Lordship has rightly queried, he did not lodge the complaint. Well, he may have reason. Fear psychosis was there when, as long as accused were there, says so-called accused were there on the spot. When they had already left, and he says that he was there up to 10 p.m. What for he was there? What he did? If he has no concern at all, he would have gone. Just he would have gone. He was not an assignee to look on the things as a spectator there. And his chief examination first paragraph, he gives so many details of all the relationship. Absolutely has no concern. He says that I did inform some of the people on the way. At the same time, he says that I did not inform my father and my parents, my wife. And next day 2 p.m, he didn't go even inquire what happened, whether funeral takes place. Forget about the incident. He has seen the dead bodies, according to him. At least for funeral, he doesn't want to go there. He doesn't want to bother. And the last portion of the PW1 cross-examination, as my friend missed that, page number 177. ನಾನು ನಿಶಾನೆ ಪಿ ಒಂದು ದಾಖಲಿಸಿದ ನಂತರ ಪೊಲೀಸರು ಎಷ್ಟು ಗಂಟೆಗೆ ಮತ್ತು ಯಾವ ದಿನಾಂಕದಂದು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿದ್ದರು ಮತ್ತು ನಮ್ಮ ಊರಿಗೆ ಯಾವ ದಿನಾಂಕದಂದು ಬಂದರು ಎಂದು ನನಗೆ ನಿಖರವಾಗಿ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ನಿಶಾನೆ ಪಿ ಒಂದು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟ ನಂತರ ರಾತ್ರಿ ಸುಮಾರು 11 ಗಂಟೆ ವೇಳೆಗೆ ನಾನು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಹೋದೆನು. ರಾತ್ರಿ ಪೂರ್ತಿ ನಾನು ಘಟನಾ ಸ್ಥಳದ ಮೇಲೆಯೇ ಇದ್ದೆನು. ಅದ್ರಲ್ಲಿ ಡೆಡ್ ಬಾಡೀಸ್ ರಾತ್ರಿ ಪೂರ್ತಿ ಇದ್ವು ಅಂತ ಯಾವಾಗ ಡಿಸ್ಕವರ್ ಮಾಡಿದ್ರು? ಹೂ ಲಿಫ್ಟೆಡ್ ದೆಮ್? Who placed into the mortuary of government hospital? Everything is not explained. ನಾನು ಘಟನಾ ಸ್ಥಳ ಈ ರೀತಿ ಹೋದಾಗ ಪೊಲೀಸರು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದಿದ್ದರು. Whereas PW14 and PW12 are totally silent about this fact. That part of the investigation, if really had taken place, why that is not placed on record? Why that is suppressed? And definitely, anybody, a prudent man, could draw an inference. This exhibit P1, which said to have been lodged at 10:30 p.m., is a created story to implicate these accused. That is the reason PW10 doctor is not in a position to definitely say that it is a homicidal death. Now, Lordship may kindly see the injuries on the face. If the tire in a reverse direction, if tire, the vehicle was made to move on the head portion, no, not any other portion, what would have been the position of that part? There are no tire marks found at the time of inquest or at the time of postmortem. Therefore, when one of the witness says that PW5 himself says he saw this accident taking place from a distance of, he was following them 1 kilometer. Due to the hit by a jeep, the Basappa and his wife and the children were tossed. Definitely these probable injuries are likely. It is not just they have fallen down just from a height of 2 or 3 feet.
Admission in the cross-examination.
Regarding
Only suggested whether it is possible to road accident. Then he said, no, in my experience.
Now we want to rule out. See, Lordship, by submission is, the suggestion is one thing. He is an expert, so far as. But we have to analyze from this whether it is possible. The witness says it is tossed. We don't know how it has happened. PW5 says that he saw it. And specifically says they were tossed due to the hit from behind.
But doctor has given an explanation.
No, that explanation is only afterthought. Like, that's not found in the opinion. Balancing explanation of the possible. Opinion nalli avaru certificate nalli illa.
But idರಲ್ಲಿ cross ಅಲ್ಲಿ you only suggested. He specifically said these injuries.
Facial.
That's a natural answer.
That is theirs, my lord. But in the opinion, it is missing one thing. And if you see the injuries found on the facial aspect, and the allegation that the ran over the hind portion of the right hand tire was made to ran over the head portion or the face portion. Now, there could have been some other injuries with a marking of the tire as well, impressed marking, that they are not there. Now, so far as Pooja's non-inclusion is not fatal and ಹೇಳಿದರೆ, and there would have been
them have sustained laceration and contusion.
And there would have been peeling of skin at that portion. Nothing of that facial portion.
Laceration, contusion, and these abrasions.
Yes.
How this contusion injuries in road traffic?
Lordship,
In a road traffic,
can't is possible because body was tossed, and they have come to hard surface, the body. That contusions are likely, and vehicles, impact between the two vehicles. That possibility cannot be ruled out.
the weapons used, this one, some sticks.
Sticks, rod and
One stick,
lead ball.
one sticks,
Sisal
ball.
gundu.
one stick, one iron rod.
And lead ball.
Lead
That's a
ball.
very dangerous weapon.
Iron ball under one end, there will be a belt.
No.
Long rope like belt. They'll hold it. and they'll flash it. Every
Ball, ಏನ್ ball ಅದು?
lead ball, yeah, ball.
ball.
Lead ball, ಸೀಸಮ್. ಅದು ದೊಡ್ಡ ಬಾಲ್ ಇರ್ತದೆ, ಅದಕ್ಕೆ ಲೆದರ್ ಇದು ಇದೆ. ಸೊ ಈಗ ಫ್ಲಾಶ್ ಮಾಡಿದಾಗ is not a flashing against a wall or a wooden some material object.
It is harder than iron, my lord.
Confusion seems to be caused from this,
Hardening.
this, the weapons used, what, rod and,
Rod there may be.
rod and. what
Yes,
were
my
the
lord.
items?
Rod and stick.
Stick.
Stick is there, my lords.
No, that's because there are two vehicles impact was there, and the PW5 says, PW5 has said, this Basappa while riding the motorcycle with speed, he overtook a tractor. So involvement of the tractor accident is also not ruled out, he says. And that has come in the spot Panchanama. And that portion, they wanted to delete it by
Steel made it. Very hard. Doesn't break even.
That contents of the Panchanama was
With the thread.
With a thread. It will be covered
Gundu,
with the leather pouch, my lords, and use it. This is
ಈ
steel made.
ಜಿಮ್ಸ್ ಎಲ್ಲ ಉಪಯೋಗ ಮಾಡ್ತಾರೆ, ಲಿಫ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹ್ಯಾಂಡ್ ಬಾಲ್ ಟೈಪ್, ಮೋರ್ ದೆನ್ ಹ್ಯಾಂಡ್ ಬಾಲ್ ಆ ಥರ.
ಅಲ್ಲ, even otherwise, see, once you, the vehicle ಬಂದು ನಮ್ಮ ಗಾಡಿಗೆ ಹೊಡೆಯಿತು, that itself is sufficient.
ಯಾರು ನಮ್ ಗಾಡಿಗೆ ನಾವೆಲ್ಲ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ.
That is the say of this PW5, that boy.
That boy.
ಹಿಂದಿಂದ ಬಂದು
PW6. ನಮ್ಮ
ಹಿಂದಿಂದ
ಜೀಪಿಗೆ ಬಂದು
yes.
ರಭಸವಾಗಿ
ಗುದ್ದಿತ್ತು.
Provided, my lords, if they produce, my lords, the vehicle documents and all.
MVI report ಇಲ್ಲ.
Provided if they establish that, my lords, the vehicle belongs to me, that could be one of strongest circumstances can say that yes, it is my vehicle. Because he says that you all inmates. But my lords, the prosecution did not establish by producing the RC book and any details of it.
IME report ಯಾವ್ದು ಹಾಕಿಲ್ಲ.
ಯಾವ್ದು?
Till today.
ಅಡ್ಮಿಟ್ ಮಾಡ್ಯಾರ ಅವರು. IO has admitted, yes, it is not there ಅಂತ.
ಅವ್ರ vehicle ಅಲ್ಲಿ
ನಮ್ ವೆಹಿಕಲ್ ಯಾವ ವೆಹಿಕಲ್ ಇಲ್ಲ, ಅವು ಯಾರ ವೆಹಿಕಲ್ ಅಂತ ಇಲ್ಲ. ಈಗ ಆ ವೆಹಿಕಲ್ ಬೇರೆದವ್ರು ಇದ್ರೆ we had taken that vehicle from somebody, ಅವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೇಕು. Or somebody, we had my vehicle, it is, I had abandoned for some reason at some place and that has been misused by somebody. ಆ ಥರ ಆದ್ರೂ ಏನಾದ್ರು ಬೇಕು. Nothing is there. That chain of link is totally missing. Therefore, in totality, my submission is that the prosecution has in fact miserably failed to bring up the guilt of any of the accused, and for more particularly accused number 4. I am submitting the
In my, my lords, in my reply arguments.
I'll make a submission by 2 minutes. I'll take minutes, not more than that. Lords, so for my learned friend, SPP's reply, my lords, motive, my lords, double-edged weapon. It can be used either way, depends on the other evidences, my lords. And so for my learned friend SPP's argument related to the number of the tractor driver, my lords, it is undisputed, my lords. From the tractor driver phone, my lords, it is called to PW1. Either the IO, my lords, or the PW1 could have given the number of tractor driver, my lord. It will be very easy to establish or get him, my lords, call details. Avನಿಗೆ ಆರಾಮಾಗಿ ಹಿಡಿದು he could have established that chain, my lords. They did not make any venture to, my lords, get the call records, or through call records he would have been traced, my lords. Though they can't say that after the call he just flew it, because they had an opportunity to get him back through that call records. They did not do it, my lords. So for a PW5 is concerned, my lord, he says that learned SPP's argument, my lords, he's scared of it. If he is really scared of it, my lord, he did not come forward and adduce the evidence before court, saying that I am the eyewitness to the incident. And apart from this, my lords, he who, my lords, named A5,
by only by virtue of the PW5 evidence, my lords, he named this A5's name. If he really scared, he would have not made such ventures, my lord. And my lord, so far this puja is concerned, my lord, in the complaint itself, page 9 of the paperwork, lordship may kindly see. Last para, PW1 mentions that, my lords, ನನ್ನ ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶ್ವನಿಗೆ ಬಿಜಾಪುರ ಸರ್ಕಾರ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಉಪಚಾರ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ದಾಖಲು ಮಾಡಿ ಈಗ ತಮ್ಮ ಕಡೆಗೆ ಬಂದು ಫಿರ್ಯಾದಿ ಕೊಡಲು ತಡವಾಗಿದೆ. ಅಣ್ಣನ ಮಗಳಾದ ಪೂಜೆಯ ಒಳಗೆ ಗಲಗಲಿ ದವಾಖಾನೆಯಲ್ಲಿ ಪ್ರಾಥಮಿಕ ಉಪಚಾರ ಮಾಡಿಸಿದ್ದೇ ಇರುತ್ತದೆ. Pooja also may not shown to the doctor. Since my learned friend said that she was not taken to the hospital, she was very much shown to the hospital. Injuries are, my lords, not aware of it because they have not produced any MLC reports, my lords. And so far this child witness is concerned, my lords. My lords, it's very obvious that the child is about 8 years. After the incident, it is with the guardian, PW1 itself. And there is every possibility, my lords, child may be tutored because it was there about 3 years gap. So that is a possibility that, my lords, child may be tutored and made him to adduce the evidence as an eyewitness to the incident. So can't be said that child has been not tutored, my lords. And apart from this, my lords, they could have, if you want to prove the case, my lords, they should have, my lord, taken the report of the RTO inspector. So for the tire or the panchanama of the tire and other things, my lords. And apart from this, as my learned friend mentioned, my lord, regarding the, as per the evidence of PW5, my lords, the A5 has holded the legs of the deceased Basappa. And, my lords, 2 has ran over the vehicle on that. If that would have been the case, my lord, the injuries would have been different. Because the moment they take away the, my lords, on the head, my lords, certainly there would have been possibility of peeling off the skin. Ashta heavy vehicle hoದ್ಮೇಲೆ certainly it would have been peeled off. ಹಾಗೆ ಇರಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. So, my lords, this version of the PW5, my lords, falsify the case of his presence also, my lords, because he is a planted eyewitness to the incident, my lords. Apart from this, my lords, I'd like to make quote few citations of the Supreme Court, my lords.
So to mention the relevant portions in your memo, Satyanarayana, to mention the relevant portions in the memo, you have to extract that. You are relying for this purpose and what is the law, the exact point.
I'll mark.
Reply, my lords. One is to connect the accused number 4 to this incident, my lords, the page number 158. The PW1 is categorically stated that, my lords, as the learned senior advocate Kadlur sir has submitted that there is no nexus to this particular case to the act number 4, my lords. That in para number 2, ನನ್ನ ಅಕ್ಕನ ಹೆಸರು ನಮ್ಮ ಮನೆಯಲ್ಲಿ the small ಮನೆಯಲ್ಲಿ ದ್ಯಾಮವ್ವ ಎಂದು ಮತ್ತು ಆಕೆ ಮದುವೆಯಾದ ನಂತರ ಆಕೆ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಆಕೆ ಹೆಸರು ಲಕ್ಷ್ಮೀಬಾಯಿ ಎಂದು ಇದೆ. ನಮ್ಮ ಅಕ್ಕ ದ್ಯಾಮವ್ವಳನ್ನು ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆ ಬದಾಮಿ ತಾಲೂಕಿನ ಹಣಮನೇರಿ ಗ್ರಾಮದ ಬಸಪ್ಪ ತಂದೆ ಅಮೋಘಪ್ಪ ಕಮಟಗಿ ಇವರಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕಮಟಗಿ ಇವರು ಹಣಮನೇರಿ ಗ್ರಾಮದಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನನ್ನು ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಅಕ್ಕ ದ್ಯಾಮವ್ವನ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲೆ ಮಾಡಿಸಿದರು. ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕಮಟಗಿ ಇವರಿಗೆ 4 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು. ಆ ಪೈಕಿ ಒಬ್ಬ ಹೆಸರು ಸಾಯವಳ ಗಂಡನ ಹೆಸರು ಕೃಷ್ಣಪ್ಪ. ದ್ಯಾಟ್ ಈಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4. ಚಂದ್ರಪ್ಪ ಅಂದ್ರಿಗೆ ಚಂದ್ರಪ್ಪ ಅಂದ್ರಿಗೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ 4ನೇ ಆರೋಪಿ ಇದ್ದಾನೆ. ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳು ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕಮಟಗಿ ಅವರು ನಮ್ಮ ಅಕ್ಕನ ಹೆಸರಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನು ಖರೀದಿ ಮಾಡಲು ಕಾರಣರಾಗಿದ್ದಾರೆ ಎಂದು 4ನೇ ಆರೋಪಿ ನಮ್ಮ ತಂದೆಯ ಮೇಲೆ. That point number 1, my lord, there is a nexus in this case to accused number 4. And secondly, what my learned friend has stated that if the PW5 did not make any try to lodge a complaint or he didn't inform to anybody, and if that is there, how he has come forward to adduce his evidence? Yes, definitely. All the accused are in custody. If they were on bail, they are on bail, the thing would have been different. He would not have come forward to adduce that. Obviously. That is my claim. And also, my lord, if the weight of the vehicle is taken into consideration, the injury would have been different, what my learned friend has stated. The doctor has to say, doctor categorically stated, and defense in their own cross-examination, the doctor has submitted that due to road accident, such type of injury will not be. That's it.
Citations may make it synopsis and, yeah,
ಮಾಡಿಬಿಡಿ,
part
ಏನಿಲ್ಲ.
and
Memo
parawise, I
just
already made it, but
paragraph and
paragraphs and the
Yes.
reason for we are giving,
yes,
that I'll make it,
yes.
or else,
Evening ಕೊಟ್ಟು ಬಿಡಿ.
please.
Heard for dictating judgment Monday.
Tomorrow I'll leave with the court of summons, citations.
ಆಯ್ತು.
Great.
And these are for a short bullet points for consideration.
yes.
Whatever I argued, my lords, I put it into.
Yes,
different-
ಕೊಟ್ಟು ಬಿಡಿ.
Serial number 40, additional SPP, Ramchandra K.
He was telling that, my lords, he has given no objection to the party that
What?
Ramchandra K had come and he was telling me, but he wanted to file a retirement notice and all.
ಅಲ್ಲಿ ನೋಡೋಣ ಏನಿದೆ ಅಂತ.
ಆಯ್ತು.
ಇದ್ರೆ ನೋಡೋಣ, ಇಲ್ಲಾದ್ರೆ ಬೇಡ. ಏನ್ ಜಸ್ಟ್ ನೋಡು ಏನೋ. Four 302, ಹ್ಮ್
498 302.
ಹ್ಮ್. ಯಾರಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್?
ನೋಡಿಲ್ಲ. Even 4 appeal ಅಲ್ಲಿ my lords have directed me. 2 days I have
ನೋಡೋಣ
prepared this appeal.
ಸಿಂಪಲ್ ಸ್ಟೇಟ್
Yes, yes, my lord.
ಏನಿರುತ್ತೆ?
Yes, my lord.
10 minutes.
Yes, yes. Dying declaration ಇದೆ.
ಎಸ್ ಎಸ್ ಹಾ ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಓರಲ್
Yes.
ಇರ್ಬೇಕು ನೋಡಿ.
Yes.
ಹಾ ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ದ ಡಿಸೀಸ್ಡ್, that is her statement recorded complaint.
Yes.
Exhibit P16
P16.
her complaint.
P16. Exhibit P16. In page number 4.
Ambova is the deceased ಅಲ್ವಾ?
Yes, my lords.
Hmm.
Yes, my lords.
ಹಾ
Shall I read the complaint?
ಎಸ್ ಎಸ್.
ನಾನು 9 ವರ್ಷ ಮಕ್ಕಳು ಅಂಗನವಾಡಿ ಟೀಚರ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಉಪಜೀವನ ಸಾಗಿಸ್ತೀನಿ.
ಹ್ಮ್.
ಹೀಗಿದ್ದು ನನಗೆ ಈಗ 10 ವರ್ಷ 4 ತಿಂಗಳ ಹಿಂದೆ ಪೇಟಶಿರೂರು ಗ್ರಾಮದ ಸುರೇಶ್ ತಂದೆ ನಾಗಪ್ಪ ಪೂಜಾರಿ ರೀತಿಯನ್ನು ಕೊಟ್ಟು ಲಗ್ನ ಮಾಡಿದ್ದು. ನನಗೆ 4 ಜನ ಮಕ್ಕಳು, ಸಿದ್ರಾಮೇಶ್, ಸಂಜನಾ, ಸಮೀಕ್ಷಾ, ಮೌನೇಶ್ ಅಂತ ಇದ್ದು. ನನಗೆ ಈಗ 1.5 ವರ್ಷಗಳ ಹಿಂದೆ ನಮ್ಮ ಪೇಟಶಿರೂರು ಗ್ರಾಮದಲ್ಲಿ ಅಂಗನವಾಡಿ ಟೀಚರ್ ಅಂತ ನೌಕರಿಯಾಗಿದ್ದು. ನನಗೆ ನೌಕರಿ ಆದಾಗಿನಿಂದ ನನ್ನ ಗಂಡ ದಿನಾಲು ಸರಾಯಿ ಕುಡಿದು ನನಗೆ ಸರಾಯಿ ಕುಡಿಯಲು ಹಣ ಕೊಡುವಂತ ಜಗಳ ತೆಗೆದು ನನಗೆ ರಂಡಿ ಬೋಸಡಿಂತ ಬೈದು ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದು. ಹಾಗೂ ನಾನು ಅವನ ನೌಕರಿ ಮೀಟಿಂಗ್ಗಳಿಗೆ ಹೋದರೆ ನೀನು ಯಾವನ ಜೊತೆ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡಿರ್ವಿ ಅಂತ ಸಂಶಯ ಪಟ್ಟು ಜಗಳ ತೆಗೆದು ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದು. ನಾನು ನನ್ನ ಗಂಡನಿಗೆ ಇದೇ ತರ ಸರಾಯಿ ಕುಡಿದು ಬಂದು ಜಗಳ ತೆಗೆದು ಹೊಡೆಬಡೆ ಮಾಡಿದರೆ ನಮ್ಮ ಸಂಸಾರ ಕೆಟ್ಟು ಹೋಗುತ್ತೆ ಅಂತ ಎಷ್ಟು ಬುದ್ಧಿ ಮಾತು ಹೇಳಿದ್ರು ಯಾವುದೇ ಕೆಲಸ ವಗೇರೆ ಮಾಡದೆ ದಿನಾಲು ಸರಾಯಿ ಕುಡಿದು ನನಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದಕ್ಕೆ ಈ ವಿಷಯ ನಮ್ಮ ಭಾವಂದಿರ ಸುಭಾಷ್, ನಿಂಗಣ್ಣ ಹಾಗೂ ನಮ್ಮ ಗ್ರಾಮದ ಮುಖ್ಯಸ್ಥರಲ್ಲಿ 1-2 ಸಲ ಹೇಳಿದ್ದಕ್ಕೆ ನನ್ನ ಗಂಡ ರಂಡಿ ನೀನು ಯಾರ ಮುಂದೆ ಹೋಗಿ ನನ್ನ ಬಗ್ಗೆ ಚಾಡಿ ಹೇಳಿದ್ದೆ ಅಂತ ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದು. ಈ ವಿಷಯ ನಮ್ಮ ಅಣ್ಣ ಗುಂಡಪ್ಪ, ತಮ್ಮ ರೇವಣ ಸಿದ್ದಪ್ಪ ಇವರಿಗೆ ತಿಳಿಸಿದಾಗ
ಅವ್ರು ಒಂದ್ಸಲ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನ್ನ ಗಂಡನಿಗೆ ಬುದ್ಧಿ ಮಾತು ಹೇಳಿದ್ದಕ್ಕೆ ಅವರಿಗೆ ಯಾಕೆ ಕೇಳಿದ್ದೆ ಅಂತ ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದು, ಈಗ 3 ದಿವಸಗಳಿಂದ ನನ್ನ ಗಂಡ ಅತಿಯಾಗಿ ಸರಿಯಾಗಿ ಕುಡಿದು ಬಂದು ನಿನ್ನ ಪಗಾರ ನನಗೆ ಕೊಡುವಂತ ರಾತ್ರಿ ಅಂತ ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದು. ನಿನ್ನೆ ದಿನಕ್ಕೆ 26/4/2012 ರಾತ್ರಿ 10 PM ಸುಮಾರಿಗೆ ನಾನು ಹಾಗೂ ನನ್ನ ಮಕ್ಕಳು ಮನೆಯಲ್ಲಿದ್ದಾಗ ನನ್ನ ಗಂಡ ಸರಾಯಿ ಕುಡಿದು ಬಂದ್ರಂడి, ಇವತ್ತು ನನಗೆ ಸರಾಯಿ ಕುಡಿಯಲು ಹಣ ಕೊಡು ಅಂದಾಗ ನಾನು ಎಲ್ಲಿಂದ ತರಲಿ ಹಣ, ಮಕ್ಕಳಿಗೆ ಏನ್ ತಿನ್ಸೋಣ ಅಂತ ಅಂದಕ್ಕೆ ರಂಡಿ ನನಗೆ ಎದುರು ವಾದಿಸುತ್ತಿ ಇವತ್ತು ನಿನಗೆ ಜೀವನ ಸುಟ್ಟು ಹಾಕುತ್ತೇನೆ ಅಂತ ಮನೆಯಲ್ಲಿಟ್ಟು ಸೀಮೆ ಎಣ್ಣೆ ಡಬ್ಬಿ ತೆಗೆದುಕೊಂಡು ಅದರಲ್ಲಿನ ಸೀಮೆ ಎಣ್ಣೆ ನನ್ನ ಮೇಲೆ ಸುರಿದು ಅಲ್ಲೇ ಒಲೆಯ ಹತ್ತಿರವಿದ್ದ ಬೆಂಕಿ ಪೊಟ್ಟಣ ತೆಗೆದುಕೊಂಡು ಕೊರೆದು ನನ್ನ ಮೈಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದನು. ಆಗ ನಾನು ಎದ್ದು ಚೀರಾಡುತ್ತಿರುವಾಗ ನಮ್ಮ ಅಣ್ಣತಮ್ಮಿಕೆಯ ಭಾವೇಂದ್ರ ಮಕ್ಕಳಾದ ಪ್ರಕಾಶ್, ಶಿವಪ್ಪ ಇವರು ಬಂದು ನೋಡಿ ಕೌದಿಯಿಂದ ಹಾಗೂ ನೀರಿನಿಂದ ಬೆಂಕಿ ಹಾರಿಸಿದರು. ಆಗ ನನ್ನ ಎದೆ, ಹೊಟ್ಟೆ, ಬೆನ್ನು 2 ತೊಡೆಗಳು ಸಂಪೂರ್ಣ ಸುಟ್ಟು ಬೆಳಗಾಗಿದ್ದು ವಿಷಯ ತಿಳಿದು ನಮ್ಮ ಭಾವ ಸುಭಾಷ್ ಹಾಗೂ ಬೆಂಕಿ ಹಾರಿಸಿ ಪ್ರಕಾಶ್, ಶಿವಪ್ಪ ಹಾಗೂ ವಿಷಯ ತಿಳಿದ ಅಣ್ಣತಮ್ಮಿಕೆ ಶರಣಪ್ಪ ಒಂದು ಆಂಬ್ಯುಲೆನ್ಸ್ ಫೋನ್ ಮಾಡಿ ಕರೆಯಿಸಿ ಅದರಲ್ಲಿ ನನಗೆ ಹಾಕಿಕೊಂಡು ಉಪಚಾರ ಕುರಿತು ಇಲ್ಲಿಗೆ ಸೇರಿಕೆ ಮಾಡಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಓಡಿ ಹೋಗಿದ್ದು ಇರುತ್ತದೆ. ಕಾರಣ ಮೇಲೆ ಮುಗಿಸಿ ನನ್ನ ಗಂಡ ಸುರೇಶ್ ಈತನು ದಿನಾಲು ಸರಾಯಿ ಕುಡಿದು ಬಂದು ಸರಾಯಿ ಕುಡಿಯಲು ಹಣ ಕೊಡುವಂತ ಜಗಳ ತೆಗೆದು ಅವಶ್ಯದಿಂದ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದಾರೆ. This is the complaint, my lords, and it is stated to be the dying declaration.
FIR registered on 27.
27/4/2012, my lords, at
Time?
9 AM.
9 AM,
9:05 AM.
9:05 AM.
Yes, my lords.
Next day,
Yes,
in the hospital, huh?
in the hospital.
Uh,
Yes, CH-2 Brahmpur.
Who registered, who recorded the statement? PW?
Yes, CH-2 police sub inspector ಮಾಡ್ಬೋದು ಅಂತಿದೆ ಸರ್. Yes, madam.
Karana Basappa, no?
One second.
Manohara Bai ಅಲ್ವಾ? HHO, PW,
17,
PW 17.
page number 94. Shall I read on that?
Yeah, ಬೇಡ. Registered the FIR.
Yes, ಇಲ್ಲ ಸರ್, ಗಾಳಿ ಚಿಕಿತ್ಸೆ ಪಡೆದ ಅಂಬೋ ಅಲಿಯ ಸಂಬಿಕೆಗಳನ್ನು ನೋಡಿದ ಮತ್ತು ಮರಣಪೂರ್ವ ಹೇಳಿಕೆಯನ್ನು ಪಡೆಯುವಾಗ ಸಲುವಾಗಿ ತಹಶೀಲ್ದಾರ್ಗೆ ಪತ್ರವನ್ನು ಬರೆದಿದೆ. ಆಮೇಲೆ ಹೇಳಿಕೆ ಫಿರ್ಯಾದಿನ ಪಡೆದುಕೊಂಡು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ಠಾಣೆ ಗುನ್ನೆ ನಂಬರ್.
ಆಯ್ತು, ತಹಶೀಲ್ದಾರ್ ಬಂದ್ರ?
ತಹಶೀಲ್ದಾರ್ ಬಂದಿರ್ತಾರೆ ಸರ್.
ಬಂದಿಲ್ಲ. ತಹಶೀಲ್ದಾರ್ ಇಲ್ಲ ನೋಡಿ.
ನೋಡ್ತೀನಿ ಸರ್.
PW1 ಬನ್ನಿ.
ಸರ್.
PW1 ಶಾಂತಪ್ಪ. is a witness for exhibit P1, spot Mahazar. PW1, page 59 ಗೆ ಬನ್ನಿ.
Yes. ಪೊಲೀಸರು ನನ್ನ ಪಂಚನಾಮದ 2 ವರ್ಷದಿಂದ ನನ್ನ ಆರೋಪಿ ಮನೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ರು. ಪೊಲೀಸರು ಒಂದು ಚಿಮಣಿ ಎಣ್ಣೆ, ಪ್ಲಾಸ್ಟಿಕ್ ಡಬ್ಬಿ, ಒಂದು ಮ್ಯಾಚ್ ಬಾಕ್ಸ್, ಸುಟ್ಟ ನೀಲಿ ಜಂಪರ್ ಇವುಗಳನ್ನು ತೋರಿಸಿದ್ರು ಮತ್ತು ಅವುಗಳನ್ನು ಪೊಲೀಸರು ನಮ್ಮ
1, 2, 3
ಅಮೌಂಟ್
spot.
ಎಸ್ ಸ್ಥಳದ ಪಂಚನಾಮ ಬರೆದ್ರು. ಪೊಲೀಸರು ಆರೋಪಿ ಹೆಂಡತಿ ಅಂಬವ್ವ ಅನ್ನೋಳನ್ನು ಸುಟ್ಟುಕೊಂಡು ಪಂಚನಾಮ ಬರೆದ್ರು. ಒಂದು ಪ್ಲಾಸ್ಟಿಕ್ ಡಬ್ಬಿ, ಒಂದು ಮ್ಯಾಚ್ ಬಾಕ್ಸ್, ಒಂದು ಸುಟ್ಟ ಜಂಪರ್ ನೋಡ್ತಾ ಅವುಗಳನ್ನು ಸಾಕ್ಷಿ ಗುರುತಿಸಿತ್ತು. ಅವುಗಳನ್ನು ಮುದ್ದೆಮಾಲ್ ನಂಬರ್ 1 ರಿಂದ 3 ಅಂತ ಗುನ್ನೆ ಸ್ಥಳ ಪಂಚನಾಮ.
ಆಯ್ತು.
He has supported the case of the first.
Yes, 2 ಬನ್ನಿ. Spot Mahazar.
Yes.
ಜಟ್ಟಪ್ಪ, inquest.
Inquest. He too supported the case of the first.
ಆಯ್ತು, exhibit P2.
Yes. Exhibit P2 and P2 is his signature. Ishan is a PDO, my lords.
Ishan is the PDO.
PDO.
The register,
Khata extract.
Khata.
That particular house where the incident is set to have occurred.
Belongs to whom? Belongs to whom?
Belongs to accused and deceased.
ಆಯ್ತು. Exhibit P3,
Exhibit P3. Exhibit P3.
ಆಯ್ತು.
And deceased brother supported PW4.
3 and 4.
Gundappa.
PW4.
Deceased brothers. He supported the case of the.
ಏನ್ ಹೇಳ್ತಾನೆ?
ಸುಭಾಷ್ ಅವರು 11:30ಕ್ಕೆ ಫೋನ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು ನಿಮ್ ತಂಗಿಗೆ ಹಿಂಗ್ ಸುಟ್ಕೊಲ್ಲೇನಂತ. ಅವಳು
ಆರೋಪಿಯು ಸೀಮೆಯನ್ನು ಸುರಿದು ಅವಳಿಗೆ ಹಚ್ಚಿದಾನಂತ ತಿಳಿಸಿದ. ಸುಭಾಷ್ ಅನ್ನುವವನು
ರಾತ್ರಿ 11:30 ಫೋನ್ ಮಾಡಿ ಆರೋಪಿ ನಿನ್ನ ತಂಗಿ ಎಂಬುವಳಿಗೆ ಸೀಮೆ ಎಣ್ಣೆಯನ್ನು ಸುರಿದು ಅವಳಿಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದಾನೆ ಅಂತ ತಿಳಿಸಿದನು.
ರಾತ್ರಿ 12:30ಕ್ಕೆ ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆನು. ನನ್ನ ತಂಗಿ ಮಾತನಾಡುವ ಸ್ಥಿತಿಯಲ್ಲಿ
ಇರಲಿಲ್ಲ.
ನನ್ನ ತಂಗಿಯವಳು ಸರ್ಕಾರ ಚಿಕಿತ್ಸೆ ಪಡೆಯುವಾಗ
ಮರುದಿವಸ ಮಾತನಾಡಲು.
ಮರುದಿವಸ ಮಾತನಾಡಲು ಪ್ರಾರಂಭಿಸಿದರು.
Yes. And the same incident narrated to the PW4
ಆಯ್ತು.
by the
Oral statement by deceased.
Yes, yes. And PW5, my lords. Bhimaraya, independent witness and member of Gram Panchayat of that particular village. He supported the case of the prosecution.
ನೋಡಿ ಪ್ರತಿಕೂಲ ಸಾಕ್ಷಿ ಅಂತ
ಸರಿಯಾಗಿ ಬಾಳ್ವೆ ಮಾಡ್ರಿ ಅಂತ he advised.
is eye witness actually.
Who, sir?
Is eye witness turned hostile. He said panchayat held ಅಂತ ಅಷ್ಟೇ.
Yes, yes, ma'am. Independent witness.
ಪಂಚಾಯತ್ ಹೆಲ್ಡ್ ಅಂತ ಹೇಳ್ತಾನೆ ನೋಡಿ.
ಹಾ, ಹೌದು ಸರ್.
ಬುದ್ಧಿ ಮಾತು ಹೇಳಿ ಕಳಿಸಿದೆ.
ಬುದ್ಧಿ ಮಾತು. ಜಗಳ ಮಾಡಿಕೊಂಡು
ನೈಬರ್.
ಹೌದು. ಸರಿಯಾಗಿ ಬಾಳ್ವೆ ಮಾಡ್ರಿ, ಜಗಳ ಮಾಡ್ಬಿಡ್ರಿ ಅಂತ ಹೇಳಿ ಕಳಿಸ್ಕೊಟ್ಟಿದೆ. ಆಮೇಲೆ 6 ತಿಂಗಳ ನಂತರ ಮತ್ತೊಂದ್ಸಾರಿ ಅವರಿಬ್ಬರು
ಈ ಹಂತದಲ್ಲಿ ಪ್ರತಿಕೂಲ ಸಾಕ್ಷಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ನೋಡಿ.
ಇದೆ ಸರ್. ಇದೆ ಸರ್. ಪಾರ್ಟಿ ಸವಾಲ್.
So turned hostile in respect of the actual incident.
Any of my lords, he supported somewhat.
PW6
Shivasharanappa, deceased younger brother, supported the case of the prosecution as of PW4.
PW4. ಅಲ್ಲಿಗೆ ಹೋದಾಗ ಅವಳು ಮಾತನಾಡ್ತಿದ್ದು ಹೇಳಿದ್ಲು ಅಂತ.
Yes, yes, yes.
Next PW7.
PW7 is an independent witness supported. ನನಗೆ ಆರೋಪಿ ಸುರೇಶ್ ಮತ್ತು ಮೃತ ಅಂಬೋಯವರ ಪರಿಚಯವಿದೆ. 26/4/11 ನಾನು ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಇದ್ದ ಗುಂಡಪ್ಪ ನನಗೆ ಫೋನ್ ಮಾಡಿ ನನ್ನ ತಂಗಿ ಅಂಬೋಯವಳು ಸುಟ್ಟುಕೊಂಡಿದ್ದಾಳೆ ಅಂತ ಹೇಳಿದನು. ನಾನು ಮತ್ತೆ ಸಿದ್ದಪ್ಪ ಕುಡ್ಕೊಂಡು ಗುಲ್ಬರ್ಗ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆವು. ಆಗ ಅಂಬೋಯವಳು ಸದರಿ ಆಸ್ಪತ್ರೆ ಚಿಕಿತ್ಸೆ ಪಡಿತು. ಅವಳು ಆಗ ಮಾತನಾಡುತ್ತಿದ್ದಳು. ಅವಳು ಆರೋಪಿ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದಾನೆ. ಸೇಮ್ ಓರಲ್
oral information. 6 and 7 oral declaration by deceased.
Yes.
In the hospital.
Yes.
ಆಯ್ತು.
Next is Prakash.
8.
8 is accused cousin. He has not supported.
Hostile. 9.
9 also not supported the case of the prosecution. Who has supported the deceased younger brother supported Revan Siddappa.
10.
PW10. Deceased younger brother. Same sir. As of PW4 and 7.
ಸರಿ. ಅಲ್ಲಿಗೆ ಹೋದಾಗ ಹೇಳಿದ್ಲಂತ. 10.
11 hostile in chief but admitted somewhat in cross examination. That's Shivappa. I know accused and deceased Ambo. I do not know for what reason Ambo died.
ಆಯ್ತು. hostile.
Most.
12.
12 is my lords the RS Ratnakara CDPO.
CDPO.
Yes, my lords.
Deceased Ambava was working as Anganawadi worker.
Yes, yes, Anganwadi. That she has stated in her exhibit P16.
Next, PW13.
13 is Jescom engineer pertaining to electricity. No, my lords. Jescom engineer.
Jescom.
Whether the electricity was there or not on that day. Shivaya, who is an independent witness. ನನಗೆ ಆರೋಪಿ 2 ವರ್ಷಗಳಿಂದ ಆರೋಪಿ ಸಿಮೆಂಟ್ ಹಾಕಿ ಸುಟ್ಟ ಸರ್ಕಾರ
ಎಕ್ಸ್ಟ್ರಾ ಜುಡಿಷಿಯಲ್ ಕನ್ಫೆಷನ್. ಭೀಮರಾಯ ನಾಟಿಕಾರ ಯಾರು?
ಭೀಮರಾಯ ನಾಟಿಕಾರ
ಭೀಮರಾಯ ನಾಟಿಕಾರ ಇವನು ಆರೋಪಿ ಅಂಬವ್ವ ಇವಳ ಮೇಲೆ ಸೀಮೆಯನ್ನು ಸುರಿದು ಬೆಂಕಿ ಹಚ್ಚಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದನು. ಸೊ ಈಸ್ ಅನ್ ಹಿಯರ್ಸಿ. ಅಲ್ವಾ?
ಹಿಯರ್ಸಿ ಆಗುತ್ತೆ ಸರ್.
ಹಿಯರ್ಸಿ.
ಅವಳಿಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದನು. ಎಸ್, ಹಿಯರ್ಸಿ. And somewhat he has supported extrajudicial hearsay. And PW15 is an engineer who prepared sketch. PW16 is a doctor who conducted PM. Yes.
ಏನ್ ಹೇಳ್ತಾರೆ?
But same
set by
that I am of the in page number 92 minutes. I am of the opinion that cause of death was cardiorespiratory failure as a result of septicemia secondary to 75% to 80, infected, superficial to deep burns. That corroborates what the story. Manohara Bhaiya Pundalik, ASI Wadi. This person has registered the case and recorded the statement of Ambika. And PW 18 is a PSI minutes.
18 is a
PSI. Mad.
PSI.
PSI.
Conducted spot and other investigation.
Yes, yes. Some part of the investigation he has come. And
ಆಯ್ತು ಅಷ್ಟೇನಾ?
yes, ma'am.
ಮತ್ತೆ ಎಲ್ಲಿದ್ದಾರೆ? ಡಾಕ್ಟರ್ ಎಲ್ಲಿದ್ದಾರೆ?
Doctor,
ಅಲ್ಲ ಡಾಕ್ಟರ್ ಅಲ್ಲ, ಅಂದ್ರೆ ಡಾಕ್ಟರ್ who certified that she is in a fit condition to give statement.
ಅವ್ರಿಲ್ಲ.
ತಹಶೀಲ್ದಾರ್ ಎಲ್ಲಿದ್ದಾರೆ?
ತಹಶೀಲ್ದಾರ್ ಇಲ್ಲ. Before them, there are main factors of the recording the dying declaration.
The oral dying declaration must be corroborated. Oral testimony, oral dying declaration of the deceased.
Yes.
Cannot, without any certificate or any.
Yes. Certificate is a must.
So death is due to burn injuries, septicemia.
Septicemia with superficial to deep burns.
Any cross ಮಾಡಿದಾರ ಡಾಕ್ಟರ್ ಅನ್ನು?
ಮಾಡಿದಾರೆ.
ಏನಂತ ಹೇಳಿದಾರೆ?
ಇದು ಬಹುಶಃ ಯಾರು DLS ಯಾರು ನಡೆಸಿರೋ ಗೊತ್ತಿಲ್ಲ ಸರ್.
PW 16.
Page number 92.
While preparing food. Accidental burn injury, and that is their case.
Accidental ಅಂತ that their defense. 4 ಮಕ್ಕಳು ಇಟ್ಕೊಂಡು ಅವಳೆ ಗಂಡನ ಮೇಲೆ ಇದು ಮಾಡ್ತಾರೆ.
Accidental burn ಅಂತ. They suggested that if a sari of a woman touches with fuel while preparing food in the kitchen, she will get a blaze.
And she may die due to the burn injury. It is true to say. ಅದು ಆಯ್ತು ಸರ್. But if it is an accidental burn injuries, why would she involve that question?
But even otherwise, say the 75 to 80% burn injuries. So whether the certificate in this case is very much required.
Yeah, that is required.
75 to 80%
But
burn
yes,
injuries.
yes, I do agree, sir. But 75 to 80, even 85, 90%
Yes, yes.
burn is
Yes,
also
yes.
there. They may able to talk for 2 to 3 days.
That is there.
Certificate is required, my lords.
Certificate is.
That is also one of the fatal to the prosecution.
Next day she is able to speak. Next day she is able to speak. So next day only she is lodging the complaint. So the complaint. Say, the doctor must have informed to this PW 17. MLC ಬಂತಂತ ಹೇಳ್ತಾರೆ. She received MLC. So doctor must be there. Who has sent the MLC?
Doctor must be there, and also Tahsildar has in presence of.
At least while recording this statement, exhibit P1.
Yes, yes, yes.
Shown the.
They're all the
presence of
requirements.
exhibit,
They are all the requirements which are to be fulfilled to prove the dying declaration.
Yes.
Nothing has been followed. That I fairly admit.
Not there. ಮತ್ತೆ ಇನ್ನೇನಲ್ಲಿ ಇದರಲ್ಲಿ ಏನ್ ರೀಸನಿಂಗ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನಾದ್ರು ಸೆಷನ್ ಜಡ್ಜ್ ಏನ್ ಹೇಳಿದಾರ?
ಅದೇ ಇದು ಹೇಳಿದ್ದಾರೆ ಸರ್, ನೋಡಿದೆ. That in last, the page number 108, sir. The evidence of PW 4, 6 and 10 also purported to be a dying declaration narrated by the deceased to PW 4, 6 and 10. The deceased admittedly suffering from burn injury to the extent of 75 to 80%. The death of the deceased occurred in 1/5/2012 at 6:30 am, on the 7th day of occurring of incident. That means the deceased has taken treatment in the hospital for 7 days. Neither PW 16 or PW 18 or PW 19 IOs have taken care to place medical records before the court to find out as to whether victim in a position to speak at the time of recording exhibit P16 dying declaration. What my lordship has opened, that is same. Even after 5, 6 days, 6, 7 days she died, my lord. Even they could have
Recorded
tried,
the statement, they could have clarified.
the thing would have been different.
ತಹಶೀಲ್ದಾರ್ಗೆ ರಿಕ್ವೆಷನ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾನೆ PW 17.
But there is no evidence of that. He didn't come over there. Nothing is there to show that Tashindar was there. He is the right person to record his statement. I mean, he has to be present at that time. Two not seven and ready this. Nice.
He died on
One 17.
1/7, huh? ಅಲ್ಲ 27/4/2012
1 5
incident.
1 5
1 5
1 5
1/5/2012. Thereafter 302 invoked, huh?
Thereafter, initially 307 and thereafter 302. 1/5/2012 at 6:30 AM. She died. Morning.
Well, good.
And in the last,
Madam.
in the last lines, my lords, in page number 108, the trial court has opined that, my lords. In page 108. Last 3 lines. In the absence of medical records, the defense is justified in arguing that the presence of PWs 4, 6, 10 and 17 while recording the dying declaration is doubtful. My lords, the doubtful dying.
State has preferred this appeal against the judgment dated 28/4/2016 passed by the district and 4th additional district and session judge at Kalaburagi in SC number 382 of 2012, wherein the learned session judge acquitted the respondent accused for the offense punishable under section 498A and 302 of IPC. Also, the factual matrix of the prosecution case, in brief, that the marriage of respondent accused and deceased
10 years.
Ambava, deceased Ambava, deceased in this case, Ambava was performed 10 years ago at Pettisur village. Thereafter, she was appointed. Thereafter, the deceased was appointed as Anganwadi teacher in the said village, and the accused demanding money from her for his bad voices and also suspecting her fidelity and used to ill-treat her both mentally and physically. Full stop. On this background, on 26/4/2012, in the night hours at about 22 hours, in their residential house, the accused, after consuming alcohol, insulted the deceased wife, deceased Gangabai, deceased Rambawa, and abused her in filthy language and insisted her to give money for alcohol, for consuming alcohol. When she refused, he poured kerosene on her and set her ablaze. Full stop. Thereafter, she was shifted to Kalaburagi District Hospital and admitted as an inpatient on 27/4/2012, 26/4/2012, and 26/4/2012, and on the next day, 27/4/2012, PW17, the then PSI of the complainant police, received MLC from the said hospital and he visited the said hospital at about 9:05 AM and recorded her statement as per Exhibit P16 and based on the same, registered the FIR in crime number 35 of 2012 dated 27/4/2012 against the accused for the offence punishable under section 498A and 307 of IPC. Full stop. Subsequently, the injured Ambawa, succumbed to the injuries on 1/5/2012 at about 6:30 AM. Thereby, the PW17, sent a requisition for the filed a requisition before the jurisdictional magistrate to invoke section 302 of IPC after obtaining sanction from the magistrate, obtaining permission from the magistrate, section 302 invoked in crime number 35 of 2012. Full stop. Accordingly, full stop. Thereafter, thereafter PW 18 and 19 conducted the investigation, after obtaining necessary documents from concerned authorities, so also recording the statement of witness, laid the PW 19 laid the charge sheet against the accused for the offence 304 for the offence, 498A and 302 of IPC. Before the committal court. Full stop. After committal of the case before the session court, the learned session judge framed the charges against the accused for the aforementioned offences and aforementioned offence which denied by the accused and he claimed to be tried. Full stop. In order to prove the case, charges leveled against the accused, the prosecution in total examined 19 witnesses and got marked 19 documents as exhibit P1 to P19. Also identified 3 material objects, MO 1, 2, 3. Full stop. After assessment of the oral and documentary evidence, the learned session judge acquitted the respondent accused for the charges leveled against him in the impugned judgment. The same is challenged in this appeal by the state. Also, we have heard the learned SPP, she so and so, for the appellant, and also the learned learned SPP for the, we have heard the learned SPP full stop. It is a contention of the learned SPP that the trial court grossly erred while acquitting the accused in spite of the prosecution placing sufficient evidence before the trial court. Full stop. He would contend that the evidence of PW 4, 6, 7, and 10, the close relatives of the deceased, deceased, coupled with the exhibit P16, that is the complaint lodged by the
Deceased.
deceased herself, clearly establishes the guilt of the accused. Full stop. The deceased given the statement before PW 17 on the next on 27/4/2012, wherein she categorically stated that the accused used to harass her both physically and mentally by demanding money for his bad voices, so also suspecting her fidelity.
Yes.
For sure. Fidelity, and on the date of incident, that is on 26/4/2012, he poured kerosene on her and set her ablaze. Full sure. The deceased died after 5 days. 5 days from the date of lodging exhibit P16
On 1/5. 1/5 to
exhibit P16, that is on 1/5/2012. As such, the contents of exhibit P16 has to be treated as an oral dying declaration, and the evidence of PW 4, 6, 7, and 10. 7 and 10 clearly corroborates to the contents of exhibit P16. Exhibit P16. Full stop. However, exhibit P16. In spite of such materials, the learned session judge has acquitted the accused without appreciating the evidence and materials on record. Full stop. According full stop. With this submission, he prays to allow the appeal, and to convict the accused for the charges leveled against him. Full stop. The charges leveled against him. Full stop. Full stop. Having heard the learned SPP, so also having perused the entire evidence and documents made available before us, the only point that would arise for our consideration is whether the learned session judge is justified in acquitting the accused for the offense he has charged. Full stop. Next, on full stop. Before the trial, in order to prove full stop, in order to prove the prosecution case, of the prosecution, before the trial court, the prosecution has examined in total 19 witnesses. Full stop. 19 witnesses. Among them, to prove the homicidal death of the deceased, the prosecution mainly relied on the evidence of PW 16. PW 16, no?
PW 17.
Doctor
is PW 16.
PW 16, the doctor who conducted the autopsy on the dead body of the on the corpus of the deceased, as per, and issued the postmortem report as per exhibit P15. Full stop. On perusal of exhibit P15, the doctor has opined that cause of death was due to cardiorespiratory failure as a result of septicemia secondary to 75% to 80% infected superficial to deep burns. Full stop. Deep burns. deep burns, full stop. Further, deep burns, further, comma, further PW 17, who recorded the statement of injured, the deceased on 27/4/2012, also stated that the deceased had sustained the burn injuries, full stop. Further, with the PW, further the investigation officer, PW, PW inquest is to
Sir.
PW 16 to PW 16, 17 and 18, the investigation officers center. They have drawn the inquest panchanama on the dead body, full stop. The same also depicts that the deceased Amba sustained burn injuries, In such circumstance, we are of the considered view that the prosecution has proved that the deceased died due to the burn injuries burn injuries in unnatural circumstance, in unnatural death, unnatural death, full stop. Unnatural death, full stop. However, to connect the accused to the unnatural death of the deceased, the prosecution mainly relied on the complaint lodged by the deceased as per Exhibit P16 before PW 17, the then PSI of the respondent police, full stop. On perusal of Exhibit P16, the complaint lodged by the deceased, the same reveals that the accused married the deceased 10 years prior to the incident, and thereafter, she was working in Anganawadi as a helper, full stop. The accused used to harass her both physically and mentally, demanding money from her for his bad vices, and also is to suspect her fidelity, full stop. On 26/4/2012, in the night hour at about 10 p.m., the accused, after consuming alcohol, came to the house and quarreled with the deceased and poured kerosene on her and set her ablaze, full stop. Thereafter, she was shifted to hospital and admitted in the hospital on 26/4/2012, full stop. The 2012. The said statement of the deceased was recorded by PW
17.
PW
17.
PW 17, full stop. Though PW 17 in his evidence stated that after recording the statement, he has sent a requisition to the Taluka Executive Magistrate to record the dying declaration of deceased, there is no such evidence forthcoming. There is no such record forthcoming in the charge sheet, full stop. Nevertheless, the Tahsildar has not been examined before the court, full stop, before the court. The prosecution also failed to obtain any such statement of the deceased, though she was alive for a period of 5 days after the incident in the hospital, full stop. Exhibit P16 also, before recording Exhibit P16 also, the PW 17 failed to obtain any such a necessary certificate or endorsement from the doctor to state that the deceased was in a fit condition to give such statement, full stop. Though statement, full stop. Though the prosecution relied on the evidence of PW 4, 6, 7 and 10, 7 and 10, wherein they have stated that the deceased
Used to.
had given the statement before them orally, or deceased had given statement before them. Deceased had informed them. Deceased had informed them in the hospital that the accused ill-treated her and on 26/4/2012 he poured kerosene on her and set her ablaze. But before giving such a statement, also, the prosecution has failed to state that, failed to place any document that the deceased was in a fit condition to give such statements, full stop. Such statements, full stop. The statement. The investigation officer, PW 16, the investigation of PW 16 also states that, he had sent requisition to the Tahsildar for recording statement, but as stated supra, the Tahsildar not recorded any dying declaration of the deceased, full stop. It is the contention of the learned SPP that PW6 exhibit P16 has to be treated as a oral dying declaration of the deceased, and the same proves the guilt of the accused beyond reasonable doubt, full stop. Reasonable doubt. The Honorable Apex Court, in the case of Honorable Apex Court in the case of Irfan alias Naka was the state of Uttar Pradesh in criminal appeal of the 825-826 of 2022, dated 23/8/2023, held at paragraph number 62 as under. Full stop. The next further. The dictum laid down by the Honorable Apex Court in the above judgment emerges that though dying declaration is a substantive piece of evidence to be relied, provided it is proved that the same was voluntary and truthful, and the victim was in a fit state of mind. Full stop. It is just not enough for the court to say that the dying declaration is reliable, as the accused is named in the dying declaration as the assailant, full stop. On careful scrutiny of the evidence of PW 4, 6, 7 and 10, 7 and 10, there is no such, they have not stated that whether the accused was in a fit condition to give to state before them about the incident,
Yes.
about the incident, full stop. Further, this being the appeal against the acquittal, the Honorable Apex Court in the case of HD Sundar and others versus State of Karnataka, reported in 2023, volume 9 SEC, page 581, held in para number 9 held that when an appellate court exercises appellate jurisdiction, the duty of the appellate court is to find out whether the verdicts which is under challenge is correct or incorrect in law and on facts, full stop. The appellate court normally ascertains whether the decision under challenge is legal or illegal. But while dealing with an appeal against acquittal, the appellate court cannot examine the impugned judgment only to find out whether the view taken was correct or incorrect. Full stop. After reappreciating the oral and documentary evidence, the appellate court must first decide whether the trial court's view was a possible view. The appellate court cannot overturn acquittal only on the ground that after reappreciating the evidence, it is of the view that the guilt of the accused was established beyond a reasonable doubt. Full stop. Only by recording such a conclusion, an order of acquittal cannot be reversed unless the appellate court also concludes that it was the only possible conclusion. Full stop. Thus, the appellate court must see whether the view taken by the trial court while acquitting an accused can be reasonably taken on the basis of the evidence on record. Full stop. If the view taken by the trial court is a possible view, the appellate court cannot interfere with the order of acquittal on the ground that another view could have been taken. Full stop. The Honorable Apex Court in the case of full stop. The Honorable Apex Court in the the Honorable Apex Court in the case of Mallappa and others versus State of Karnataka reported in 2024, Volume 3 SEC 544, while summarizing the principles in dealing with the appeal against acquittal, in para 42 held as under, full stop. As under, full stop. And on careful perusal of the above law laid down by the Honorable Apex Court, Apex Court and Apex Court with the evidence placed by the prosecution in the case on hand, we are of the considered view that the prosecution has failed to place sufficient evidence to prove the charges leveled against the accused beyond reasonable doubt. In that view of the matter, we are declined to interfere in the judgment passed by the trial court. Full stop. Accordingly, we answer the point raised above in the negative and proceed to pass the following order. The appeal filed by the state criminal so and so is dismissed. Yeah.
Yes, well. Even I have marked everything, but now when I opened my file, I saw that last year only I prepared this. Yes, some rulings in afternoons. I'll submit tomorrow. Tomorrow's appeal, which appeal I have? Because if it is tomorrow there is no appeal. Then I'll be.
Monday.
My lords.
Attendance Girish Patil.
Yes, my lords. Two appeals are there.
They are rising out of same judgment.
No, my lords. They are different. But they are heavy matters. Much obliged.
ಅಂತ ಹೇಳಿದ್ರೆ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೆ ಸರ್ ಅದನ್ನ ಹಾಕ್ಬಿಟ್ರಿ ಸರಿ ಬೇಡ ನಾನು ಇಟ್ಕೊಲ್ಲ. ನೀವು ಪ್ರಿಂಟ್ ತಕೊಂತೀರಾ ಅಥವಾ ಮಾಡಿ ಕಳಿಸ್ತೀರಾ? ಹಾ ಅದ್ರಲ್ಲಿ ಸರ್ ಈಗ ಅಷ್ಟೇ ಇವು ಒಂದು 30 ಆಗ್ತದೆ ಸರ್ ನಾಳೆಗೆ ಮಾಡ್ರಿ. ಯಾಕಂದ್ರೆ 8 ರಿಪೀಟ್ ಅವು ಇದ್ರಲ್ಲೇ ಇರ್ಲಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಉಳಿದಿದ್ದೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಎಲ್ಲ ಬೇಡ್ರಿ. ಕಡಿಮೆ ಹಾಕ್ತಿದ್ದಾರೆ ಮತ್ತೆ 40 ಹಾಕ್ಬೇಕು. ಎಲ್ಲ ಅದಾವಲ್ರಿ ಅವನ್ನ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಕೊಟ್ಬಿಡ. ಇವು ಮಾತ್ರ ರಿಪೀಟ್ ಸಾಹೇಬ್ರು ಅದನ್ನ ಲಿಸ್ಟಿಂದ ತೆಗಿಬೇಡ ಅಂತಾರ. ಮತ್ತೆ ಕರೆಕ್ಟ್ ಸರ್ ಯಾಕಂದ್ರೆ ರಿಪೀಟ್ ಕೊಡ್ಬೇಕು 8 ಮಾತ್ರ ಅಂದ್ರೆ ಅವು ಮತ್ತೆ ಇವತ್ತು ಮನೆಗೆ ಬೇಕು ಅಂತ ಚೇಂಬರಕ್ಕೆ ಬೆಳಗ್ಗೆ ಕರೆಸ್ತೀನಿ ಸರ್. ಇವು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಅಂತೂ 3 ಆಯ್ತು ಬನ್ನಿ. ಇದನ್ನ ನಾವೇನು ರಿಪೀಟ್ ಕೊಡೋಂತ ಅಷ್ಟಿಲ್ಲ. ರಿಪೀಟ್ ಕೊಡೋದಷ್ಟೇ ನೋಡೋಣ. ಮೂವತ್ತೊಂದು ರಿಪೀಟ್ ಬರ್ಕೊಂಡು 32 ರಿಪೀಟ್ ತಗೊಂಡ್ಬಾರ್ದು 31 32 33 ರಿಪೀಟ್ 34 ರಿಪೀಟ್ 35 ರಿಪೀಟ್ 36 ರಿಪೀಟ್ 37 ರಿಪೀಟ್ 38 ರಿಪೀಟ್ ಆಮೇಲೆ ಕೇಳ್ಕೊಂಡ್ 41 ಇದಕ್ ಕೊಡೋಣ ರೀ ಬರ್ಕೊಂಡ್ಬಿಡ್ರಿ 21 42 21 43 21 44 22 1 46 22 1 20ನೇ ತಾರೀಕು ಕೊಡ್ರಿ 20 ಆಮೇಲೆ 50 20 ಅಂದ್ರೆ ಆರ್ಸಿ ಇದಾರೆ 47 ಅವತ್ತು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಡೇಟ್ ತಗೊಂಡಿದ್ದೇನೆ 50 ಕ್ರಿಮಿನಲ್ ಆರ್ಸಿ ಅವ್ರಿಗೂ ಕರೆದು ಸ್ಟೇಟಸ್ ಎಲ್ಲ ನಾ ಹಾಕಿದೆ
ಯಾವ್ದು ಜಜ್ಮೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಯಾವ್ದು?
ಕಳಿಸ್ಬಿಡ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಡಿಕ್ಟೇಟಿಂಗ್. ಇಲ್ಲ ಅದನ್ನ ಚೇಂಬರ್ ಅಂತ ಬರ್ಬಿಡ್ರಿ ನೀವು ಹಾಕು ಅಂತ ಹೇಳ್ರಿ ಒಂದು. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಮನೆ ಹಾಕ್ಬೇಕಂತ ನೋಡ್ರಿ ಬರ್ಕೊಂಡ್ರಿ 36 ಇಲ್ಲ 32 ರೀ. ಏನ್ ಮಾಡ್ರಿ ಅಂದ್ರೆ 32 ಒಂದು ಬೇಡ ಒಂದೇ ಹಾಕಿ. 32 ಹಾಕ್ರಿ. ಡಿಕ್ಟೇಟಿಂಗ್ ಜಜ್ಮೆಂಟ್ ಹಾಕ್ಬಿಡ್ಬೇಕಂತೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬರ್ತಾರಂತ. ಆಮೇಲೆ ಆ ಹುಡುಗನ್ ಕರೆದ್ರೆ